let's make a start on this. I mean, this isn't even the entirety of dataset 7. It's 412 pages of this exact same thing. We're going to find out what it is. So, brace yourselves, boys. Fucked up already. The United States Department of Justice, Office of Professional Responsibility. Interview of R. Alexander Acosta. Washington, D.C., Friday, October 18th, 2019. Interview of R. Alexander Acosta, a witness of lawful age taken on behalf of the United States Department of Justice in the above entitled action, before Beth Roots, Notary Public in and for the District of Columbia, in the offices of the U.S. Department of Justice, 950 Pennsylvania Avenue, NW, commencing at 9:34 a.m. Diversified Reporting Services, Inc., redacted. So this is apparently a witness. Are they a member of staff? Don't currently know. Certainly it's not Maxwell, so it'll be, hopefully it'll be a bit better reading than any of Maxwell's interviews, because I fucking hate that bitch. I will just go straight up and say it. I have grown to hate Ghislaine Maxwell a lot more than Epstein, because we still have Ghislaine Maxwell, or at least you guys in the US have Ghislaine Maxwell, and she's not naming names. She is refusing to cooperate. So, you know, I guess it's harder to hate Epstein just because it's dead and we haven't had, like, transcripts with him specifically yet. But Ghislaine Maxwell, we had a few in 2024, and goddamn, I really grew to hate her. Anyway, speaking of hating, we're already on page 2 now, so I better get a move on. Appearances. On behalf of the Department of Justice. Redactions. Department of Justice, 950 Pennsylvania Avenue, NW, Washington, D.C., 20530. Redacted. On behalf of the witness, Gordon D. Todd, Esquire, T.J. Heron, Esquire, Sidley Austin, LLP, 1501 K Street, Northwest, Washington, D.C., 20005. Redacted. Proceedings. Whereupon R. Alexander Acosta was called as a witness and, having been first duly sworn, was examined and testified as follows. Examination by Ms. Redacted. And I'm not going to say QA for each, even though it's done in this format. I'm also not going to say the numbers on the side. To differentiate the questioner and the answerer and the lawyers, I will just use different voices, and that'll make things quicker. So, would you tell us your name, please? Renee Alexander Acosta. And Mr. Acosta, you're accompanied by your attorney, Gordon Todd, is that correct? Yes, it is. And Mr. Todd, would you identify the associate you have with you? It says Mr. Heron. Yes, T.J. Heron. Ms. Redacted. Ain't she R-R-O-N? Mr. Heron. Correct. Ms. Redacted. Thank you. Mr. Acosta, I'm Redacted. I am a counsel with the Office of Professional Responsibility here at the Department of Justice, and with me are my fellow OPR counsel. Redacted, redacted, and redacted. We are in a conference room at the Department of Justice main building on today, October 18, 2019, and we're starting at about 9:30 in the morning. Before we start, I just want to put on the record that Mr. Redacted worked in the Civil Rights Division at the time that you were the AAG heading that division, and I believe had an occasion to briefly meet you in connection with a matter. The witness. Could I ask what section? Mr. Redacted. I was in the Special Litigation section. The witness. Oh, okay. Mr. Redacted. And I provided Mr. Acosta some talking points for a press situation that we had in that case. The witness. 14141. Mr. Redacted. Yes. The witness. Probably. By Ms. Redacted. All right. Thank you. Mr. Acosta, OPR is investigating two things. As you know, one, whether one or more federal prosecutors in the Southern District of Florida U.S. Attorney's Office may have committed professional misconduct by entering into the non-prosecution agreement, or NPA, in 2007 with Jeffrey Epstein, who at the time was under investigation by that office and the FBI for engaging in widespread sexual misconduct involving underage females. The second thing we're investigating is Judge Mara's finding of February of this year, 2019, that the government may have violated, or actually, he found the government did violate the CVRA, or Crime Victims' Rights Act, when it entered into the NPA without first providing the victims with notice and a reasonable right to confer with the government. You are a subject of the OPR investigation. That is, one of somebody whose conduct is being reviewed and evaluated by OPR, and specifically as U.S. Attorney at the time for the Southern District of Florida, you had the ultimate authority over the Epstein for a period of 2.5 years, as we understand it, from the time the line AUSAA redacted first briefed you, and then criminal chief redacted in the July of 2006, and until you were formally recused from the case on or about the 8th of December 2008, after notifying the Executive Office of the U.S. Attorneys that you were seeking employment with Kirkland & Ellis, a firm of which two attorneys, Ken Starr and Jay Lefkowitz, had been representing Jeffrey Epstein. Is that correct? Ooh. So this is the head lawyer that got Jeffrey Epstein, well, not punished severely enough back in 2007, which is when he was first imprisoned for, I think, 1.5 years. And, yeah, it should have been longer. And apparently these people agree. Oh, excuse me. We may get into it a little bit later, but I think the characterization of my seeking employment is not accurate. We can talk about that a little bit later. All right. We have the documents that relate to that. So that's what we're basing it on. Correct. And I believe the term that's used is seeking employment. That is the term used in the email. I think I addressed that in my... I believe Mr. Todd addressed that in the letter that was sent to... All right. OPR. All right. Thank you. So we recognize that you're no longer with the Department of Justice. Right. And that it is your choice to come and talk with us, and we very much appreciate your willingness to voluntarily do so and help us figure this case out. OPR provided you with a few thousand pages of records, emails, and correspondence, and some other documents that reflect your involvement in the Epstein matter over that 2.5-year period. Now that you've had a chance to review, I hope, those emails and other documents, we hope you can be specific in helping us understand what happened. Have you in fact been able to review these documents? Yes, I have. Thank you. OPR asked you for a written response to certain questions. We've received and reviewed a written response prepared and submitted not by you, but by your attorney, Mr. Todd, on your behalf. Have you reviewed his response to, yes, you? Yes, I have. And will you now under oath subscribe to that response, as if you had submitted to it yourself? So, Mr. Todd spoke to me and conveyed the investigation that I provided him. I believe he conveyed that information accurately, and the statements that he ascribes to me in that letter I believe are accurate. All right. Do you have any changes or corrections to that written response? No, I do not. Is there anything in it that you do not agree with? Again, I think that the statements that he ascribes to me are accurate, and I agree with them. All right. So we are going to accept that statement as representing accurately what you would have responded if you had responded to us directly. Is that correct? Yes, the statements. He basically gives my positions, and I believe that he gave my positions accurately. Perfect, thank you. So as we ask questions and refer to documents, we would like you to correct any misstatements in our questions, or any misstatements or errors that are in the documents themselves, because we want to make sure the entire record, is correct. Also, there's been an enormous amount of publicity about the Epstein case, particularly this year, including about the events and decisions made back in 2006 to 2010 that are the subject of our investigation. And so, as best you can, we ask you to try to answer today from your knowledge, understanding, and recollections as of that period of time. However, to the extent you are asked or do speak retrospectively, we'll just make it clear that you're doing so. All right, okay? And if I could just say, one of the difficulties is... Oh, my Streamlabs appears to be buggered. There we go. I'll redo that. And if I could just say, one of the difficulties is with everything that... all the publicity and all the documents that are made into the press and in litigation, distinguishing between recollection versus after the fact. Right. Speculation. And I will try, but I would appreciate reminders along the way, because it's an important distinction, but it's kind of hard sometimes. We recognize particularly the importance of it. Right. That's precisely the heart of, our matter. So, Mr. Acosta, your professional background is a matter of public record. I have a couple of questions. By what state bar are you currently licensed? So, I am inactive in Pennsylvania and also in DC. All right, and not in Florida? Not in Florida. So, do I understand that you are not currently an active member of any bar? Guys, chill. Not sure if you picked that up, but I've got the kitties running back and forth. So I've no doubt they'll tire themselves out and they'll eventually come up and say hi. Yes, here we are. I would have to confirm with DC. I said not inactive in Pennsylvania and in DC because I am not certain whether I'm currently active or inactive in DC. I am not currently practicing, and so I would have renewed under either active or inactive. Alright. And we can verify that and get that. They're talking over each other. We would appreciate it if Mr. Todd could let us know your current status. I also would like to know your bar status in the period of 2006 through 2008. Do you know what that was? Most likely, I can speculate. I don't know as a fact. Most likely active in DC. And inactive in Pennsylvania. Okay, but likely active somewhere, correct? Yes, I think that's a requirement. Yes, that is requirement. So, it would be DC. The distinction between active and inactive in DC is more minor, as I recall, than Pennsylvania, where there's a large fee difference. Alright, thank you. And we look forward to hearing confirmation of that from you, Mr. Todd. So, after serving nearly 2 years as the Assistant Attorney General in charge of the Department's Civil Rights Division, you were presidentially appointed the interim U.S. Attorney for the Southern District of Florida in June of 2005, and then, as we understand it, you were formally nominated as U.S. Attorney in June of 2006. And after being confirmed by the United States Senate, you were sworn in by the U.S. Attorney as U.S. Attorney in late October 2006. So yeah, this guy this 412-page interview, this is the guy that was the head honcho for the district when the Epstein stuff came about, and though they pursued the investigation, they got Epstein, they arrested him, they found him guilty on these charges, they let him go early. He served 1.5 years, I think, in prison, 2007 to 2008, and then for some reason they let him go. I think the official reason was of Epstein cutting a deal, but I am unsure. That said, investigations into Epstein were reopened because of the very light sentence he received. So, and obviously the stuff that he went on to do, because this is just the tip of the iceberg. He apparently did some worse shit, which we know, Epstein Island is famous for a reason. And apart from the photos earlier, we haven't had any interviews, transcripts and stuff about Epstein Island, or indeed the Zorro Ranch. Most of this is covering the Florida investigation in West Palm Beach, and also some stuff in New York as well with his New York address, because, it happened over there as well, and Florida witnesses are confirmed to have travelled over there. So yeah, we'll carry on. This is going to be very interesting. I think that may be inaccurate. I would have to confirm. When you say presidentially appointed, I believe it may have been appointed by the Chief Judge at the request of the Attorney General. The Chief Judge has appointing authority. Okay. And you'd have to go back and confirm whether it was either an AG designation or the Chief Judge. Alright. Which is different than presidential. And I understand. And again, I would appreciate if you could, follow up on that. I'm Mr. Todd? Not certain how to confirm that. That's something that in all candor the department would know. Alright. Much better than I. Then we will pursue it. My point is that there was a change in your status from interim to you, the U.S. Attorney, with the full, correct, confirmation. How, if at all, did that change in status affect your view of and your exercise of your authority as U.S. Attorney? So it's difficult to recall. You're now asking that just 10 years back, but even further back. I was interim for a sufficiently long period of time that by the time the change in status took place, I would speculate that I was, in my mind, acting as U.S. Attorney, whether you have an adjunctive interim, or acting in front of your name or not. I had great people. I don't recall when Redacted came on board as first assistant, but he was my crim chief, and I thought for the continuity of the office, it was important to promote him to first assistant, and he was promoted actually effective October of 2006. You made a series, according to emails. The personal announcement was made to be effective in October 2006, naming Redacted as criminal chief and Redacted as first, assistant. Right, and they were both long-serving professionals within the office, and basically, as my recollection, everyone just moved up one rung. Okay. You would know better than I because you have those records, and so sitting here today, I don't recall any specific way in which that shift would have impacted. Alright, my thinking. You had not served as a prosecutor before, and didn't have direct criminal experience, is my understanding. That is correct. I had supervised civil rights, for example, had supervised criminal prosecutions, but I had not been a line prosecutor previously. So as the US attorney supervising a couple of hundred, line prosecutors, most involved in criminal work, what interested you most, or appealed to you most as you undertook and carried out your duties as US attorney? What interested me and appealed to me? So, the work of the office. I mean, it's a broad question, but the work of... That office and any US attorney's office, I think, is incredibly impactful to any local community. And I very much enjoy being a part of the effort to bring folks to justice, to move policy initiatives. You know, I recall early on we identified healthcare fraud, as one big area, and we had one of the largest out of the largest healthcare fraud initiative. You know, we focused quite a bit on gun violence, and we did a great job on that. And it's one of those jobs where people feel very good about what they do, and it's great to be part of it. I'm sure No, that's... Okay, that's helpful. It just gives us some perspective. Yeah. Was there any aspect of it that you particularly disliked? To the extent you're dealing with personal issues, I think personnel issues are really the preferred part of any executive function. You mean the conflicts among attorneys, things like that, or performance issues? Performance issues. Alright. And you know, when you've got... In any large office, you get personal issues, disciplinary issues, and those are never... Those are never fun. So we talked about the professional. High-level personnel changes you made sort of after your first year there. Redacted had, we understand, been functioning de facto as a first assistant, while Redacted was not. We understand Redacted had been first assistant, but he stepped away, and Redacted came in to essentially take over his brief until he was formally appointed first assistant. Is that consistent with your memory? So you might have characterized that more strongly than I would have. Okay. Again, it's difficult to recreate from back then, but there was certainly a transition period from Mr. Redacted to Mr. Redacted, and if I could, because when you said high-level changes, my intent... It was a great office, great professionals. My intent in elevating Mr. Redacted was just, you go from criminal chief to first assistant, and I don't recall Mr. Redacted's prior position, but I know that he was also elevated. I think he might have been major crimes, but that's correct. I'd be speculating. I could guess it. We can verify that. Okay. Yes. What was your assessment of Redacted? His capabilities, his judgment, and his working relationship with you on a day-to-day basis? Outstanding. He had been in the office for decades. He was respected by everyone. He had a good tone to him. He was someone, I wanted individuals around me that were respected within the office, and that were trusted, and that had been there for a long time. And then I think I was very lucky to have that in my management team. As we understand it, your office as US Attorney was sort of on one side of the reception area, and the First Assistant's office is on the other side. Is that correct? That is correct. Or, at the time, correct. That was correct. So did you and Redacted have a sort of easy back and forth? Walking? Open door? Into each other's offices multiple times a day? Alright. Kind of relationship. Alright. And given that he had experience throughout his career as the department in the criminal arena, and you had not, to what extent would you rely on him, among others, for guidance, perspective, information, and so on? I named him first assistant because I valued his guidance and his perspectives, and I thought those were valuable. Okay. You also, as we pointed out, appointed Redacted to succeed Redacted as criminal chief, effective October of 2006, and he served for about 10 months before he left for private practice. He left at the beginning of August. 2007. What you did... You said you didn't recall, as we said here today, what section he'd come from. Right, I guessed it was major crimes. Alright. What was your assessment of Redacted? Outstanding as well. And if I could say, when I say I don't recall but I guess, when you're going back 12 years, sometimes you get an impression but you can't say it's a recollection, and that's going to come up multiple times today just because it's a while ago. As long as we make that distinction, right, both are helpful. Right, and so whether it's a recollection or a construction after the fact, I can't I can't say, but, I thought that one of the helpful factors with Redacted is he has spent a lot of time, and Major Crimes is the most active unit. I assume you all know the structures of the office. But Major Crimes is not Major Crimes. It's sort of the entry-level crimes, and I valued the fact that he had trained in, so many ASAAs, and really spent a lot of time reviewing the Major Crimes Chief, as opposed to the other chiefs spends a lot of time reviewing the work of ORSAs, and so he'll be someone who is very experienced and able to get in the weeds. And he, in fact, was around during that time period, had gone back in the courtroom, if you recall, to actually try a major case. Do you recall that? It was I didn't until you... Major fraud case. Mentioned. I didn't until you mentioned it, and now there's something in the back of my head that's saying that sounds right, but I can't give you more detail. Alright. What was your assessment of Redacted sort of working style, and particularly working with you? Again, positive. I didn't see him as often as Mr. Redacted, but was he located on the same floor? He was located on the same floor, but not within the same suite. And that affects interaction, but a positive working relationship. Alright, and how, to what extent would you, as criminal chief, was he relied on by you as distinguished from Redacted with regard to the criminal matters pending? Also relied on. That would depend almost on the matter for, as in a typical situation. He would bring things to Redacted, who would bring them to me along, and so he would bring things to Redacted, and then depending on their discussion, they might both walk into my office. But he would typically run things through Redacted before coming to me. Were there occasions when he would come to you directly? Sure, that's why I said in a typical, It's difficult to sort of recreate the interactions, but he certainly could come to me directly, and in some cases, I would say probably would. Again, it being a large office with several physical locations, as we understand it. A very high volume, of cases, right. And particularly in the criminal context, is it fair to say you didn't review every prosecution as it was brought? It is not just fair, but accurate. I recall a conversation with a US attorney from a small district early on at one US attorney's conference where we compared notes, and the interaction of an office with 30 prosecutors is very different than one with, a few hundred prosecutors. So, when you did engage on a criminal case, would you, whether it was a planned prosecution or a case heading to trial, would you generally rely on written submissions, or would you... This is really an inquiry into, your style. Or would you have everybody together and talk about it, or would you rely on your most immediate subordinates to be briefing you? Which one of those? Approaches, did you take? I would say that really depended, and probably varied based on individual needs. For the most part, I would most likely just speak with my first assistant and or criminal chief and assess what else needed to be done. In other words, you would sort of do it on a verbal or based on oral, correct. Interaction and correct. Presentation as opposed to going through stacks of papers. I would say that was typical. Yeah. I don't want to say that was the case every single time, but that was typical. Alright. And to what extent did you go out and about to encounter the line attorneys, for example? Was that something that you were able to do and wanted to do? Yes and yes. And when I started, I made it a point of walking every floor and meeting everyone, and toward the end of the day, I would also, if I could just make it a point, particularly of major crimes, of just walking down to the floor and seeing who was there and what they were doing, and sort of popping my head in and just saying hi, because I think it's the right thing to do. Okay. Was that a way to support the troops, or was it more a way for you to become informed about what was going on? Probably a little of both, of support the troops, but also get the temperature for the office, see how matters are progressing. You at the criminal, or rather the civil rights division, had experience with human trafficking and child sex trafficking cases. Correct, under your supervision. We understand that you brought that concern, or your concern about those issues, with you to the U.S. Attorney's Office, and that we know that under your tenure, the U.S. Attorney's Office had many successful prosecutions involving conduct ranging from internet child pornography, to international sex tourism. Correct. Victimizing children in particular. In mid-2007, you, according to press reports, you set up a new Special Prosecutions Unit. Correct. To focus on, among other things, sex crimes against children. Could you tell us what importance those kinds of cases held for you as U.S. Attorney? Sure. If I could just back up a little bit, because the question goes, the Special Prosecutions Unit, and let me address that part of it. There are a few things embedded in that. There's the Special Prosecutions Unit was set up because there were some issues that I thought were important to pursue in particular. And one of those was sort of the trafficking issues. Another one was the gun violence, and the intent of special prosecutions was to have a group of individuals that would sort of be dedicated and not be part of the usual major crimes group. So it wasn't exclusively... Your question may have implied it was exclusively for sex crimes, did it? Oh no. And it wasn't. Yeah. No, I understand it was not. Right. Okay. And so I thought it was sufficiently important, and so it was one of the initiatives that we were certainly pursuing. And was that something that to which you brought your experience as head of the Civil Rights Division as well? It was. I think I know when I was head of Civil Rights, so that's something that I put particular emphasis on, and I thought Civil Rights really stepped up and did a great job on that. Did you yourself ever... I recognise you were never a prosecutor as such, right, but did you ever have experience being involved in a prosecution that... sort of the nitty-gritty of the prosecution of that kind of case? Sort of seconding yourself to a trial team, for example, or an investigation? So if by nitty-gritty you mean seconding myself to a trial team, the answer will be no. Alright. There are a number of cases that I recall being briefed on and talking about, but at that high level? Correct. Alright. The department set up in 2006 a PSC program, a Project Safe Childhood program. Correct. Focused on internet child pornography. And you appointed Redacted as your first PSC. Correct, coordinator. And she was also, of course, the line attorney on the Epstein case. How well did you know Redacted, and can you give us your assessment on her capabilities, judgment, and her interaction with you? So, a few things in there. How well did I know her prior to appointment? I don't recall. I don't think I knew her particularly well prior to appointment. She was clearly respected within the office. Hello, Dexter. And I don't recall, but I can speculate that she was appointed based on recommendations of management, and her interest in some combination, and prior work and some combination thereof. You asked me to characterise Redacted. Your view of... Right. Her capabilities, her judgment. Right. Her acumen, her knowledge of the law. I think she was a good, strong professional also. I mean, did you have any negative, anything less than fully positive in your assessment of her? No. Okay. I think she was a good, strong, dedicated author. All right. Redacted, yeah. Was the managing author at the West Palm Beach office. Correct. At least. And Redacted worked there. How closely did you work with Redacted? And again, that, assessment question. Right. What was your assessment of him? So, less so, only because of geographic distance. I would also say he was a respected professional. He had a good reputation. He went on to be chief of staff here at the criminal division, which I think speaks to how he was viewed within the department. And so I would say positive. Okay, so now turning to the Epstein case. Yeah. Now that your recall has been refreshed by virtue of the documents we provided, before we get into the actual sort of documents and some of the details of the events, would you please give us a general overview of what you currently remember, refreshed, about how the case came into the U.S. Attorney's Office, how it was assessed for prosecution, and how and why the decision was made to resolve it with a 2-year state plea that ultimately became an 2-year state plea that ultimately became, an 18-month state plea. Okay, so, Mr. Heron, before you answer the question, let me just jump in on the notion of refresh your recollection, which is, of course, has a very specific legal meaning, and I think to assert that Mr. Acosta's recollection has been refreshed generally probably overstates it. It's really a document-by-document, issue-by-issue thing, so I push back on that. Redacted. Mr. Heron, a little bit, but the question is fair and accurate. Redacted. If you're talking about handing him a document to refresh an exhaustive recollection, that's not the process we're talking about. We're using it in a more lay term that, if we asked you this before, giving you all these documents, you'd probably would not have been able to be as full in your responses. So we're asking for your full response. Thank you. Mr. Heron, we appreciate the opportunity to review the documents, and Alex, in your answers, try to distinguish what you actually recall. The witness, yeah. Mr. Heron, in your own head versus what you saw in the documents. Redacted, yeah. Mr. Heron, and that would make for Redacted. Thank you. Mr. Heron, the cleanest record. The witness, Okay, so 3 parts. How did it come into the office? I'm sorry, by misredacted. How did it come in? Right. How was it assessed for prosecution? Right. And then how and why the decision was made, right, to resolve it the way it was. So, let's begin with how did it come into the office. Putting all the documents aside, I can't say with certainty how it came in. I can speculate how it came in. The way it would have come into the office is... Oh shit. I can't say with certainty how it came in. I can speculate how it came in, and the way it would have come into the office is... I can speculate that the chief rider from Palm Beach County would have brought it to either the FBI or to the Palm Beach office. I'm not certain that I would have asked who brought this case to the office, as opposed to the case is now in the office. So let's discuss it, right? The format, or the mode in which it came in, I think is important, because my recollection is it arrived to us in the position that the state attorney had negotiated a plea, and that the reason that we looked at it was that the plea was going to be that there had been an initial charge that wasn't pursued, and that required jail time and registration, and that the plea that was going to be taken was a charge that didn't require jail time and didn't require registration, and based on the preliminary assessment of the facts, that seems wrong. So that's how did it arrive. The next question was, how is it assessed for federal prosecution? So it was assessed for federal prosecution, my recollection from very early on, and I'm sure we'll talk about this some more, is you have a case that, well, technically it wasn't final at the state level, but for federal involvement would have been final, and so from the earliest point we were thinking federal versus state and petite, and the contemporaneous record sort of shows, at least the material that I got, the earliest communication was Mr. Redacted telling me that Ms. Redacted is preparing a petite policy waiver. And that's consistent with my recollection of how it was assessed and then brought in. Assessed, you know. Does it make sense to go forward? Yes. Investigate and circle back. And then the third part was the how and why the disposition. So my general recollection is the view was that if the state had followed through on an original charge, I don't recall which, that called for jail time and that called for registration, that the local police or whoever brought it would not have seen the need to refer it. And so that was, in terms of pre-indictment resolution, a logical and reasonable place given all the other sort of factors, both the petite concerns, the witness concerns, and the legal concerns. And to that, I would add a fourth concern, which is it had already been reviewed by a grand jury at the state level, is my recollection. And so to some extent, that's indicative of how some individuals may sort of view this matter. Okay, we're going to pick that apart. I figured. But thank you for that. You asked for an overview, so I tried to be very, general. The second part of that last prong was why a 2-year state plea? In other words, you talked about assessing the case and why resolve it, but why with a 2-year state plea? Overview. And so my general recollection is, my understanding, if I was asked, what is the best understanding that I have of why 2 years, is what would have been obtained in one of the original state charges. Again, this is, how do you know that? How did you know that? That's why I say general recollection. I'm reconstructing memories of that 12 years ago. I can speculate that at some point the matter came up and I or someone else said what would the original plea have, what would the original charges have likely brought? And someone said this amount. How would have said that? I'm speculating at this point. I don't have a recollection, but that's my general understanding. All right. Well, now unpack. Yeah, some of that. I noticed. And by the way, my colleagues, we're all in this boat together. So they're going to feel free to, chime in. Yeah, as they see fit. So the first thing going to the intake of the case, we know from the records that, and by the way, we've obviously done a great deal of other investigation. Right. And spoken to many people. So Redacted briefed you and Redacted pretty much when the case first came in. In mid-2006, after the FBI and indeed the US Attorney's Office in West Palm, had opened the case, but before Epstein was indicted. So this first exhibit number 1, that you have in your binder before you, or in your folder before you, Is that email from Redacted to you that you just referred to date July 24th? Right, 2006, in which he's sort of passing on the information that Epstein has by now been arrested and indicted by the state. Or indicted? Indicted? Do you recall anything about that original briefing from Redacted? I don't. Alright. Did you know at the time she briefed you, which is prior to Exhibit 1, did you know who Epstein was? I did not. Never heard of him, to your knowledge? To my knowledge, I don't recall having heard of him. And what did you understand at that early point the case to be about? So, I don't recall the briefing, and so I can't give an independent recollection. You know, based on this, I mean you're talking about Exhibit 1, and you're based on Exhibit 1. You know, I can infer that this would have been my general understanding of the case, and, you know, and the key things that I point to is pre-trial diversion, which is code for no jail time, and petite policy. But this, Exhibit number 1, right, does not make it clear to you that this case involved allegations that Jeffrey Epstein had been enticing, coercing, whatever verb you want to use, young underage females. We will, for the record, call them girls here. Yes, as opposed to women, and these underage females were being paid to provide him essentially with sex. Oh, no, pretty salacious nature. Do you recall that as being essentially what you were briefed on from the beginning? Okay, I think that's the end of that bit. Okay, I'm just going to read the chat real quick. Sorry, I've neglected this. I've been locked in with this. Page 35 of 412 of this entire little saga, but this is really interesting. I've got to carry on. Good evening. Hello, Aaron. Did you get a haircut? Absolutely. I was going to make a joke about wearing a wig before, but no, I got a haircut. I don't know if it's yet. I think it wasn't yesterday. It was the day before. Yeah, it needed to be done. Long overdue. And to be fair, the barber was of questionable immigration status, but he was so quick, and he got it done. Like, he took I swear he took less than 10 minutes. Got it all done. Got it done really well. And yeah, and that was it. Big Stein was spotted at Tel Aviv yesterday at 2:48 p.m. I mean, that keeps getting mentioned. You know, I'm just going to say, let's see the photo. Let's confirm it's not AI. All of that kind of stuff, because, you know, that joke has been done to death. But I would say, you know, where's the body? What happened to the body? Can we get DNA evidence? But anyway, yeah. I hope you guys are doing alright, but I'm going to try and lock in as much of this as possible. If I can get the entire lot done tonight, I will, but I suspect that might not be possible. I'm close to 10% of the way through this little bit. He's the new Elvis Presley. Again, I don't recall the initial briefing. I take it based on your review that there was an initial briefing. I can't say the degree of detail. I can't say what it was about. As a typical matter, I wouldn't be briefed when a case comes into the office, other than being made aware this is a case. This is what we're looking at. So then, understanding you don't remember the briefing, is it fair to say that you did have some understanding of what the case that West Palm Beach was pursuing as of mid-2006? I certainly had an understanding of the general facts of the case early on. I can't speak to whether it was mid-2006 versus late 2006 versus 2007, but early on. I certainly had an understanding that it was a case that involved, you know, a billionaire who was doing sordid things with young women or girls who were minors. Redacted, and the records indicate that her concerning bringing this all the way to you, and her first, at that time, criminal chief, right, but sort of acting first assistant Redacted, was because she was afraid of political pressure that might be brought to bear against the US Attorney's Office in this case. Do you have any recollection of that being a concern that was laid before you? I don't recall that briefing. I've reviewed this email and I can, I take it. It would have been natural for me to say, should we approach the state attorney? Because we had lots of ongoing matters with the state attorney, and it seems that Redacted said no for fear it'll be leaked straight to Epstein, and I assumed I'd let it be at that point. And do you know what he meant by it being leaked to Epstein by the state, by Barry Krishna, the then state attorney? So based on the context, what I would assume is that if the state attorney is cutting this kind of deal, and it appears that things have already leaked, because, there's clearly an article here we've leaked, so something is already leaked. You're referring to Exhibit 1. Exhibit 1. Other things would leak. Had you ever met Barry Krishna? Sure. What was your relationship with him? So there were multiple state attorneys within the district. It was a professional relationship. It was an elected position, correct? It was an elected position. And what was your assessment of his aggressiveness as a prosecutor and his capabilities? On the public, most of my assessment with him was on the public corruption front, where we had brought several cases, and I was a little disappointed that these were cases he could have brought that he chose not to bring. Right. So am I accurate in inferring from that you didn't regard him as a particularly hard-charging prosecutor? So with my state attorney, I hesitate to sort of paint broad brushstrokes. I don't think that's always fair, but my experience has been in the public corruption space. Yeah. And in that space, I did not think, whether it was him or whether it was his office, I can't speak, but I did not think they had done as much as they could have done. Is there any area in which you thought he and his office did pursue aggressively? So as I recall, we had emphasized gun crimes quite a bit, and really had a lot of success moving the ball in the gun crime space in Palm Beach. What? But let me just say, it is also very difficult to reconstruct timeframes. And so I hesitate because I don't know if that was 2006 or 2007, but you asked in another area, and in this Exhibit 1, you ask whether it's appropriate to approach Barry Krishna and give him a heads up as to where the U.S. Attorney's Office might go, presumably, right, with this case, correct. Why would you want to extend that deference to him? Why would it matter? A colleague in law enforcement. I thought it was important for the office to work with state attorneys as a general matter, and I found that the office worked best when it had good working relationships with state attorneys and with, for that matter, the agency Sachs and others, and right. But again, rather than my asserting, I'm asking Redacted, and Redacted was saying no, and I don't know what the ultimate outcome was, but I would guess that we just defer and let it be. Turning to Exhibit 2, this is an email that was forwarded to you by Redacted. The original forwarded email is from Redacted, copying Redacted, and it essentially relates to a dust-up between Redacted and Redacted over chain of command and her workload, but in the first paragraph she specifies that, when I first heard about the Epstein investigation, I spoke with Redacted about it. Redacted was not here. Redacted said that she would back me up on the case, but I knew what has happened to the state prosecution can happen to the federal prosecution if the U.S. Attorney's Office isn't on board. So I spoke with Redacted about the case, and he spoke with Alex, and they gave the green light. So that actually appears to be an initial contact with Redacted that she's talking about prior to the briefing of you, so way early when the case first came in May of 2006. Do you recall being contacted or having a conversation with, Redacted about that case so early? Again, the early recollection. Whenever it might have taken place, was I made aware of the matter. It seemed a reasonable matter to pursue, and that's the level of detail that I recall. So if Redacted said back in the day that she got from you all the green light, what did you understand her to be authorized to do? Authorized may be too strong a word, but so to pursue, to investigate, to pursue. Yeah, to someone. I'm speculating here, but there's a case, and they want to know, should we spend our time on this? And the answer is, it seems reasonable. Sure. Okay. And do you recall making that explicit to her? I don't, and it wouldn't have been my practice to sort of make it explicit to, yeah, go spend your time, as opposed to, thank you for letting me know, that sounds reasonable. Alright. And whatever, details, it looks like based on Exhibit 1, there was subsequent follow-up between her and Redacted, or with her and the management team, and they said, go back, work on A, B, and C. Do you know what Redacted was talking about when she referred to something happening to a federal prosecution if the U.S. Attorney is not on board? Had there been a case in which you were not supportive of a particular prosecution that was being proposed? None that I recall, and I knew that what has happened to the state prosecution can happen to a federal prosecution if the U.S. Attorney is not on board. I don't recall any federal prosecution that I wasn't supportive of, at least in this context. What do you mean by this context? It was my way of narrowing an answer, so I didn't spend the time to go through every office and every division. For the most part, as I sit here, I'm sort of running through each office. I don't recall any, and if I could, based on this, on Exhibit 2, I'm not sure that she's referring to a specific case as opposed to concerns that the state prosecution started to point, with charges that required jail time and ended up somewhere else, and it may have been because management, alright, wasn't. But that's a current reading of, That's my recollection. That's my reading, not... Alright. Based on the early description you got of the case, right. Did you have any idea how many victims were involved? I did not. Did you know what the name of the case was? What the investigation's name was? You know, cases get names. So, I know that based on review of the correspondence, I may have known that then. I do not independently recall that. That being Operation Leap Year. Correct. Alright. And do you know where that comes from? I have... Well, I mean, other than February 20th, yeah, I don't know. Well, the original allegations that came in involved 28 victims, and then subsequently redacted advised that she was uncovering more victims, so there was... Yeah, over 30 victims. Well over 30. I did not know that. Alright. You did not... As you sit here today, you didn't know it. I don't recall knowing that. But is it reasonable that the number of victims would be one of the factors that you would have been informed of at that time? I don't know. It all depends how detailed that briefing was. Again, as a typical matter early on, this is what is being done. I would trust my officers and my management staff, right, to pursue it. It wouldn't be a... Here are all the facts associated with this case, just heads up. There is a high-profile case involving a very wealthy man abusing young women. A state attorney is prosecuting, but there's dissatisfaction. I wanted to give you a heads up, both to inform me, but also so I'm aware in my interactions with other Palm Beach officials. Okay. Based on whatever information you got at the time, did you think that there was a federal interest to be served by pursuing a federal prosecution potentially? Yes. And what was that? So, the exploitation of young women. Girls. I want to be minors. Minor females. Alright. For a sort of a glossary convention. Right. That we are using is, and we can use in this interview, is girls. Right. For the victims who, at the time of the conduct, were minors, and women, for those who are not, even though the girls at a later time became age of fair. Majority. Fair. Okay, so here we're really talking about the girls. Okay, who were victims. Yeah. Okay. Girls, minor females. I just don't... Sometimes that term is viewed differently, and so, right. Yeah, so the exploitation of girls or minor females, and that certainly is an important federal interest. Well, and is the number and the breadth of the scheme, the scope of the activity, also a factor there? In other words, it wasn't one or two on one or two occasions. So there's several factors that probably go into what's the federal interest. The acts, the sordidness of the acts, the number, the likelihood or the importance of registration was important to my mind because that goes to further prevention to putting the community on notice. And were you aware that the individual in this case, Epstein, also had homes in other districts, and that it was an interstate activity on his part? The interstate travel and so on? Mr. Heron, I'm sorry, we're still in the original intake time frame. Misredacted. Yes, Mr. Heron, here. The witness. Yeah, again, for the intake time, I can't speak to the details, because I don't remember what the extent of that intake briefing. Ooh. Harry Potter ZR2QM. What did I just get in my recommended? I am live reading the entirety of the Epstein files. All of it's being read live. Oh, 3.5 million, I think, files so far. And I'm on file, what is it? 9,274. So yeah, welcome. I'm reading the Epstein files. Sit back and listen to my suffering. Speaking of suffering, my throat's dead. By misredacted. But could I ask? Yes, a question. Was there a clear briefing as opposed to a heads up based on the record? Yes. That redacted came to Miami to conduct a briefing of you and, okay, redacted, in order to tell you about this case and get from you, okay, a green light. To proceed with it. I asked because I recall an email, and I don't know what the time would have been, where she's coming to Miami, and redacted says, why don't you stop by my office first? Right. And I would speculate that, why don't you stop by my office first is, why don't you give me a bunch of details, and then we will walk across to the US attorney, right, and fill him in. And so that would have been almost a two-tiered discussion. And is that, I don't know if that, the timeline on that email is when you say briefing. Well, we are asking, what it would, be. I'm speaking just based on review of the record, not based on recollection here. Alright. So, to be clear, you have no recollection of any specific briefing in 2006. I accept that I was made aware of the matter. Okay. Sounds like a fun time, hell yeah. I can't say how or in what context or to what degree of detail. Or by whom? I knew the matter. It's easier to recollect, at least for me, what I knew as opposed to who told me what. Alright. At this point, at any point, did you have any reservation about investigating and potentially prosecuting Jeffrey Epstein? A reservation stemming from his wealth and reported standing in the community at all, and influence? No. And we have prosecuted lots of influential folks in the office. So, while he had wealth, it's not unusual. UBS was in the office at the time. I mentioned several high-profile Palm Beach public corruption cases. So there was no concern about possible negative blowback in the press, or the community, or even at Main Justice, if you went after someone like Jeffrey Epstein. There was no concern stemming from his wealth or his status. What would it have stemmed from? At some point, I think there was concerns regarding the law, and we'll probably get into that. I alluded to that earlier in the overview. I don't know if that would have been developed this early on, but that's not a function of his wealth. That's a function of the fact pattern. Right, okay. So as you mentioned petite policy concerns, could you tell us what your position was on the policy as it applied in this case, as you understood it from in the beginning? So the policy, on its face, doesn't specifically apply. Based on Exhibit 1, I'm now inferring, not recalling, it looks like either Redacted on her own or Mr. Redacted asked for a petite policy waiver memo to be prepared, in part on the assumption that the state prosecution may or may not have gone for it. I don't know, but I do recall that early on this was unusual because he had been arrested or arraigned. It was going forward on the part of the state, and so here is the big bad federal government stepping on a sovereign, state, saying you're not doing enough, and to my mind, when, the whole idea of the petite policy is to recognize that the estate is an independent entity, and that we should presume that what they're doing is correct, even if we don't like the outcome, except in the most unusual circumstances. And what kinds of... so the petite policy exists because there's a recognition that there are cases that are appropriately pursued. I mean, you were the head of the Civil Rights Division, after all. Correct. Which is why I say except in the most appropriate of circumstances. Right. But let me add that based on this, I was comfortable, saying, let's go forward because the lack of jail time, to use petite policy language, a plea that did not include jail time or registration would seem like a manifest injustice. Alright. So, did you have any doubt that you'd get a waiver if you applied for one? I'm not... So I'm now speculating. I don't recall, but I'm not sure I would have said, is there a doubt that I get a waiver as opposed to, is this something I feel comfortable doing, or not, and this being the prosecution, or this being the applying for a waiver? Applying for a waiver. And so, either Main Justice gives it or doesn't give it. That doesn't mean you don't apply for it if you think it's the right thing to do. So, for example, in the UBS case, which was one of our big tax, prosecutions, we asked for a Bank of Nova Scotia. Authorization to the Bank of Nova Scotia, subpoena. Subpoena, sorry. And I didn't think Main Justice would, I pushed really hard, and I got into the weeds in that case for that purpose, but I still thought, let's go for it, and we did. And Main Justice didn't give in to it, and that's okay. That's how it works. Okay, so they denied that request. They denied that request, and I say that as an example of, as a typical matter. I don't think what's Main Justice going to say, as opposed to how should we approach this matter. I don't understand about what you mean by how should we approach this matter. So honestly, how do I explain this? So I think there's a difference in saying, let me predict how Main Justice will come out and follow that prediction, versus, folks, what do you all think? Sorry, let me redo that. Versus, folks, what do you all think? Okay, if you're comfortable with this, let's write it up, and let's see what Main Justice does. One is trying to predict what folks in this building are going to think. Another one is trying to predict, another one is saying, what do we do in Miami, think, and then let Main Justice figure it out. And which is the approach you typically took? And my point is, the approach that I typically took is, what do we think, and let Main Justice give it a thumbs up or a thumbs down. Alright, and in this case, how did you do that? Let me redo that. Alright. And in this case, did you do that with regard to the petite policy? So in this case, we didn't get that far in that we didn't have to submit to DOJ. But we were approaching it not based on what main justice was going to think, but what do we feel is the right outcome in this office. So, as I understand, the bottom line is that you didn't, as I hear you, I believe you're saying that you didn't stand down or in any way cease or limit pursuing this case on petite policy grounds. You pursued it as you would. So we went forward with the matter, although there were petite policy concerns in the background. So you're setting this up as a binary, was it a fact? As a binary, you did not limit yourself on petite policy grounds, and I'm pushing back a little bit because I don't think it's part or it's not, as opposed to when you look at a case, there are all sorts of factors, and it is a factor in how you think of a matter going forward. By misredacted. If you had those petite policy concerns, you or members of your staff, I would say a combination of me and my management staff. By misredacted. Who? I can't recreate, but who are you dealing with on this case? Primarily, it would be my first assistant and criminal chief, as I typically... So, there is, to sort of put it in main justice terms, a line attorney has a deputy section chief, and a section chief and a DAG and an AAG, and the AAG usually deals with the section chief or the DAG. And so I was dealing with my first assistant and my crim chief. Right. And they were there in Miami, and by the way, redacted, first line supervisor was redacted? Correct. Do you know why she was not actively participating in this chain of command? I noticed that in the correspondence, and I couldn't speak to that. Alright. But it goes to the point that if you look at she reported to redacted, who reported to redacted, who reported to redacted, who reported to redacted. And so, as a typical matter, I try to empower my first assistant, and my criminal chief, and my office heads, and work through them, not bypass them. In this particular case, with regard either to the petite policy, right, or any other aspect, was there anyone other than that group of 5, if you will, in that chain, correct, from you down to redacted, through redacted, right, and redacted that you were dealing with? I can't recall. I can say as a general matter, it would not be unusual for me to walk down the hill and talk to someone that I trust and say, hey, I've got this fact pattern. What do you think? Do you recall ever doing that in connection with this case? I don't recall the specific briefings or who I talked to. I'm just saying as a general matter that there are folks on the 8th floor that were in management that I would often just walk down the hall and... But do you recall doing that? I don't. In this case, I don't recall. Okay, so we shared with you in Exhibit 3 a pretty lively exchange between redacted and redacted. You didn't... We have no reason to believe you saw this before, but it makes some representations about you, and that's why we brought it to your attention. Okay? Do you recall this email exchange? I don't recall the email exchange. I mean but I didn't see it then. Do you recall having read it before today? I recall reviewing it, yes. Alright, okay. So starting from the end, redacted... Using redacted BlackBerry, which is a little confusing to begin with, notifies redacted that of a particular conversation he had with one of the defense attorneys. At this point, what I want to do is draw your attention to the comment and his response, and we're looking at page 3. Page 3. So in the third paragraph, yeah. It was made clear to you by the U.S. Attorney and the First Assistant from the time when you were first authorized to investigate Mr. Epstein that the office had concerns about taking the case because of petite policy and a number of legal issues. And then later he says that you were never given authorization by anyone to seek an indictment in this case. And, close quote, and then on the first page, Redacted presents her version of that original contact with you, meeting with you, at the bottom of the page. Halfway through the last paragraph she says, my recollection of the original meeting with Alex and Redacted is quite different than your summary. In that meeting I summarized the case and the State Attorney's Office handling of it. I acknowledged that we needed to do work to collect the evidence establishing a federal nexus, and I noted the time and month. I noted the time and money that would be required for an investigation. I said I was willing to invest time and the FBI was willing to invest the money, but I didn't want to get to the end of it. To the end, and then have the officers be intimidated by their high-powered lawyers. I was assured that would not happen. Can you tell us which version of that initial... Which version... Right, is correct. So again, I don't recall that initial briefing, so I can't tell you which version is correct. I would also say that it's possible neither version is correct, and that there's a little bit of truth. Now, I'm just speculating. Alright. That there's a little bit of truth in either one, because it's certainly possible to say. I hear you. Righteous case, go forward and investigate, work on the federal nexus, which is what Exhibit 3 is saying. Go work in the federal nexus and find evidence for the federal nexus. But we have concerns about petite policy and legal matters, so there's a lot of work to be done. So what kind of a direction does that amount to the line author? What's her job then? So the job would then be to go back and investigate and develop facts and report back. And if she developed enough facts and supportive law to present proposed prosecution, right, okay. And so a lot of times in this, she said, there's a little bit of truth to both sides of the discussion. I'm just saying as a general matter, your questions are sometimes either or, and sometimes right. It can be a combination of both. Alright, but in fact you don't recall. But I'm speculating. Alright, is there anything in either of those two versions that you say didn't happen, couldn't happen? I can't because I don't recall it. I can't. Okay, speak to that. I would speculate that there's probably a little bit of truth on both sides, and if you read it closely, you'll see that Redacted acknowledges the need to work in a federal nexus. So that goes to, where Redacted or Mr. Redacted. I'm sorry, I'm using first names. It's alright. So I'm going to just start. This is an informal interview. I'm going to just start using first names. I don't mean that disrespectfully, where, Redacted says, because of petite policy and legal issues, and Redacted is acknowledging the legal issues, because she's saying needed work to collect evidence establishing the federal nexus. Alright. So, yeah. So they're not as inconsistent as presented. Alright, arguably. Back in 2006, in this exhibit number 1, Redacted tells you in his email that the indictment target date is August 25th, 2006. In other words, very shortly, right, thereafter, within a month or so. Do you know why the line author, Redacted, was keen on getting the federal case against Epstein brought on a quick basis? So I can't speak to that, and can I ask, based on your record, was that the state indictment target date, or was that Epstein had already been indicted and arraigned on the indictment. So that's the federal. So that's talking about a federal indictment. All right. The point, correct, is that early on, the investigative teams, the FBI, and Redacted were hot to trot to get this, case moving from a federal standpoint. That may well have been quite unrealistic given, correct, all of the issues that we've been discussing. But the question is, do you know why there was some urgency? I haven't the slightest idea. When was it? When was it initially brought to the office? It was brought to the office in May of, 2006. There will be a really, really fast timeline. Right. So the question is, aspirational though it may have been, there was a hope, to get it done quickly? Right. So the question is, can you think of factors that would have led a prosecutor to want to pursue, this quickly? I don't recall. I can speculate that Redacted was very hard-charging and wanted to do a lot, and was that your experience of her? So based on this, I see, so Exhibit 2 is, excuse me, but just from your memory, is that your recollection of how Redacted operated? Hard-charging? Yeah, I'd say. So a lot of really good prosecutors are hard-charging. That's alright. That's part of the job description. Okay, and so yes. This was... right. A priority? I have heard that discussed recently in the media. I don't recollect that part of a discussion back in 2006. Alright, okay. Do you recall that Redacted, and this is just, do you recall? That she periodically would give you in that early period of 2006 updates, written updates. Did you think that it was appropriate for a line author to be shooting emails updating on a case that was under investigation directly to you and your first assistant? It was unusual, and so did I think of look, I can't reconstruct what I would have thought, but you're asking not just what did I know, but what would I have thought 12 years ago. But I can say that based on general practice, it would have been unusual. And my best guess as to how I would have reacted would have been, hey, Redacted, this is unusual. Is the chain being fully informed? Our feathers been, right, ruffled. Figure it out because, you asked me early on to characterize Redacted's qualities. I think one of the things that I said was he was very good at smoothing things over. And sort of the interaction, because he was respected, and so I might say that's kind of unusual. Go figure it out. But you wouldn't necessarily jump at that chain yourself and be... indirect communication. I tended not to... Okay, do that. By Redacted. Would she have sent this to you, something unusual, if she thought that this was a case that you wanted to be involved in? Even in those... I think this is a different person questioning, but I'll keep the same format just for ease of doing it. Would she have sent this to you, something unusual, if she thought that this was a case that you wanted to be involved in? Even in those, I try to be, as a general matter, fairly sensitive to the chain, because I had found that if you start jumping the chain too much, even if you become informed, managers feel, out of the loop, and that's not conducive to sort of allowing them to do their job of supervising. It's a big enough office. You have to empower your folks to do their jobs. So the concern on your part would not be that she was communicating directly to you, but that as long as all of the chain of command was informed as well. Yeah, I mean, if you're redacted, or don't want to talk to the line attorney before the line attorney talks to your boss. And so it's not just informed, but it's respecting your supervisor. And it's difficult balance, because often really good authors are also the ones that, just want to get things done. By Ms. Redacted. Did you have any reason to believe during this investigative phase that Redacted was not pursuing this investigation adequately, appropriately, and fully? No, I did not. Did you? Not to my recollection. Did you feel that she did not have appropriate oversight? Not to my recollection. Okay. Did you feel that she had any resource problem? That is, did she have, as far as you know, sufficient resources available to pursue her investigation? To my recollection, yes. I noted her early. I noted more recently the email where, that was shared with me by Redacted about resource concerns, and I would just note that I would allow the management chain to figure that out. All right. Did you at any point consider, based on what you then knew, expanding the scope of the investigation? Did you ever suggest or propose that instead of simply looking at Epstein's conduct in West Palm Beach via a vis-a-vis these girls, that the federal authorities could use their resources to look at other aspects of Epstein's activities? So I think it's important to take a step back. And I was aware of any number of cases going on in the office, and based on what that stage of case was at, I would get more involved for a time. It wasn't my practice to direct authors in how they should investigate, or what the scope of a case investigation should be. The Miami office, before I got there and after I left, had a reputation for knowing their stuff. It's a large office, it's got good people. I would assume that authors and their management would follow their natural leads. Alright. Were you aware that during this period, and by this period, I'm talking about the investigative period from the time that the case came in mid-2006, right, up until May 1st when Redacted put forth her pros memo, right, and proposed indictment. During that sort of 10-month period, or almost a year, were you aware that defense counsel for Epstein were reaching out to Redacted and to Redacted to pitch their view of how the case... Right, should proceed. So I don't have a specific recollection of who reached out at what time. I would assume as a general matter that defense counsel were clearly involved before the case came to the office. And so I would assume that defense counsel would remain involved while the office was investigating. I say that not based on independent recollection, but right. Why would they stop being involved? And is it, in your experience as a US attorney, was it common or uncommon for defense counsel to approach the line prosecutor and supervise to make whatever pitch they want with respect to a prosecution? Fairly common. Alright. And was it also common for those approaches to be entertained? In other words, for the line officer and supervisor, right, to meet with defense counsel? As a general matter, yeah. And did you view that as appropriate? As a general matter, it was typical. It happened before I got there and is probably happening now. And you view it as an appropriate part of the process, do you? I think authors need to have direction to meet with defense counsel, or discretion to meet with defense counsel, sorry. And defense counsel certainly should be able to present perspectives. There is an outlook. This is Exhibit 4, and this is something... Okay. It's really sort of a point of information here. This is an outlook that shows you and Redacted had a scheduled meeting with Roy Black. Roy Black, a prominent, local criminal defense attorney at the time in the Miami area. This was a meeting scheduled in your office for the 23rd of February of 2007. Do you have any... He at the time, it was one of Epstein's attorneys. Do you have any idea whether this meeting related to Epstein or some other case? I don't. I noticed that, and I don't know whether it was this or another matter. But you have not particular recollection of meeting with him on the Epstein matter? I don't. At this time? Okay. So I want to, and let me note, I think most of the correspondence was from other attorneys and not him. And so, yeah. Alright. Are you okay? Do you want to take a short break, or... Yeah. Do you... What time is it? Oh, 11 o'clock. 5 minutes? Yeah, 5 minutes. Yeah, let's take a 5-minute break. Off the record. Off the record. By Mr. Redacted. Ooh, I'm tempted to take a break as well. But no, I'm going to power through. How's everyone holding up? We've got some very interesting stuff here. I'm going to look to clip all of this, and I'll probably wait to see what's ahead in dataset 7, but there's a reason why that this is essentially its own dataset, and this is the majority of dataset 7 as well. Just this interviewing this person here. So from what my understanding is, he was the head honcho at the time, but there's a massive chain of command. So he was the guy right at the very top. He did have some say in this, at least if what he's saying is correct. But there's a little bit of Chinese whispers, and there's a little bit of a laissez-faire management style. Essentially, he's not a micromanager, which, okay, that I can respect, and he's letting his subordinates, carry out their duties. But the big question is, with this, who is responsible for not pursuing Epstein to the degree they should have in Florida during the Florida investigation? Because Epstein only ended up with 2 years in prison, which got knocked down to 1.5 years. And I think, from my understanding of that whole thing, although it may change here, from my understanding, that is because he cut a deal, some kind of deal, like a plea deal. So I don't know why did that happen? Was it lack of resources or something else? But it seems like here it's just this guy wanted to get along with the state attorney, local attorney, that kind of thing as well. And I think this bureaucracy did kind of slow things down a little bit. But I don't. This is not necessarily to say that this guy is innocent. I mean, he's, at the end of the day, he captained the ship, and he probably should have said some things in there. But yeah, the police had nothing to do with it. The police in Florida did a damn good job. I will say that the police in Florida did a damn good job. But they did note that the attorney's office and all of that, they were slacking a little bit. But I think is Barry Krishna, I think the name was. That was the guy that they noted as not prosecuting harshly. And that, from what I can tell so far, that might be the point of the weak link in the chain. But I don't know. We haven't even gotten through 25% of this yet. I think I will definitely take a break when we finish this file, which is, all of these files are like 100 pages with the exception of this one. This goes from page 300 all the way down to 412. So yeah, it's 25% sort of. All of these, this is 100 pages, this is 100 pages, this is 100 pages. These files are very, very dense. Densely packed. Barry Krishna does sound very familiar. I think he might... I don't know. I think some action might have been taken against him. Yeah, I think Barry Krishna might have been the prosecutor. I did also... I mean, the name has come up before. I don't know if he's obviously not one of Epstein's attorneys if he's, part of the whole part of the whole prosecution stuff. But he has definitely been named before. Excuse me. Alright, I'll carry on here. Alright, back on the record at 11:12, having broken at 11. Mr. Acosta, we're going to move on to that time frame I mentioned a moment ago. May of 2007, when Redacted submitted her prosecution memo of more than 80 pages and her proposed indictment. Her initial proposed indictment, which was more than 50 pages. She submitted that by transmittal memo to her entire chain. Redacted, 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 and you. Was that a typical way for an indictment and proposed prosecution? The memo to come? To my recollection, it was not, and I don't recall that happening in other cases. I'm hesitating just because I'm trying to think through if there's... I don't have any recollection of it happening in another case. Why do you think it happened in this case? And who caused it to happen? I don't know, and I don't know. Alright. So, before you saw it, I don't know if you even knew about it. By reference to Exhibit 6, you learned essentially from Redacted that the FBI was planning to do a press conference 2 weeks after that. And Redacted, this office had not approved the indictment. Therefore, please do not commit us to anything at this time. And eventually that email chain, right, gets to you, apparently by blind carbon, because there's no indication you actually get it. Right. But you advise Alicia Vale, who I think was your press person, correct, that Redacted hasn't even finished her recommendation to Redacted, i.e., we are a long way off. So, did you have any idea why the FBI was planning a press conference on Epstein? I don't know if I did. I don't recall if I did. How typical was it for the FBI to plan a press conference on a case that was being indicated at the time of an indictment or arrest, without coordinating that with you and your office? Under Redacted, highly atypical. He was the SAC at the time. He was the SAC. I know he was the SAC at the time as of September, and I'm almost certain he was the SAC at the time. Alright. And when you said that we are a long way off, and Redacted hasn't even finished her recommendation to Redacted, do you know whether you had any idea that she had actually submitted her pros memo, and that she had made a recommendation to Redacted? I can't recollect. Okay, but I'll take my words as reflective of, if I say she hasn't finished her recommendation, then I assume she hasn't finished her recommendation, but I don't recall. Does that mean that level of detail? As you look at your own words, does that suggest to you that you were unaware as of that moment that she'd actually submitted her pros memo? That suggests that I would not have been aware that she submitted it. Because it sounds like I'm saying she hasn't even submitted her memo to Redacted. So, alright, we're a long way off. Alright, but again, this is based on practice, not recollection. Alright. And when you said we are a long way off, did that reflect, if you recall, an assessment of the length of time to get to a memo? A recommendation and an assessment of that, or your expectation that even when you saw a pros memo and an indictment, it would be a long process before it was approved? So, I would assume, and again, this is just based on speculating from the way that I write, that I'm thinking she hasn't submitted a recommendation to Redacted. Redacted needs to review it. He may, he'd probably want to talk to Redacted. It needs to be scrubbed. This ain't happening next week. Alright, but do you have any reason to believe that whatever that process is that you are describing would be any different in any particular measure in this case from the ordinary complex case? So in my language, I would take that it's the same process, but that there is a process, and the process hasn't yet been followed. Alright, okay. So it would be the typical process in a typical complex case. Alright, and is it fair to characterize this as a relatively complex case, given the legal issues? I think it is, yes. Okay. In Exhibit 8, you actually got in Exhibit 7, you see that in the bottom part of that you received a copy of the pros memo on the second page of that exhibit at the top. Right. Redacted is forwarding to you the pros memo. Alright. In Exhibit 8, you see that Redacted is forwarding or sending to that chain, excluding Redacted, that is, Redacted, and you, additional items in Operation Leap Year, and that's a summary of the indictment, and evidence regarding the individual victims. Okay, so as of May 11th, you had before you the PROS memo, the proposed indictment, and this substantial amount of additional, information. Did you read the PROS memo? Right, so I don't recall. And I know you're going to say, why don't I, but this was a long time ago. I don't recall if I read it, or if I went back to the office and sat down with redacted and went over it. I can't recall from this far. I can say that it looks, based on this, that I was at the US Attorney's Conference. The idea of printing this out on a hotel printer, I can't believe I would have printed this out on a hotel printer. Let alone read it on an airplane, correct? Let alone read it on an airplane. That just wouldn't, have been my practice. But arriving back, to your office. Was it your practice to take voluminous documents like this and go through them yourself, or did you rely on your senior staff? I would typically rely on senior staff. They're the experienced ones that have seen these matters before. They would go through it. We sit down, we talk about the issues. We might have it in front of us, almost like you've got all those, binders there. But you're calling my attention to particular issues, and we sort of talk it through. And do you recall doing that in this case? I recall having discussions with senior staff about this case. Who? Certainly redacted at various points, and I can't say that I did that in May versus April versus June. I can't give you, timelines. Well, we're talking now about May, because you got the actual, process. It would have been my practice based on this to go back and discuss it, and so based on my practice, I would have gone back and lightly discussed it. I doubt I would have printed this out at whatever hotel I was at. But even when you got back to the office, would you have had somebody print it out, so you would have had it available? I may have had someone print it out, so it's available. I may have focused on particular parts of it. What kind of issues would you have focused on? In other words, some might go straight to the facts. Some might be interested in the legal theories. What was your approach? So I think that depended on the case. Okay. Here you had legal questions, and you also had witness issues, and I would think those would have been the two primary areas. Would you have gone through the indictment and the PROS memo and all of those other materials, or just relied on your experience seeing your people redacted? As a general practice, probably some combination. As a general recollection, the concerns in this case weren't about the sort of details of what happened, because we believed he did what he did. The concerns were about some of the legal issues around it, and some of the issues in terms of the testimony. Of the victims? Of the victims. Alright, on page, and I say that because that would have been what I would naturally focus on, as opposed to reading these sort of details, because I think everyone believed the victims. Alright, Exhibit 9 is an email that you are not on, but that notes that redacted is advising redacted that you, redacted, has your memo and Lefcourt's letter. Gerald Lefcourt was, a New York attorney who was one of the members of the Epstein defense team. Did you know him? I did not. Did you ever encounter him, as far as you recall? I did not. Alright. He had, according to the documents we have, made 2 substantial submissions to redacted in, February of that year in an effort to dissuade them from pursuing a prosecution, and we have every reason to believe, and no reason not to believe, that that's what is being referred to. Do you recall reviewing substantial submissions from defense counsel at this time, attacking in very granular detail, the credibility of the witnesses, and so on? I don't recall reviewing those. Again, I recall discussions with my senior team about issues that included the credibility, and I'm not sure if it's... credibility is the right word, but how the victims would do on the stands. Okay, and who do you recall talking to you about that? So, some combination of redacted would have been the likely... I recall the discussion. I don't recall whether it was redacted or whether it was redacted, but the logical inference would have been some combination of redacted. Redacted has told us that during this period, he was not actively involved in this case. But that redacted was. Would that be consistent with your memory, or would... that... sure, they were a team. They became more or less involved based on needs. And was there any particular... If redacted was working with you directly on reporting, on his assessment of this case, was there any reason for redacted to be involved? I might bounce ideas of him. He was right across, so he worked closely, but redacted was the criminal chief, and if he was in the weeds, redacted, I would speculate was sort of, much like me, defer to his judgment, because they've known each other and they've worked together, and they had a good working relationship. And Do we understand correctly that as first assistant, Redacted had a brief that really encompassed the entire office? He did. All right. So he supervised the civil, the criminal, the appellate, and the forfeiture. All right. There is here in this email that you did not see back in the day, Exhibit 9, a pushback from Redacted regarding the rush that Redacted is in to pursue this case. And he says, this is obviously a very significant case, and Alex wants to take his time making sure he is comfortable before proceeding. Can you tell us what the basis will be for, or was for that assertion, by Redacted? So, I can't tell you from recollection what the basis is. I can speculate that the material is being transmitted Friday morning. Oh, I guess it was. Yeah, so, the 11th. Yeah, Friday. So, Friday morning. It hasn't been reviewed by anyone in the management chain, much less approved and edited, and Redacted that Monday as saying, why don't I have a decision? And so, absent truly extenuating circumstances, typically you'd it'd go through the management chain up to the US attorney, and so he's pushing back, saying, hey, it's been a day, or it's been a weekend, I'm just reading between the lines here. Who had authority to sign off on the Epstein prosecution? To, say, indict? So, as a delegated matter, Redacted has signature authority. As did Redacted, and obviously I did. As a practice matter, this is something that would have gone through the chain, and that we would have then discussed. But why up at your level? Is it because it is, as Redacted says, obviously a very significant case? So, at my level, not only because of the facts, because it's not about the facts, but I do think that there are legal issues that implicated policy that we were thinking through. And what were the legal issues, and what were the policy issues? So the legal issues, and also factual issues in terms of the witnesses. So the legal issues. And there's an email from Redacted based on the contemporaneous record that alludes to some of this. In my experience as the Civil Rights Division, trafficking cases involved, I can describe some horrific cases of girls being held against their will, You had child pornography matters with young women, sometimes incredibly young, that the office prosecuted. As the trafficking laws were being developed, there was a lot of discussion about what's the difference between trafficking and solicitation, and that discussion took place as the trafficking laws were being developed, and so this implicated what is local and what is federal. Alright, so in the first category, you're talking about the individual charges that were being proposed, which included both trafficking and coercion and enticement. Correct. Alright, and in the latter, you felt that, to what extent did the victim witness, kind of credibility issues implicate policy? So I think I said policy and victim in that. Alright. In that there was certainly discussion between me and my management about concerns as to how these victims would sort of stand up in court. So, what would make you comfortable before proceeding? What at that point would have made you comfortable about proceeding? So I think that at this point, I don't think it's what would or would not have made me comfortable, and I'm speculating here. I think it came in on Friday. Let's talk this through. But you've just identified for us issues that in your mind we would have had to be resolved, wanted to talk through. Alright, okay, at that point, did you, to your recollection, have any doubt that some form of indictment or charging instrument against Epstein was likely to become viable? So it was a case that I thought it very important that we do something. How that something played out, I think, had all along been a matter of discussion. As something other than what the US Attorney's Office does, which is prosecute? Well, no. I mean, what the US Attorney's Office does is ensure that justice is served. Right. And in partnership with state attorneys, and sometimes that means state attorneys take the lead. Sometimes it means the US Attorney's Office takes the lead, and a lot of times we actually had, we would share stuff, because sometimes it made sense for one part of the other to take the lead. So, writ large, I thought throughout it was very important that something happen. There were these concerns all along. I can speculate that this is just a reflection of those continuing concerns. As expressed by you to Redacted in the ordinary course, as developed as a group throughout this, so, if we go back to, what was the exhibit? June of 2006. So, Exhibit 3, redacted says, in that meeting I summarized the case and the state attorney's office handling it. I acknowledged that we needed to do work to collect evidence establishing a federal nexus, and I noted the time and money that would be required for an investigation. And so, as far back as that initial meeting, there was the discussion about the federal nexus, and is this a state or a federal, right, case. Alright. Exhibit 7 is an early email from redacted to you. Early, meaning it precedes the one, correct, we just looked at. And early in that is right as your right. Receiving the pros memo, and you ask him, have you read the memo? And curious why you ask redacted rather than redacted? I don't recall. I can speculate, and I have two thoughts that I'll speculate. One is redacted, her direct supervisor. And I might be thinking, second line supervisor. Her second line supervisor. So why is redacted sending me this? Redacted, have you read this? Did you jump the chain? Secondly, I may have wanted to have multiple opinions on this. It's most likely that I had talked to redacted already, because redacted and I talk more often, and I'm asking another person in the management chain, hey, what do you think? Let's have multiple opinions on the table here. Well, this is the first time other than redacted that we see you getting a recommendation. Right. When redacted says, he thinks that you should charge him. You, the office, should charge Epstein. He has issues with the charging strategy proposed by redacted, but one, he says, we all need to get on the same page as to whether the statutes covered the conduct, and whether the conduct is the type we should charge. I think the answer to both is yes, although there is some risk on some of the statutes. He proposes that the office start with a complaint, which is not unusual, is it? It happens, yes. Alright. Which allows the defendant to be arrested and ideally detained, and then the defendant is then highly motivated or incentivized, to work a pre-indictment resolution. That's what redacted is proposing. He also knows that it's important to, in his view, to cap him with conspiracy counts to make a plea attractive. And the court could give us a hard time with that if we had to dismiss indicted counts. Right. Okay, the proposed indictment included one conspiracy. A conspiracy that has a 5-year cap. Statutory maximum. And this notion is that Epstein be charged with a 5-year conspiracy count and take it from there. Do you know what he was referring to when he noted that a court could give you a hard time in dismissing indicated counts in this case? So as a typical matter, once there's an indictment, a pre-indictment, well, by definition, a pre-indictment resolution comes off the table, but in cases of this nature, the resolutions tend to happen before indictment, because once the indictment is done, at least in South Florida, dismissal of charges. For example, if redacted is saying, let's think about a 371 with a 5-year cap, a Rule 11, that's something that South Florida judges. They tend not to, dismissing a number of counts and then doing a Rule 11 is not something that judges tend to do. Alright, two pieces to that. One is, the issue of dismissing substantive counts. Was that a particular concern in this case because of the nature of the conduct represented in the substantive counts? So your question, you asked a general question and then now you're moving to a specific. As a general matter, not just in this case but in other cases, it was rare that the office in cases like this, after a full charge was done, that the substantive counts were dismissed. So, for example, in the public corruption cases that I referenced earlier out of Palm Beach, those were all negotiated pre-indictment and agreed to, and then by the time the case was indicted, it was all sort of set on autopilot. Sorry, I'm stumbling a lot with these legal terms. So typically, in my experience, a disposition like that results in a criminal information, not an indictment. Correct. And are you saying that you would go ahead and indict then? No. What I'm saying is that it was all negotiated in advance, and then there was an information. Oh, okay. and the information would go forward, not an indictment. All right. And so that is how a number of high-profile cases typically proceeded, as opposed to indict and dismiss. And that is the experience of the Southern District of Florida in general. It was in particularly the Palm Beach office with other high-profile cases that were there at the time. Do you recall any case in which a judge in an indicted case refused to dismiss counts when the government, in an indictment under those circumstances? I don't recall specific cases, but I can say that typically in the higher profile cases you'd negotiated with opposing counsel, presenting information. The information would have agreed to an agreed guideline, and it would proceed in that way. Understood. But in this case, I'm focusing on the assertion by Redacted that the court could give us a hard time, and that's a little different from, exercising discretion to negotiate and proceed by information. So is there any charge that was particularly concerning with regards to an unwillingness to, dismiss? I don't. So first, this is 12 years ago, and I don't recall any specific judge, but I can say that was not the practices of the office, or practice of the office. The practice of the office was to proceed by information rather than indictment with dismissal, because you can lay out more what you've negotiated. I think later there's a letter from Redacted that sort of presents the same perspective. Alright, in Ms. Redacted. One moment. Ms. Redacted. Go ahead. The witness. Yeah? By Ms. Redacted. You said in cases of this nature, the resolution happens before indicting. What is this cases of this nature? Higher profile cases. So, not necessarily sex offense cases. Not necessarily sex offense. No. Higher profile cases where, and this was a higher profile case because this was so I would say it's a combination of all of the above, and to my mind, one of the parts of this case is the legal theories were, if not novel, they were novel within the Southern District of Florida. At least some of the legal theories, and I will probably get into that. Did his wealth make it a high-profile case? Well, it was clearly in the paper, and so that made it a high-profile case. I don't think it was his wealth. I think it was all of the above. This was a matter that the state attorney had been ready to charge, that the federal government is now jumping into and saying, by its presence, that the state did not do enough. That in and of itself makes it a very high-profile case. I can't remember any other instance, certainly during my time, when we jumped in and said, the state dropped charges, and so we are going to do more. By Ms. Redacted. As opposed to, or as distinguished from what you described a few moments ago, a situation in which the federal authorities and the state authorities kind of worked together to sort out what would be charged, where, and do it cooperatively. And that was more cooperative, and I do recollect that, and I think the record bears this out, that this was not a particularly cooperative relationship between us and the state attorney. Yes, we will get to that. Will you... If I could return, I think your question, the way you posed your question, you said a recommendation from Redacted, and let me push back a little bit on that. Saying, what are your thoughts? Have you read it? What are your thoughts? And he says, yes, we can talk next week. My current thoughts are, it's very different than we sat down, we discussed this, this is now informed position, or this is my now informed position. Understood, and I should have been clearer. I was referring to his recommendation that if you were going to proceed, you should start with a, complaint, just to be clear. And I'm just saying, okay, initial thoughts are, yeah. Alright, so were you aware that Redacted bootlegged a copy of the PROS memo to Redacted Axios? I was not. He did at that time. Okay. And did you know Redacted? A little bit. I certainly knew of him. Had you encountered him when he was the chief of the Child Exploitation and Obscenities section? Right. In the criminal division here, correct? Had you encountered him while you were in this building also? Most likely. I knew of him enough that the correspondence shows, and I recall asking to involve him pretty early on. So it does read as if you are acquainted with him. Yeah, alright. And did his opinion, his views as chief of CEOS and as Redacted, who had been an ORSA, right, in Miami, did his views have influence on your thinking about this case? I don't think at this time I was aware that Redacted had been consulted. Alright. And in July, just so you know, and this is not something you saw, he provided a fairly strong statement by email to redacted, in which he advises that he reviewed the Pross memo closely. It's terrific. He says Redacted did a terrific job, and he says, we agree with her legal analysis. Her charging decisions are legally sound. And then Redacted goes through the different statutes and concludes that they are all properly charged, and that although there are some issues legally that in his view we should prevail, our position should prevail. And that he also reviewed the arguments contained in the letters from defense counsel, and he found none of their arguments persuasive. So, at least as of July 18th, you're right. 3 levels of supervisors down were on notice that COS was on board and wanted to, right, see the case move forward. But am I correct in understanding that at that time you are unaware of that? I do not recall being aware of that. Alright, okay. If you have been aware of it, if they had sent this, I don't want to overstate it, but it is a pretty strong endorsement of the proposed prosecution. Would you have been influenced by that? Sure, I would have. I mean, I respected Redacted and clearly wanted him to be part of the team, and later invited him down. And so, yes. Okay, alright. Do you know why they wouldn't have shared? Your people wouldn't have shared this with you? I don't know. Alright. So, based on the briefings that you got in this time period, when there was an effort to try to figure out, right, what you were going to do, were there any issues of concern of fact or evidence, or the charges that were left unaddressed? In other words, if there were issues about victim credibility, were steps being taken to address those? Unaddressed is it is a very binary, and it's not about addressed versus unaddressed. And so let me sort of come at it, if I can try to get... There were concerns around some legal issues. There were concerns about how the victims would do when put on the stand. Right. As a general matter, we thought there was enough if we had to go forward, we could, as an ethical matter, go forward. That doesn't mean that there was not value in a pre-indictment resolution. And so here you have Redacted, based on this Exhibit 7, saying, we need to get on the same page as to what to charge, pre-indictment resolution, capping with conspiracy count to make up the attractive. So a 5-year cap, something less than 5 years, you have Redacted in her affidavit that was submitted to the court saying she favoured a pre-indictment resolution. And so it's not a, have you addressed everything, yes or no, as opposed to putting all of this, how do we move forward? Right, but there is a binary point here, and that is, you either indict or you don't indict. Or indict. I don't know how you're meant to say it. It's legal jargon. You either present an indictment to the grand jury or you don't, right? That's a decision, right? So I would actually push back in that in many cases. It's not quite that binary. In many cases, you sit down with opposing counsel and say, look, we can go to a grand jury and we can present this indictment and indict, or we can resolve this now. If we resolve this now, this is the path that can go forward. Alternatively, we can go here, and so it's not an A versus B. I understand that nuance, but the decision to indict you either indict or you don't. If you don't indict, it's for any number of reasons. If under these circumstances, the choices that are available are you have a case that's been brought in, taken in from, the state. You can decline it. Send it back to the state, make it go away, whatever. Right. We're not interested. You can indict. Or indict. You can indict and go to trial. These are the subcategories. Or you can indict and have the defendant plead to the indictment. Or you can indict and work a post-indictment plea deal, which raises the issue you talked about. Or you can negotiate or you can charge, proceed by complaint, and do as Redacted was suggesting. Right. Work a pre-indictment but post-charge disposition. Or you can work a pre-charge disposition, right? I mean, that's really... So that's the parade of possibilities. Sure, but there's more than indictment or don't indict, or indict. That's 6 or 7 options. I understand that. That's how it will play out. But the decision as to whether to indict is binary. You're either indicting or you're not indicting. The act of indicting is something that either happens or doesn't happen. That's all I'm saying. Sure. Okay? So, what I'm getting at is, with respect to the indictment, so, as you're looking at this case, it sounds as if you're doing sort of one analytical track, which is, what do we do with this case? The other piece of that, and a track that could have been followed exclusively, is, what do we need to do to get an indictment that is legally sound and evidentiary? evidentiarily solid. Fuck that word! I like to focus on that track. Okay. Because they're not unrelated. Sure. If you never get down the do we have a viable indictment road, that you're not going to be able to do anything in the other, sure, road. So at this point, you had identified, and you and your people had identified some victim-witness issues, and some legal issues. My question is, were steps being taken to, I used the term address, right. Let me clarify. With respect to the witnesses, was the FBI and the line attorney, with the assistance perhaps of the grand jury, taking steps to corroborate, right, shore up victim-witness testimony, find new victims, find additional evidence, and so on. So taking that in part is helpful. So, with respect to the witness issues, I recall, and Redacted goes into much more detail in her affidavit, but I recall concerns that were communicated to me about, in essence, to sort of summarize my impression or recollection. These girls are young. They're impressionable. They are scared. Will they stand up in court? There's any number of things that could be used against them. Some of them are, and this is uncomfortable, but some of them thought he actually cared for them. And that's not atypical in these cases where they sort of develop thoughts actually saying he did nothing wrong. And because many of them knew one another, how would that all play out? Right. And so it would be my assumption, particularly given, how much work Redacted was doing on this case, Ms. Redacted was doing on this case, that she, in combination with the FBI, would be pursuing those matters and looking to develop the evidence and cooperate. And throughout this process, it would have been my assumption and hope that she was continuing to develop the facts, because that can only help. And so as U.S. Attorney, would it indeed have been your expectation? Yes. And the expectation that all those interim supervisors would have been supporting her and encouraging her and guiding her? It would have been, and that's what happens in typical cases. Right. Just because we're having a legal discussion doesn't mean you stop pursuing leads. Alright, let me stick with the evidence piece of that. Yeah, I'm going to keep these. Helpful. Strains going. You got a very detailed accounting reflected in Exhibit 8 from Redacted of the different Jane Does, and there were a lot of them, and there were many counts in the indictment, and many... Okay, that's the end of that file. Many, carefully, each victim was tied to a particular set of criminal activity. In other words, these victims were not lumped in an aggregate sort of formless petri dish. Yes, they were individuals. Redacted was meeting with them. Indeed, was finding new victims along with the FBI. And they were conducting individualized assessments of the viability of each victim witness. And indeed, Redacted submitted a follow-on pros memo, a pros memo addendum in July and another one in September, and continued to tailor her proposed indictment to these individualized acts. The question, when I hear the victims referred to in the aggregate, I wonder what effort there was to sit down and address each individual victim, because there were so many, and a credibility issue that could be very troubling with one victim, or 2 victims or 4 victims, fair, could well be overcome by other victims who had not these credibility issues, perhaps others, and if I may finish, that in the aggregate, when presented individually in total, a kind of a persuasive case could be made that would be impossible with 1 or 2 or 3. Is that a fair? So that is fair, and I think, and your point that we shouldn't sort of talk about the victims in aggregate is a fair point. I would respond, and Ms. Redacted goes into this in her affidavit a little bit, and I've got it, and I have a recollection of some discussion of this between myself, and you're going to ask me who, so let me just say I don't know who. But the concern is when you have victims that know one another, to what extent would defense, even if you got 2 victims that say A happened, even if it's similar sets of facts, and another victim that said he did nothing wrong, and another victim that said horrendous things happened, to what extent does defense cast this as they are trying to recover, they're trying to do? And so one of the concerns was when you have victims that know one another, that brought one another in, even if you've got similar patterns, if some of them cast doubt, how would that be taken by the jury? Is that assessment or analysis your own, or is it one that you developed with the people you talked to about this case? So that assessment would have been in my general recollection, but also based on my practice, that kind of witness assessment is the kind of thing that I would have relied more on the ORSA, on my management team for, because that was more within their area of expertise. Right, and Redacted in particular was known as a trial attorney. Right, correct? Right. Do you recall having discussions with Redacted about that? He would have been the logical, right, person. I know that we had those discussions and we talked about what happened. How will they play out at trial? And the takeaway was, it could play out well, it could not play out well. So, as of the time that all... And again, I say they as a collective. Right. Understanding that some would say exonerating things. Some would have contradictory statements. Some may not want to testify. And so that conversation was had. So, was had. You and Redacted talked about it? I can't say. Redacted and I can say. I recall the discussion, I don't know, 12 years ago? You might recall a discussion from 12 years ago. What you presented to me, for the record, I'm pointed to Redacted, or I'm indicating Redacted. The issue about civil rights. Do you recall who else was in the room, or wasn't in the room at the time? It's a rhetorical question. We'll take it, I guess. But, yes. One can remember substance without remembering who was in the room at the time. And understanding, right, that this was one case of thousands that were under your, correct, authority. Although a particularly sensitive and high-profile one. But the question to you is, do you know what individualized assessment Redacted did of the victim witnesses? I can't speak to that. Do you know whether he actually met with any of the victim witnesses? I can't speak to that. Do you know whether Redacted went to West Palm and sat down and actually went through the evidence as to each one of the potential eyewitnesses? I can't speak to that. Do you know any of that information as to Redacted? Again, I can't. I can't speak to that. I would say that Redacted was first assistant, and to the extent he relied on the criminal chief, he used to be criminal chief, and so, right, he would naturally view the role of criminal chief as being important, and someone that would naturally review matters before they went to the first assistant. I'm trying to find a good point to stop, to be honest. Okay, so when you were, as you recall, having these conversations about the victim issues as matter of evidence, you cannot tell us what the basis for Redacted analysis was. I can't. I mean, as a general matter, I don't recall the specific. As a general matter, when I talk to individuals about a case, I would assume that they had informed themselves and had done the diligence necessary to have that discussion with me. Do you remember him passing out for you, or I don't recall that. The individual, that level of granularity. All right. To finish my sentence, to the individual witnesses, and you're saying you don't, yeah. And by witness, I mean victim witness. Did you ever sit down with Redacted and have her present to you each witness, each victim as a potential witness, and her individualized credibility issues, and how as a prosecutor and an experienced trial attorney, Redacted was going to overcome those issues? I don't recall doing that, and as a matter of general practice, particularly when it came to what I'll call trial issues, we had really experienced individuals in the office, and that's not something that I would typically do on this or other high-profile cases, because they're the trial lawyers. This is what they do. I would tend to focus more on the legal issues. All right, I want to stay with the witness issues and the evidence of that for the moment. In Exhibit 3, this lively exchange between Redacted and Redacted. She asks to make a presentation to you in the last major paragraph of her email on page 4. She says, I would like to make a presentation to the U.S. Attorney, Redacted, and you, with our side of the... Redacted, and you, with our side of the investigation and a revised indictment. The presentation will address the points raised by Epstein's counsel and will convince you of the strength of the case. Bearing in mind that by this time Redacted and Redacted had in front of them, right, her pros memo, her proposed indictment, this analysis she did as evidenced in Exhibit 8, but also the submissions from Jeffrey Lefcourt, and that Redacted had not had a chance to actually make a presentation to them. Redacted's response is on page 3, his last paragraph. He chides Redacted and tells her that you may not dictate the dates and people you will meet with about this or any other case. If the U.S. Attorney or the First Assistant desire to meet with you, they will let you know. She, in her final response on page 1, points out that she's not trying to dictate anything. She's just asking. Are you aware that... Bear in mind you didn't see... Correct. Exhibit 3. Were you aware that Redacted very much wanted to make a presentation to you and to Redacted and Redacted about her case and her evidence? So, I don't recall this. By this you mean, I don't recall being aware of this request. All right. As a As a general matter, it seemed that there was communications going back and forth, and so she certainly felt comfortable emailing me when she wanted to. I guess is my point, rightly or wrongly. And so I wasn't aware of that request, and so are you suggesting that she could easily have emailed you and said, Alex, I really want to make a presentation to you? I'm not suggesting. What I'm suggesting is from my perspective. There was a lot of communication in this case, more than is typical. I don't recall the request, but there was communication in this case. What do you mean by communication? I mean, there are a lot of emails, but there are a lot of emails, right? But a lot of them are because there are draft. There are draft. Later on we have drafts and so on, but we don't. So what I mean by that is, I do not recall an impression that she didn't have access or wasn't being heard. To you? Correct. You've already seen 2 emails here, where she was scolded pretty seriously, and in one case for approaching, correct. Redacted, and you without Redacted being involved back when, correct. Redacted was crim chief. And then here, what Redacted says to her is quite strong, isn't it? Would you have ever used that language to a subordinate? You've seen my emails and my style. I think not. What I am saying is, from my perspective at the time, to the best of my recollection, this was not a case where she was frozen out. This was a case where there was ample communication. Mr. Redacted. Well, by Miss Redacted. Did Redacted ever tell you, hey boss, this line assistant, she's been a pain. You know, she's asked to make a presentation to you. She's asked to make a presentation to you. Do you want to do it? I don't. Look, this was 12 years ago. I don't recall it. Whether he did or not, I can't say, but I don't recall it. If he or Redacted, or even Redacted, had directly asked you for that opportunity, would you have entertained it? Would you have agreed to a presentation from the line attorney? As a general matter, if someone makes a direct, saying, this is a case that I have worked, I need to sit down and talk to you, I would have said yes. Do you recall any occasion when a line assistant on his or her own initiative came to you and made such a request and you granted it? I don't, because it rarely got to that level. From my impression and my recollection, we had pretty good communications in the office. All right, I'm sorry, Miss Redacted. That's okay. Miss Redacted. Cut you off. By Miss Redacted. You've talked about needing to respect the chain of command. Right. Would there have been any repercussions for a line assistant actually trying to approach you about this presentation? I would hope not. I think it's important for line assistants to be respectful and to, let their supervisor know. And issues, and to do it with respect and not go around supervisors. But I would hope, not. If she had raised it with a supervisor first and the supervisor said, no, that's not your place, would you have expected her to have followed what the supervisor had told her on that regard? Fair point. I'm not aware of this email. I can't speak to that. As a general matter, I would, going back to where I started, I would at 6 o'clock walk around the office and say, how are things going? What case are you working on? In part because I thought it was important to... By Miss Redacted. Did you wander up and down, up to West Palm and do that too? Less often, but yes. By Mr. Redacted. You talked a little bit about the experience of your senior staff. Right. What do you know about the experience Redacted had in handling these types of cases? When you say these types, you mean sex crimes. I can't. Cases involving children. I can't. Or child victims. I can't speak to that. I don't know. What about Redacted? I can't speak to that. Or Redacted? I can't speak to that. By Miss Redacted. But you do know that Redacted had substantial experience with child sex crimes? You named her PSA coordinator. I know that she had experience with prior cases. All right. Yeah. Okay. We're going to go for half an hour more, and then we'll take our break. And then come back. And we will get back to that other piece of the evidence and the legal issues. Right. And then we'll spend a lot of time on the alternatives. Haven't forgotten that. In June of 2007, there was a meeting that Defense Counsel requested of the sort of next level up from Redacted. In other words, they had already made a presentation to the line assistant and her supervisor. They wanted to come to Miami and talk to, in this case, Redacted and Redacted. And they did meet with them. Were you aware? Do you have a recollection of whether you were aware that was there such a meeting? So I don't have a recollection, but it rings a bell. I don't know if that distinction is a fair one. Well, I may help amplify the bell a little bit. One of the defense attorneys who was present there, in addition to Gerald Lefcourt, Roy Black, and Linian Sanchez, was Alan Dershowitz. Oh, that name comes up a lot. Yeah. Does that ring a bell? So it does. Okay. I can't say it's a recollection, but it sounds like there. It sounds right, and in my usual course, once Redetta was meeting with someone, he would typically have let me know. All right. And where would such a meeting take place? Would it be in redacted office? Was it big enough? Or would you use the executive conference room? Based on the number of people, almost definitely the executive conference room. And do people have to go by your office to get there? They do not. Okay. And would you, in a case like this, as you said a moment ago, pop your head in? Right. And say hello? Right. As a typical matter, I probably would not, because then it very rapidly turns into a meeting with me as opposed to a meeting with okay, if that makes sense. There were some written submissions also submitted. Pretty substantial ones. These addressing more of the legal issues. Both before and after this. Did someone, and if so, who, brief you about what happened at the meeting, and what was contained in the written submissions? So, I do not recall a briefing. I would assume that, again, based on practice, there's a senior level meeting in the office. Based on practice, Redatti would have told me, and then afterwards, he would have said this is what happened. All right, but you have no actual recollection of what happened in this case. I have no actual recollection of, other than the meeting sounding familiar, I have no recollection. So Exhibit 50 in this packet is almost at the end, is the next to last really, is a letter that Redacted offered to the DAG. The then DAG. Yes. In June of 2008, a whole year later. The DAG, Defense Attorney General Mark Phillip, and this is... You certainly recall that there was an appeal, if you will, a small appeal to the DAG's office. Right. By defense counsel, and Redacted submitted a fairly substantial recounting of what had gone before in the case. And he also submitted a number of other documents relative to that. He says on page 3 that at this June 27, 2007 meeting, which he characterized his arguments, legal and factual, were presented against a federal indictment, and Redacted writes that the arguments and written materials provided by the defense were examined by the STFL and rejected. Is that consistent with any understanding you have of what happened at this meeting? So, I don't recall. So I'm going to speculate. And the speculation is that by the time this happened, we were fairly far along in how we were viewing this matter. This being 2008 or... No, June. June 27, 2007. Okay. And as I reviewed the documents, I tried to establish a timeline. But clearly, by July 31st, we had sort of concluded how we were approaching it. And so I'm going to speculate that when he said the arguments and written materials provided to defense counsel were examined by the STFL and rejected, it was they asking us to drop the matter. And we said, we're not dropping the matter. Okay. And by the way, just to clean this up, this letter was to the DAG, was signed by Redacted under your type name, as is, right. Standard, but you're not CC'd on it. Do you recall why you didn't sign this letter? Why was it sent by Redacted? Redacted? I do not recall. That's a point of interest, and so I'll draw your attention to, alright, Exhibit 49, which is actually dated the day prior, that is, June 2nd, 2008, and this is an email to you from Redacted, who was and is the ethics, yes, officer for the U.S. Attorney's Office, correct? Reporting back to you an assessment by the Executive Office of U.S. Attorneys General Counsel's Office that they did not see you as having an either actual or apparent conflict of interest that would necessitate your recusal from the Epstein matter by virtue of the fact that you according to this, intended to seek employment with Harvard Law School. Right, or was considering seeking. Was considering, alright. Right. Should you seek employment, it says. So, is it reasonable for us to infer that this potential recusal, right, was pending at the time the letter to Mark Phillip was being drafted, and that's why it went out over a redacted signature, and without you as a CC. So I would not infer that. Okay. In part because it was potential, and in part because Redacted had the facts at his disposal, and was the natural... This was a very detailed letter. I do not feel that... I'm speculating here. As a general matter, things don't have to go out under my name, and some letters went out under his name. And some letters went out under my name, and the ones that went out under my name tended to be ones that I had more authorship in. And the ones that went out under his name, in this case, were the ones that he had more authorship in. And so I would just say that this was the continuing course of that. Okay, thank you. Minor technical issue. By Ms. Redacted. Would you have read the letter before it went out? Probably. I would say in my usual course he would have shown it to me, but not always. Not always letters that would have been sent to the Deputy Attorney General's office, or just letters in general. Well, he would have. I think he would have shown this to me because it's going to the Deputy's office. The flip side is I trust Redacted. I think he's a professional. So, an important distinction to draw. I remember talking to a Orsa that has spent time at Main Justice, and contrasting the experience of an Orsa with the experience of a trial lawyer here, and sort of the line was, you can't send a letter from Main Justice without 3 letters of approval, whereas an Orsa in their case typically doesn't even get approval from their line supervisor. And so as a usual matter, particularly in this case, Redacted would run letters by me. That doesn't mean that every letter had to be run by me, and I was certainly aware that the letter was being transmitted. I was aware of the appeal to DC. I comforted him what we had done, and so I thought the appeal would be fine, and if I was out of the office, or if there was some reason that I wasn't going to be consulted, Redacted was quite capable of doing it without my review. I did. This, and is there anything in it that in your view is not accurate? I think is accurate. I think the letter, as it should be, is a advocacy piece for what the office had done as opposed to on the other hand, an analysis piece. But at this point we're defending the actions of the office, and I think it appropriately should be an advocacy piece. Hello, Clara. Alright. Do you disagree with any of the points of advocacy, or the points made in advocacy? Clara, you're in the way of my piece of my... Okay. She's standing right in front of my monitor. Oh no, she's lying down. There's a good girl. They've been mostly good. They've been chilling out and sleeping most of the time. So I'm going to try and get to page 200, ideally. I can feel my voice break. I reckon I can keep going for a little bit. I feel my voice breaking, and because I want to enjoy my weekend a little bit, and so I want to get a good night's sleep. And I need to do a little bit of last tinkering work behind the scenes of a few videos. So I'll carry on from this, line 19. All right. Oh no, hang on. Yes, okay. All right. Do you disagree with any of the points of advocacy, or the points made in advocacy? We'd have to go through it. All right, paragraph by paragraph. Okay. But nothing struck you so much that you, I think, recall? I think he fairly presented the totality of everything to the DAG, or DAG, for the DAG to review her for whoever the DAG designated, and I think that was an appropriate presentation. All right, thank you. So now I'd like to launch into, and before we break for lunch, sort of the core question, which we addressed a little bit earlier, and that is, who at the U.S. Attorney's Office made the decision to resolve this case with an offer of a 2-year state plea, and why? Right. So how we got to the 2 years, I can't tell you, because I can give you my general impression. Ultimately, all the cases in the U.S. Attorney's Office were under me. Ultimately, I saw what we will call that, 3-pronged resolution. 2 years, registration and restitution, and ultimately that was approved on my authority. So, who came? Did you come up with it? Was it your idea? Of an issue? I don't know. This is reconstructing conversations. I'm going to speculate now. This was not... Let's all get in a room and figure out the resolution in the next half hour. But this was, of course, as things are discussed, and there's a back and forth over the course of some days for a week or two, and then people get together and discuss, and a view develops, and then the office proceeds with that. But ultimately, let me just sort of push back. Look, ultimately, I approved it, and so okay, accept that. I'm not pushing away responsibility for it. I'm just saying I can't recall how we got to, for example, 2 years. I can speculate as to particular parts of it, but I can't, but ultimately I'm not pushing away responsibility. I understand, and we're going to delve into that. Right. That 2 years. Shortly. But I want to turn back to exhibit number 3, in which sort of the statement that launches this, what I keep calling a lively exchange, is on page 4, the statement from Redacted, and this is in response to an inquiry from Redacted to her management, not including you, about what conversations any of them has had with defense counsel. Right. About any resolution, because her plan was to talk to Lilian Sanchez about working a plea to federal time concurrent to the state, whatever the state time was. And in response, Redacted tells her, I told Lily that her state plea with jail time and sex offender status may satisfy the USA, meaning the U.S. Attorney. Right. I believe. So that's a close quote after USA. Okay. Had he discussed that with you? How did he know that that might satisfy you? So, I don't recall. I can speculate based on Mr. Redacted's course of conduct. I don't think he would have raised that possibility in case of this profile without having discussed it with me. But you have no specific... I have no recollection? Specific recollection, but I don't think he would have done that without having come by and said. Alright. At this point, bearing in mind that you don't have any specific recollection, at this point, do you believe you had any understanding of what amount of jail time was in play at this point when Redacted tells Lilian Sanchez? I can't pinpoint that timeline. Alright, to that degree. Alright, of accuracy. Okay, he also says later in this email that he told this to Lilian Sanchez a couple of weeks prior before the June 26th meeting. Correct. Alright. Were you aware that Redacted had been communicating directly with Sanchez about the case, and specifically that he represented that you might go for a state disposition if it included jail time and sex offender registration? I don't recall whether I was aware or not. I recall at some point adopting the concept of jail time plus registration, and then plus restitution. And so I don't know when that would have happened. Let me also speculate that the US attorney might go, could also refer to, this is being talked about, no final decision has been made. Right. If Redacted had made that informal discussion comment to Lilian Sanchez without having told you, without having gotten your clearance ahead of time to tell her that, would that surprise you? Or would you have expected him to consult with you about whether it was okay to go ahead and raise this? So, as a general matter, yes, but... And let me explain that. Also, on occasion, and because this is a higher profile case, a criminal chief may run an idea across opposing counsel and say, look, I don't have authorization. I don't know how the office will react, but it's certainly possible that X, Y, or Z may work out, and that's a very different conversation than, the office will accept. And so a lot of that really depends on how that conversation goes, and, certainly if he's representing my view. I would expect him to check on what my view is, and he's, as criminal chief, saying, this is something that I could support. I don't know how the office will react, that may, but I can run it up the flagpole. That might be a different type of conversation. Hello, Dexter. Okay, and did you know Lilian Sanchez? I did. She was an author in the office. And she left about a month after you came on board. Was it that quick? That's our information, yes. Okay. Although she apparently remained a periodic present. Hence, the wasn't that quick. Did you know that she'd been Redacted deputy at major crimes? I don't remember that. Alright. What did you remember about that? Dexter, don't attack my mic. What did you remember about her? And had you had any dealings with her after she left the office up to this point? So I remember that she was in the office, that she was a senior attorney. Whether within the management structure or not, I didn't recollect until you just raised it, and that I can't swear to it, but it rings a bell that she was in major crimes, and she was someone that you would see at bar functions that would... She was active in the local bar, and I would see her on occasion at a bar function and say hello. Alright. Did you encounter her in connection with a case? Stop attacking my mic. To your recollection, in the period before Epstein? I'm hesitating not to avoid, but I'm running through my... Not that I recall. What's your impression of her as a practitioner? She did quite well after she left the office. I think she set up her own practice. At this time, she was with something called Fowler White Burnett. Okay, so she went to Fowler White. Subsequently, she set up her own practice, and I thought she'd done well for herself. Okay. Were you aware that Redacted had a close personal relationship with Lilian Sanchez? Both because they had worked together as chief and deputy chief? In major crimes, but also because they'd had a dating relationship sometime prior. I don't recall them having dated, but I don't... Do you recall knowing that they had dated in the past? I don't recall knowing that, and in all candor, that's not the kind of thing I ask about. But in this case, with her representation of somebody in a matter being ultimately supervised by Redacted, would you have expected Redacted to disclose to you that he'd had a prior romantic relationship with Lilian Sanchez, a member of Epstein's defense team, if only to address a potential appearance of impropriety or conflict of interest? I think some of that might have depended on how recently. Was it 10 years ago? Was it 2 years ago? If they were in the supervisory chain that this happened, that could raise other issues. So for example, Redacted disclosed to me a potential conflict. To the extent that these arise, If there is a potential conflict, I'd like to know. I was aware of redacted conflict. I said, keep going. And in fact, redacted, you're talking about the Herman, yes. Connection. The prior, yes. Short-lived law firm connection. Are you aware that redacted, in fact, vetted that through redacted, your ethics person? I am. I don't recall that independently, but I recall knowing about it. He may have told me he vetted it through redacted. Redacted is highly respected in the office, and that would be the appropriate. So, are you also aware that redacted raised, again with redacted, the potential, again, appearance of a conflict of interest, or appearance of impropriety? Because of his supervision of the Epstein case and his concurrent close relationship with Mike Tyne, who was an attorney who was representing Epstein, as well as Guy Lewis, a former US attorney. So, I was not aware of that. You were not aware of it, but I guess what I'm noting is that both redacted and redacted perceived appearance issues. I went through the process that's provided for them to get the blessing to go ahead and proceed with the case by the blessing by the ethics expert. Right. But redacted apparently did not in this case via vis-a-vis Lily Ann Sanchez. Yeah. Does that surprise you or disappoint you or perplex you or do you care? I would want to know more. Right. But certainly it would provide... I want to know more before saying I'm disappointed, but again, was it 10 years ago? Was it 2 years ago? What's the continuing... There are a lot of facts, but certainly it's the kind of discussion one would typically have with redacted. And in this case, what we're talking about is an informal conversation, or informal discussion, to use redacted's own term, with Sanchez, as opposed to any of the other attorneys in Epstein's team, about a particular resolution that we're going to spend all afternoon talking about, because it has some problematic aspects. Okay? So, you see why I get it. No, I get it. Okay. By Mr. Redacted. So before we break, should you have talked about this potential resolution with the line assistant before actually making it? In a typical case, yes. So in a typical case, I foster communication. I get involved in cases, but we want to know what the line assistant thinks. And they can agree or disagree, but we want input. By Miss Redacted. What do you make of this reality acid tone between redacted and redacted? Really acid tone between redacted and redacted? Between redacted and redacted in his Exhibit 3 exchange. I mean, redacted is really, as I read it, is pretty strong. I'm not sure what to make of it. Alright. There are a couple of... can we go off the record for a split second? Off the record. By Miss Redacted. Okay, back on the record. Going back to Exhibit number 3, there are a few things here that we think are important to raise with you, albeit you not having seen this at the time. Redacted says that she complains about this soft, that's my term, plea offer that Redacted extended to Epstein through Lilian Sanchez. She says that such an offer is completely unacceptable to the FBI, ICE, the victims, and me, meaning Redacted. Did you have an understanding of what the FBI's position about prosecuting this case was? My recollection of interaction with the FBI is with Redacted, who was the SAC, and as I recall, he supported the eventual direction of this case. Is he the individual who you identify, I believe in actually your attorney's written response as the SAC who called you to congratulate you about the case? About the result? Yes. And was SAC redacted? In that same written response from your attorney, there's a mention that he was present at many meetings on this case. He was present at least some, and in part, that was at my request, because this was a high enough profile case that I wanted to bring him into this. So, we know he was present at the December 14th, 2007 meeting, right? Yeah. With Ken Starr and company. He is not present according to our investigation, at any other case with defense counsel. Others are. His ASAC, redacted, is present. So, recollections aren't nearly as good as documents. I don't recall the December meeting. I would have said that he was present at the September meeting, but it may be that I am, because this was so long ago, mixing the two. Okay. Because I thought he would have come to the September meeting. No, according to all the information we have, just so you know, right. Redacted was there as ASAC, but not... Actually, I'm not sure she was at any rate, she was... Right. He was present. Redacted was present at the December meeting only. Right. So, just so fair. Okay. Would he have been present at meetings other than with defense counsel meetings about this case? Typically, no. Typically, he and I would have talked on the phone or had discussion, and I know that he was aware of the matter. So, I recall he's been aware of the matter and generally positive as to the direction that we were going. By the direction of the eventual outcome? The eventual outcome. Alright, so what about the prosecution? Do you know what the FBI's view was about the prosecution? I can't speak to the timeline. I would have, and I'm contradicting the documents here, but I would have, if you had asked me, he said he was present at the September meeting, and was aware of the terms that were presented at the September meeting. Clearly I'm right. My recollection is incorrect, and I take that for what it is. Just to finish on, with this point, though, my question was an understanding of the FBI's position of the case, not the ultimate disposition. In other words, as of the date of Exhibit 3, there was no deal on the table. So the question is, what was the FBI's view about the case? So I'm not trying to be difficult. At some point, when you say view, the FBI, to my recollection, thought that what Mr. Epstein did was sordid and disgusting, and that we should proceed. How we proceeded, I don't recall hearing specific views as to the how, as opposed to the we should. Alright, thank you. Let's take a break. 45 minutes. Thank you. Off the record. By misredacted. Alright, we're going to go back on the record. We're beginning after the break at 1:30 in the afternoon. Thank you. Before we get started, yes. You referenced an email from Redacted that wasn't part of the packet. Correct. Is that something that I could see and review, or is there discomfort on that? Yes. No, I am not. As long as we make it on the record. Do you need to do it now, or can we do it during the next break? It depends how long. How long is it? It would just take 1 page. A minute, if you don't mind. Do you want to go off the record while Mr. Acosta... Off the record. By misredacted. Alright, on the record again. For the record, Mr. Acosta has just reviewed an email from redacted to redacted. Redacted and redacted. Dated July 18, 2007 at 2:07 p.m. It is one that I described to Mr. Acosta a moment this morning. Do you have any comments? I don't. Alright. Before we broke, I mentioned your statement about SAC Redacted having attended many meetings. That, to be clear, was a representation you made in your March 2007 letter to the Daily Beast, not the written response. Looking briefly back at Exhibit 3 and Redacted, you don't have to read it yourself. Redacted representation that, in her view, the plea offer was completely unacceptable to the victims. Do you believe that she was correct in her view that the victims' views should have been solicited before a plea offer was made? So I would have to think that was one through. That was one through? Okay. There were concerns, and I don't know about the timeline about communications with the victims. They're sort of laid out in the redacted affidavit. So whether or not victims' views were elicited is something I think was the focus of the trial team, and not something that I was focused on, at least at this time. But do you believe, as a matter of sort of principle, that the views of victims should be elicited before a plea offer? Right. Is made. So as a general matter, yes. Okay. I think that the reason I'm pushing back is because you're saying plea offer, and the CVRA does talk to plea offers, as opposed to a situation where deferring prosecution in favour of a state is a very different thing than a plea offer, and at the time, that was not it must. That was depending on the facts and circumstances. That's a judgment call. At least that's how the department, to my understanding, viewed it. And was it also your view that it would have, as a general matter, is a better practice or better approach to talk to the victims before? As a general practice, yes. Alright. Do you think that would have been particularly important in this case, where the proposal involved sending the case back to the state, which the victims were aware had already mishandled the case to begin with? So, there are a few things in that question that I think are packed. Whether the victims were aware and were of the view, from my perspective and my recollection, were of the view that the state had mishandled the case, I can't speak to. Some of the victims were, to my recollection, exonerating him. There was concern that some of the victims were more on his side than on the prosecution side. And so, that judgment call of which victims are notified, and how much I think is something that really is a judgment call that needs to be done, almost on a case-by-case basis by individuals that are aware of sort of the facts and circumstances surrounding each victim. In a general case, you want to have fulsome communication. I can understand in cases where victims might be giving exonerating information where, or there is restitution at stake, that could be different. And by the people involved, are you talking at the trial team level? At the trial team level, with whatever appropriate supervisors are engaged in the victim notification issues. And in this case, that would not include you, is that correct? That I don't recall cases where I became part of the victim notification judgments. By misredacted. Did you ever issue an instruction to the trial team that they should not consult with the victims before the MPA was signed? So, not that I recall. I know that there's some instances where after the MPA was signed, I said, I'm directing that we withhold notification for 5 days, or X period of time to work this out. But before the MPA was signed, I don't recall, in all candor, I don't recall discussions about victim notification until after the MPA was signed. I don't know if there's email traffic before the MPA was signed, but I don't recall victim notification issues until after the MPA was signed. Okay. By Mr. Redacted. And one more question on this topic is that prior to... We interviewed other people, obviously, in this case. And we interviewed Ms. Redacted, and one of the things that she told us, she has a recall of a meeting with you present, Mr. Redacted, and Mr. Redacted, where this issue of victim notification was discussed in the time frame of prior to the FBI, and at that meeting she was specifically instructed that we are not going to talk about it with the victims. Do you recall that meeting? I don't recall. If that's her recollection, that's her recollection. I don't recall that. I recall knowing that there were issues around victim notification. I recall, particularly after the MPA was signed, I recall efforts, I believe, to notify as it was being signed, to notify the victims of the upcoming state plea. And I recall discussions, if not discussions, let me not say discussions, a general concern about the victim notification. What does that do? Because the victim is also a witness, and a potential witness, and in some cases, an adverse witness. And so, how does all that balance out? Okay, well, we're going to drill down into those. Right. Both MPA issues later on. Right. Sorry, cats are running around in the background. Just now focusing on, right, pre-MPA, before it's signed, when the negotiations are going back and forth. Right. You have memory of this topic coming up. I don't recall discussing the victim notification issues. Okay. What would your response be, though, to... Are you aware of the CVRA litigation that went on? Yes. From Judge Mara? Yes. So one of the issues that comes up in Judge Mara's decision is he made a finding that the government violated the CVRA because they didn't consult with the victims. Right. Prior to signing the MPA, and there was a perception, or from his opinion, that the government did this, failed to communicate that in order to eventually keep the victims in the dark and protect the resolution. Why is that an incorrect assumption? And so I would say that Redacted sets out her reasoning in her affidavit. She talks about, by Ms. Redacted. Are you referring to her 2017 affidavit? Her 2017 affidavit. She talks about, I believe she notified at least some victims and it became an issue. And there's concern, when you have this MPA. Whether or not the MPA will ultimately remain is a very open question, because from our office's expectations, we expected him to plead shortly after that, and he did not. And so, are we going to trial, or are we not, is a very open question. And I think there has to be discretion, where there is no legal requirement. There has to be discretion to judge how much you can tell the victims and when. By Mr. Redacted. Okay, just one other point, and this is that we've reviewed, Ms. Redacted's declaration and the notifications that she's referring to there. Those discussions take place after the signing of the MPA. So, we're just talking about here still, right, just the pre-MPA, pre-signing of that. So, does that change your answer at all? Again, I don't recall the victim notification being issued before the MPA. I recall a lot of discussions afterwards. I don't recall. That doesn't mean they didn't happen. That just means I don't recall them. Was there any concern with you, or among any of the other people involved in this negotiation phase, that if the victims were to find out that we are negotiating this MPA, that it will blow up the MPA? That it will cause us trouble in some way? My focus before the MPA was signed was, here are these teams, and then for the team, go negotiate this. And so from my perspective, it was much more of a, what are the terms, than the victim notification issues around that. By Misredacted. Right, but just to follow up. Right. Did you hear any discussion amongst the people that you were dealing with? That they were afraid that the victims might raise such objections, or go to the press, that this whole thing would be, come to a halt. So I tried to think. I don't recall. I believe we notified the victims in advance of the state hearing, so that they would be aware. We didn't notify them before we signed the MPA, to my recollection, but we certainly notified them of the state hearing. And so I was aware generally of what was being done, but the MPA and the MPA was the focus, not the victim notification. When part of that. When you talk about... Go ahead.
We're going to get into that plea.
Right. And what we're...
All right.
Right. A little bit later on.
Right.
By Mr. Redacted. Just one. Can I just direct you to...
Yeah.
Document number 15.
Mr. Redacted. Exhibit 15?
Yeah. By Mr. Redacted. Okay, so do you... There was an email that is from Ms. Redacted to Redacted, then forwarded to you.
Yeah.
Do you see the reference in there where she mentions that she spoke to Redacted, or Redacted reminded her, where is it?
Ms. Redacted. It's in the second paragraph.
Yeah, no, I...
Ms. Redacted. In the middle. I see it.
The middle.
It's highlighted.
By Mr. Redacted. Could you just read that? The agents and I have not reached out to the victims to get their approval, which, as Redacted politely reminded me, is required under the law. Do you recall that email?
I don't recall this specific email. My recollection is a view that there is no requirement to notify because it's not a plea. It's deferring in favor of a state prosecution. And therefore, it becomes a discretionary issue. And what notification is appropriate is really a function of how you interact with victims who are also potential witnesses. And I was aware, I support what the office did. I'm not backing away from it. I'm just saying I can't, 12 years later, reconstruct what the thought process was, other than there was no legal obligation. It was a discretionary issue, and this is how the discretion was exercised.
But do you remember? So, there's two things. Do you remember any discussions coming up about the topic of what we have to do as far as notification in the pre-MPA negotiations?
I really don't. I know there was a lot of discussions after the MPA. I don't recall pre-MPA discussions on this.
Last question on this.
Sure. Mr. Redacted. By him.
The witness. Yeah. By Mr. Redacted. You're getting at least forwarded to you an email from the trial attorney in the case showing that she is concerned about the notification issue, and she's raising at least referencing the head of, right, CEOs about this issue. Did this ring any bells to you? Raise any...
So from this, I would infer that a discussion was had as to what the obligations were, and whether we had to or not, because... So I think it's fair to infer she is, emailing my first assistant. I don't know what the attachment here... Oh, the attachment here is the term sheet, so to speak, and my first assistant is forwarding it to me in large part so that I get the attachment. And I think from here, it's fair to infer that some conversation or discussion was had. I don't remember the conversation or discussion. My focus was on the terms. I'm willing to accept that the conversation was had. My recollection of the obligations under the CVRA is that they did not attach, because this was not an indictment, it was not a plea, and that it was entirely discretionary how we proceeded, and therefore how you proceed is a function of should you notify victims. Yes, but there are concerns because they're also witnesses. There are concerns because we are going out of our way to provide for restitution, and all of that played into a complex calculus.
That was it.
By Ms. Redacted. So you said that there was a view that there's no requirement to notify the victims. Who was that view coming from? I can't speak to person A, B, or C. I can say that if the office thought there was a legal obligation, there are too many professionals involved in this, that if they thought there was a legal obligation to notify, they would have done so. At some point in this process, whether it was pre or post, I know that there was some explicit consideration of what are the obligations and some discussion of this is not the obligations don't attach into indictment and therefore this is a discretionary matter. Whether that happened in September or in August or October I can't speak to, but I know that was talked about, and I think later on in the record there's an email from our appellate chief in a different case that highlights, well, there is this Texas case that just ruled the other way. So clearly, it's an issue that had been talked about, and I recall it being talked about. I just can't tell you the when or with who. And would there have been... You've spoken on one concern. Right. Concerning impeachment of the victims regarding their, financial aspect of the MPA. Would there have been any downside to consulting with the victims concerning, hey, the US Attorney's Office is considering a restitution short of a plea that involves charges in state court? How do you feel about that, victims? So there may not have been a downside. It's difficult to recreate. My understanding, going back 12 years, was that the victims would be aware of what was happening at the state court and have an opportunity to speak up at the state court hearing. And where does this come from? So my understanding is that when he was going to go into state court, that they would have been notified that there was an all-encompassing plea. That state court sentence would also mean that the federal government was not proceeding. But again, in terms of before... Your point is before it was signed. Correct. So that they could have input. Right. Into trying, perhaps, if they wanted to persuade you that, right, was not a good idea. It may have. It may have been a... Look, looking back on it, it may have been a very good idea. I can't speak to what the thought process was then, other than it was discretionary and it was not legally required. But at least as we sit here today, you cannot recall a particular problem that somebody brought up to you and said, we should not consult because of this problem. I don't recall that, and clearly, given the way it's played out, it may have been much better if we had. By misredacted. In the last 15 or, 20 minutes, you've several times referred to discussions and we. Right. I want to make it clear that so far, the people who were involved in this case, the Epstein case in your shop were you, redacted, and redacted. Is there anyone else who was involved in those discussions other than those 5? Not to my recollection at this phase. Okay, I just want to make sure. Yes. We understand who was encompassed, right, in that general discussion, right, of the matter. Okay. So on July 26th, so we're now a month after that presentation by the defense counsel to the team, including redacted and redacted. Correct. There was a meeting in Miami, and it was, again, among redacted by telephone, redacted, as well as the 2 case agents. Redacted and redacted. Did you know them, by the way? I did not to my recollection. Okay, and also their supervisor, redacted. Did you know redacted? Somewhat. Alright. And they were all in West Palm, of course. Yeah. And then Asak, redacted? Yeah. Do you recall her? Somewhat. Alright, they arrived, or at least the trial team. The investigative team arrived ostensibly to discuss the case. It turned out to be a very brief meeting, essentially consisting of redacted coming in, announcing that you had decided on a 2-year state resolution, and then essentially leaving without... That is, redacted left the meeting without discussion. This has been described to us as stunning to the investigative team. They had no idea this was coming. They were completely blindsided. The question is, were you aware that redacted was going to announce that you had decided on this resolution? So I don't recall that, but I decided and endorsed this resolution at some point. And so the fact that I don't recall doesn't mean that I wasn't at the meeting. I don't recall. But I clearly had endorsed this resolution, and so, his announcement would have been consistent with my decision. And again, that decision was reached without consultation and discussion with an input from the line also. Does that trouble you? Sitting here today, I wouldn't have said that there was no input from the author. So, to the extent that she felt there was no consultation or input, that would. From my perspective, trying to recreate things from 12 years ago, there have been discussions and consultations, and she has spoken with redacted, and it would have been my guess that views were known and articulated, and there was good communication back and forth. But again, that's your expectation of your people. Is that correct? Correct. Okay. So, and also from our interview, it's our understanding that you popped your head into that meeting and said hello to the folks. Okay. Gathered. Do you have any, recollection of that? I don't remember the meeting. Alright. I may have done that. And it's not, right, completely uncharacteristic of you. Right. Okay. It's not. Alright. No, because that was an internal meeting. That wasn't right, or correct, as opposed to the, scenario we were discussing this morning. Alright. This deal, and we're not talking about, the term sheet yet. 2 major prongs we want to talk about. 1. The first one is for going federal prosecution, right? Going for a state-only disposition. And I talked to you this morning about the 5 ways a case could proceed when it comes from the state. You can either decline it and give it back to the state. You can go ahead and indict, but let the defendant or defendants go to trial or plead to the indictment. You can indict, negotiate a deal, although you talked about some of the issues there. And you can also file a complaint and negotiate pre-indictment or negotiate something. Right. So why was it that all of those other options were rejected and the state-only deal was settled on? So let me back up a minute, because I think it was a little more fluid. The way the matter came to the office was the state wasn't doing enough. It didn't provide for prison time. It didn't provide for registration. And then you had the restitution issue. There were legal issues, which I'm sure we'll talk about. There were witness issues, and we could go to trial, potentially, and we may or may not prevail. Alternatively, we could look at a pre-indictment resolution, and at various points, the office went back and forth between a federal pre-indictment resolution and a state pre-indictment resolution. I think you showed me an exhibit where redacted said a 371 with Rule 11. There was some discussion of other statutes at some point. I don't recall the timeline. And so ultimately, the focus was as an initial matter. How do we get to this resolution with some flexibility for state versus federal? There was a preference for deferring to the state. Where does that come from? What? In part because the legal issues are to some extent also present in a federal resolution, because that then becomes a precedent for other similarly situated cases. Did you want to avoid a precedent? So, should we talk about the legal issues? Because we say we keep coming back to the legal issues, but alright, talk about the legal issues. So when I was at Civil Rights, one of the areas of responsibility that I had was trafficking. I was very supportive. We set up some of the first human trafficking task forces. I thought Civil Rights really became aggressive. I think Redacted was one of the point people. We brought in Redacted to be a point person on human trafficking. One of the background issues that informed the time and all those prosecutions and also the development of the trafficking law was what is the distinction between trafficking and solicitation, and what is the distinction between a truly federal case and a local case? Because there was a lot of concern at the time about federalizing something that is traditionally local. Now, that was 12 years ago, and I think that those concerns are no longer in play today, nearly, and certainly not to the extent that they were 12 years ago. This was the state of play at the time you were the AAG for... Hello, Dexter. At the AAG and afterwards, as I was US Attorney to some extent, there was a lot of discussions about federalizing state issues generally, and certainly in the legislative issues that went back and forth. That was a consideration. Wasn't that trend very swift as of... Was it '06 when the Adam Walsh Act was enacted? So sure, I think we're treading in a certain direction. Alright. And I think that trend has continued and accelerated, but these were valid, in my opinion, considerations at the time. And one question to be considered is, how would a court look at this? Because different judges may look at these statutes differently, and how would a court consider federal nexus issues? And so, that was, to my mind, an important consideration, because this was, at the time, to some extent, uncharted territory. And while we might prevail, and probably would prevail, we may not have. And how is that weighed against a certain plea with registration that would make sure that the public knew that this person was a sex offender? Okay, a couple of things. One, did you engage in that discussion based on your experience with Redacted? Did you engage in that kind of conversation? I don't recall who I may have talked to, but this was when you will see in the record reference to legal issues. These were the legal issues, at least in my mind, but that's referring to. But did you sit... I mean, not to be silly about it, but... Right. Did you sit in your office and ponder them, or did you in the context of we would have discussed them? Alright, we being you and I, and whether it's redacted, I wouldn't have sat and pondered them on my own, but we would have had some level of discussion about these. So conversely, is it your understanding that those three guys understood from you at least your perspective on these legal issues? Let me push back. Those three professionals, because they are... Oh, yeah, I'm sorry. Well, in this context, it's colleagues, yes. Yeah. So there were two large buckets of issues. One was the witness issues, and on those I would have deferred more to folks that are experienced trial prosecutors. The other one are these legal issues. And you see it with the Fed, with the reference at the very beginning to the federal nexus. And you see it throughout where these were discussions that we had, and from the very beginning, what is the federal nexus, and how do we make it clear that we are not stepping on something that is a purely local matter? Because we don't want bad precedent for the sake of the larger human trafficking issue. Did you have those conversations with your three subordinate colleagues in this case? I would have had those conversations with those colleagues. Whether it was with all three, or with two, I can't recall. But I would have had those conversations. And do you recall whether anyone among them pushed back, as, for example, Redacted indicated his view on some of those issues? So I don't recall specific pushback. I can say where we concluded, which is there, we are comfortable enough with the law to believe that if we need to go to court, we can do so ethically, and we have a good chance of winning. Because if we could not go forward, of course, then we just can't go forward, right? No matter what outcome you want. Was it a slam dunk? Was there some legal risk? Yes, there was some legal risk. Mr. Acosta, you used the term a roll of the dice in your press conference. Yes. There's a different... I mean, at one end you have a slam dunk. I will submit that no criminal prosecution, right, is a slam dunk. Correct. Likewise, I would ask you to commit on whether any prosecution is really a roll of the dice, given that a prosecuting authority, in this case the US Attorney's Office, will have always done investigation, persuaded at least a majority of grand jurors that there is sufficient proof to bring an indictment. Right. And so on. Would you still hang your hat on a roll of the dice hook? So, I don't know if I would use that exact phrase. Alright. But let me just say, because you prodding grand jurors. From our perspective, sitting in the office in 2006 and 2007, this is a case that someone comes to you and says, this has been presented, we have no reason to believe the state attorney acted, we're not happy with what they did, but we have no reason to believe that there was funny business. Misconduct? Misconduct. Alright. And let's assume that there is no misconduct, because you don't want to assume that again still. So the state attorney took this, reviewed it, presented it to a grand jury, and the grand jury came out with this kind of recommendation. That at least is indicative of some other authority looking at this and making a judgment as to what it looks like. Are you aware that at least at the investigative and line assistant level, they had understanding and reason to believe that the state prosecutors had put in witnesses into their grand jury and set about impeaching them? I'm not right. Suggesting that this is misconduct, but it's a way of approaching evidence before a grand jury. And if they did that, it would be perhaps charitably for the purpose of making it abundantly clear to the grand jurors how the witness would fare, right, or not fare under aggressive cross-examination at a trial and so on, right. So, were you aware of that at the time? I was not. Right. Oh. You were not. Right. Okay, there we are. You were not aware that there was an actual concern and understanding that there was, by your team, that there was a concern that they basically tanked the case. Tanked. Yes. So there was... You didn't know that. I was aware of a concern about how the state attorney, how aggressive they were. Right. There's a distance between how aggressive they were versus tanking the case. Right. But I am telling you the concern by your people at the ground level. Right. Was the latter. Understood. Okay. Aware of lack of aggression, tanking the case, very specifically. I mean, there might have been, hey, this looks really good, or really odd, but you've given a level of granularity as to highly unusual conduct. So, my point, there is at least a perspective coming out of the state. There are legal concerns. We believed, at the end of the day, I thought we would prevail, but they're valid, and then you overlay that with witness concerns, and concerns as to how jurors, which were different in 2006 on these issues. What do you base that on, by the way? It's because you're not a trial attorney anymore. So experience with how juries in South Florida looked at these matters, and with how South Florida looked at the Project Safe Neighborhood. It's childhood. Project Safe Childhood run initiative generally, and so there have been prior instances where we have talked about this and we have gotten some pushback from within the office or within the FBI, or from within the FBI. Sorry. On what? On sort of sex cases more generally. And pushback in what regard? Where should we put our resources? And so there was just general pushback. Okay, but there are a couple of things there. One is the petite juries, and which, right, I still like the answer on, yeah. And then the other is the FBI being loath to muck around with these cases that they were not, yet. So, engage with. So let's take them one at a time, and in all candor, I think we're looking at this through a 2019 lens. At the time, and I've said this in different forms, but Weinstein was known and about, and actions weren't taken, and Bill Cosby was known about, and they're each, go with me, they're each different, alright. But I do think the public looked at these cases differently in 2006, and there are at least some individuals, I'm not saying it was the right view, but there are at least some individuals who would have looked and said, this is a solicitation case, not a trafficking case. Alright, who in your office, who in the US Attorney's Office ever said that? So this came up in the context of how would the victims do in court? And it wasn't just, how would they be impeached, but how would jurors look at the fact patterns around this generally? And who was talking? I can't say. I know that it was discussed. I can't say A, B, C, or D. Well, it wouldn't have been D, because D would be redacted, and I think you would agree with me that she would not, I would agree, concede that. I would agree with you. Alright. With that, but my point is that when we're talking... So, when you're looking at victims in court today, I think it's fair to say that the way we approach, there's been a lot of changes in victim shaming, and the degree to which all of that is permitted. The degree to which I think the public understands that girls, minor females, may be scared and may testify differently. And I'm suggesting that it's important to sort of think back to 2006, and understand that these issues may have been viewed differently. You have not, since leaving the US Attorney's Office, been engaged in the investigation and prosecution of handling or handling in any respect of child sex crimes. Is that correct? That is correct. So, on what do you base this? Is it your cultural observation? Your perspective on the evolution of popular culture, not in a derogatory way, that leads you to that assessment? So, on a view, certainly the law has changed, and the law has become much more aggressive. So, for example, I believe the law on proof of age has changed, where proof of age is no longer required. The law has, but the case law even at this time was already what was reasonably clear on that. Was reasonably clear, and certainly moving in that direction. Correct. Wouldn't you have wanted to be at the forefront of this? So I believe I was at the forefront of trafficking issues, and I think if you were to look at my civil rights record, I really was at the forefront of trafficking issues. Even the US Attorney's Office had a very robust, as we discern it now, a very robust initiative. It maybe wasn't a formal initiative, but commitment to prosecute these cases. Correct, and I fully supported that. All the more reason why, if there is an issue, and there is a potential for some judge, rightly or wrongly, whether I agree or not, because you can't always predict, even though you think you'll prevail, you can't always predict where holdings go. Are you talking about on appeal, or in trial to issue a negative precedent on travel for purpose of, or on federal nexus? And if you think back at the time, on appeal, there's a lot of case law on commerce clause and federal nexus. Right. And so, I think that is an important and valid factor that goes into the decision-making that assess the risk of trial, not just from how the victims will testify in this particular case, but also what this means to the greater effort. I understand that completely. What I am not hearing is where a voice other than you and your team in this case has been heard. Like Redacted. Did you and talk to him about these issues? Because not CEOs, not to. Was at the forefront of, not to my recollection. Alright, wouldn't...
Mr. Todd, let Redacted finish her questions.
The witness. Okay, sorry. Ms. Redacted. We're all... The witness. I apologize. Ms. Redacted. We're on a mutual role here. The witness. Okay, by Ms. Redacted. But if you had those concerns, perfectly well-founded, why not reach out and engage with CEOs and see what their assessment was about the vulnerability that this case might expose your office to? So I can't reconstruct that 12 years later. One interesting question is, would CEOs have come to mind versus civil rights crim? Because coming from civil rights crim, my primary trafficking contacts would have been, did you pick up the phone and not call them? Not to my recollection. So I guess what I'm getting at is you, based on substantial experience and a commitment to these cases in your office, the US Attorney's Office, have formed your own analytical analysis, your own analysis legally. You've told us you've discussed this or made those issues and concerns known to the people who were below you, at least immediately below you, and that's where it is sort of rested. There was not an effort to go out and enhance or add to your understanding of the case and legal issues. So to my recollection, I don't recall, and we'll get into perhaps, from my impression, I actually thought I was being more aggressive than main justice would feel comfortable with, and more aggressive in what respect? In my interpretation, and how comfortable I was going forward with that main justice, and we can get into that, but I thought I was being more aggressive, not less, and so I had these concerns. I did not vet them at main justice. Okay. When you said more aggressive, are you talking about the fact that you crafted this state disposition, or that you were more forward-leaning on the potential of prosecuting Epstein federally? More forward-leaning. And yet you didn't. You didn't lean sufficiently far forward to actually pull the trigger and have an indictment returned. So I will push back on that, and that, from my perspective, we were leaning forward, because we did prosecute him by deferring to the state, and ensuring that at the state... Alright, he had a sentence where he went to jail. Alright, okay. I want to sort of move on. I want to ask you a question about 11C1C, please, that you mentioned earlier. Okay. And sort of alluded to here when we, talked about judges. And we talked about dismissing charges from an indictment. What was your position as US Attorney with regard to the binding pleas in a 11C1C plea agreement? We use them very rarely. But why? As a typical matter, judges do not like them. And was that something that, as US Attorney, you engaged with the judges on? Or was that simply a matter of seeing what they did with them? It happened before I got there. I suspect it continued to happen after I left. Alright, okay. That said, were there some occasions in which the office, if you recall at all, did do 11C1C? Their plea agreements? Maybe, I don't recall. Okay, alright.
Mr. Redacted, And redacted, before we move on to...
Miss Redacted. Yes?
Miss Redacted, another issue. Can I...
Miss Redacted. Yeah, I'm...
Miss Redacted, go back a second.
Miss Redacted. Still with federal. I'm still on the federal prosecution, but go ahead.
By Mr. Redacted. We had talked about the... You talked about the state grand jury and how that decision informed your decision, and you said, well, what state grand jury did with this? What was your understanding of what this was? Like, what exactly the state grand jury looked at?
So let me back up. I said it was a factor that informed, not just,
I understand,
determined. So my understanding is that at least some core amount of facts were presented, and I understand that since it was at the state, the FBI may have found additional witnesses. But when it was presented, the very reason the office took it in the first place was because it was presented to the state, and it went to a grand jury. And the recommendation from the grand jury was for a statute that would not require jail time, and that seemed wrong. But the very fact that it was presented to a grand jury certainly was one of several factors that we considered, because it at least indicated some level of how individual jurors may view this.
Do you have any recollection that the state grand jury presented a single witness, who, as Redacted talked about earlier, that they impeached?
I have read that it was a single witness. Since then, I don't have an independent recollection of that.
Okay.
By Miss Redacted. And how familiar were you with Florida state criminal procedure? It depends what area. Well, you never practiced there, right? Correct. I forgot what law school you went to. Not Florida. Not in Florida. And you were not a member of the Florida bar. Correct. So really, any knowledge you had would have sort of been picked up. I should point out that a number of authors in Florida are not a member of the Florida bar, so that's not unusual. Oh, okay. No, I'm not, right, suggesting, right, otherwise. And in federal employment, you can move from, right. Yeah. So I have been U.S. attorney for quite a while, and then I think we would have been interacting with the state system sufficiently, and if there was something that I had questions on, I could certainly ask. Were you aware that in the Florida system, grand juries were not required to be used to bring federal criminal charges except in capital cases? Yes. Okay, so even bringing a case to a grand jury in a non-capital context was somewhat unusual. An indication that there was some concerns or something, so the state attorney, presenting it in the best possible light, is looking to test the case. Alright, and without getting into any substance, did you at any point become aware of the kind of reaction that the line author Redacted was getting from the federal grand jurors to whom she was presenting? I did not. Alright. Another aspect of concern that I think you mentioned in your press conference was the concern about labeling or putting the victims, in a position where they would be labeled as prostitutes, right? Do you recall? I'm not sure, mentioning that. I phrased it that way, but I take your... We'll defer to the record, right. But you did express concern, and our understanding is there was some expression of concern in the U.S. Attorney's Office among the folks about the victims having to self-identify or, admit that they were sort of prostitutes. The disposition that was reached in the state, and that avoiding that was something to be desired. Yes, right? Yes. The charge to which Epstein was ultimately required to plead guilty did just that. It was a solicitation to prostitution of minors. Did that factor in at all as an issue of that was not being addressed at all? Right, by the state disposition? So I was aware of and signed off on this 3-point. The term sheet is in here somewhere. Term sheet. In terms of the negotiation over which state statute was used and which victims, that is something that to my understanding was being handled by Ms. Redacted, and from my perspective, she would certainly have had sensitivity to that. And do you have any idea how those 3 counts or charges were reduced to simply 1? I do not. That would be a function of the course of the negotiations. Why wasn't any reasoning for this disposition, deferring to the state, set forth in writing? Why didn't anyone do a memo explaining what your reasoning was or what the officer's reasoning was? I can't speak to that directly, but I can say that it would have been unusual. I don't recall other cases where there was this is the reason for our disposition type memo. At least, not memos that came to me. Okay, I'm showing you 2, and the caption is all that's relevant here, but there are 2 memos that are both dated February 2006 and March 2006. One of them is in fact addressed to you from Redacted, and it attaches a memo which is a require for pretrial diversion to resolve case against an individual named Ronald Sasse, S-A-S-S-E. And it is a child pornography possession case in which the conclusion was that the defendant merely possessed it, and that it was a case that should be resolved by pre-trial diversion. And I'm just only bringing that to your attention. Right. As well as a second one that I'll show you, to show you that there are cases involving, child sex crimes, where the office did see fit to set forth its analysis and reasoning for the proposed result. The second document, dated February 15, 2006, is a memo, not to you, but to Redacted, in his capacity as Chief of the Criminal Division, and it requests authorization to enter into a plea agreement with a 5-year cap, and it is a C1C plea, and the handwritten notes indicate that the supervisors concurred in it. Again, I'm simply suggesting that there are at least some examples where the office, in these kind of cases, right, did, so put it to paper. So I can only speculate. And questions I would have is, to what extent was this put on paper? Because it was a case that Redacted or others were not involved with. So this was the way that, in this case, the chief of the, the economic crimes, or in this case, Redacted, is chief of the criminal division, were communicating information rather than walking in and having a discussion. We're just communicating it on paper as a way to obviate a discussion. In this particular case, there was discussion, there was communication, and so a memo to sort of establish. In other words, is this a required approval memo, or is this a memo that says, in lieu of getting together, where are the facts? Let me know what you think. Alright, and was there not a practice, or even a requirement in the office, that plea dispositions should be memorialized in writing with the rationale? So, to the extent that a line attorney might be seeking permission from a supervisor, on a plea disposition, I would think that they would communicate that in writing as the cleanest, most typical way when you've got 20 or 30 line attorneys and one supervisor. That is not necessarily the only way, and certainly as U.S. attorney, I don't recall a practice of memorializing to me what plea dispositions would be. Okay, and in this case, you're involved in the case, right? And in this case, I was involved. And so to be clear, I'm not saying that I disagree with this, and I'm not walking away with it. And so, to the extent that I may have, in a meeting, said this looks good, and that... said this looks good, that may have obviated a need to... Alright, write that up. Okay, thank you. Another aspect of the state resolution that raises concern, and let me make clear that many of our questions are framed in this way, but we are also reflecting a concern that's been expressed in the press, and in the public, and by others. I understand. Understood. So, understood. We're sort of coming through that lens. So, another aspect of the state resolution that raises concern is, doesn't it appear that by sending this matter back to the state, there's more federal interference, more federal involvement in the state process than there would have been if you had just kept the case? So, in hindsight, one of the issues I think in this case is after the agreement, and we keep calling it a non-prosecution agreement, and I kept saying, call it an agreement to defer in favor of state prosecution. A DPA instead of an MPA? Right. Why wasn't it called a DPA, by the way? I don't know. There's one email where I suggested putting in reference to petite policy. Right. And Redacted said, looks strange, check it out. There's another email in the record where I keep saying, everyone keeps calling it an MPA, call it a deferred to state. So I can't say why not, but it's an important distinction. But if you had said it... I don't want to go, too far afield. But if you had said... call it a deferred prosecution. Right, agreement. They would have changed it, right? They would have, and I actually asked that we have a clause based... I don't have the independent recollection of this, but based on the record that we include a clause saying that we were doing this in light of the petite policy to defer, and Redacted pushes back and says, I haven't seen that, and he's the local expert, so I defer to him. I take responsibility, but it's an important distinction, and so... I'm sorry, I just lost track of your question. We were talking about, doesn't this involve more federal interference? Could I grab a Red Bull from you that I bought? Mr. Heron, yeah. The witness, sorry, just a... Miss Redacted, do you want to take a 5-minute break? The witness, would you mind? Miss Redacted, not at all. The witness, yeah. Miss Redacted, call it please, at any time. The witness, let me grab the Red Bull. Miss Redacted, off the record. Off the record. By Miss Redacted. Alright, thank you. Alright. Back on the record. So, Mr. Acosta, I was asking you about... Didn't this resolution end up injecting the feds into the state business in a pretty aggressive way? And so what I was saying is, in hindsight, one of the issues here is I think this would have gone very differently if, after the agreement to defer in favor of state prosecution, all the victims knew about this. They had gone into state court, He had pled October, whatever the date was, had been sentenced, had served his sentence, and case over. And so to the extent there are lessons learned, an attempt to backstop the state here rebounded, because in the process it got convoluted and complex and ended up being arguably more intrusive than it would have had this just been, here is what we'll do, if you go back to the state and work this out. But would that have required or depended on cooperation from the state authorities? So I think I was clear, and my recollection is this was an issue where I said it is up to you, and I edited a few parts of this. I got involved selectively. Exhibit 21B is... Oh, your edits. Okay, so before I say I think, let's go to... But 21. But before we talk about 21B, as a general matter, you talked earlier about the sort of more typical usual way in which the US Attorney's Office and local authorities, prosecutor authorities would work, and that is cooperatively, and would decide who gets what, and, right, who has what responsibilities. Here, there was not such cooperation, apparently. There wasn't, and I was going to say, to my recollection, we can look at whether it's in 21B or not. One of my edits was make it clear that it's up to him to figure this out with the state attorney, because we as federal prosecutors are not going to walk in and dictate to the state attorney. But in effect, you did. You did it through Epstein. I understand, and so, in an attempt to reach a resolution, particularly as convoluted as this got, I do think a lesson learned is that it ended up perhaps being worse than if we would not have in the first place. Something my team, we very much thought that it was important that he go to jail, that it was important that he register. How we got to that ending is unusual, and as an attempt to factor in, here are all the issues around the federal statutes, the concerns about trafficking law. Here are the victim issues as to trial, and how, here are all these things. And so on the other hand, deferring to the state appears logical. On the other hand, the way it played out was a lot more confrontational with the state than I would have hoped, particularly because rather than go back to the state and work it out, in the subsequent collateral attacks, they almost tried to state to circumvent and to get the state to circumvent and undermine our agreement. And that was, when you say they, you mean the defense team? Yes. So you could have obviated that whole thing if you had just offered the same result, which would be a plea to a criminal charge with, for sake of argument, a 2-year cap, which would have required a C1C plea. Right. And you get your restitution because federal law requires it. They would have been able to proceed under 18 USC 22.55 anyway, and he would have gone to jail and been registered as a sex offender. All just within the normal course of doing business as the US Attorney's Office. Why not pursue that? Who was calling the shots that said, yeah, we'll do it, but it's got to be with the state? Was that the defense? So something that wasn't the defense. Something that I think is important to sort of lay out here is the term sheet was developed really early in the case. Excuse me, it's dated. Is presented to the team by redacted on the 31st of July. Do you consider that early? So let me clarify from my perspective. It was developed and approved by me before I became involved in interactions with the defense team. In the sense that you only met with the defense team for the first time, in the person of Ken Starr and Jay Lefkowitz and company on the 7th of September, and it wasn't the 7th of September 2007. And that's important because it goes to, there was a lot of buzz in the media. Did they influence this outcome? To my recollection, they may not have even been attorneys of record in this case, and I don't know when they came onto the case. Well, there's an email in the package that indicates that you got a call from K&E. Right. On or about the 6th of August. After the term sheet was presented. And so I say that because we can, and probably will talk about whether those terms were the best judgment or not. But once those terms were agreed and approved, with the exception of the 24 to 18 as a material, and then we can talk about how that happened, we stuck, and I backed the office, and I backed redacted in her negotiations on these. And so, I think that's important to note. I understand, that's not, for the moment, the focus. Fair. It's the terms themselves, and in this case, the state court disposition. Everything that you wanted to get with the state court disposition, you could have gotten with a federal plea. Much more easily. We could have, and there was certainly some consideration of a 371, and that may be, in retrospect, it would have obviated a lot of issues. So who said no? That's not so acceptable. So, there is emails that at that time redacted spoke to me about it. I don't recall, but I'll take responsibility for for favoring or not for favoring, but if that's what happened, I will take responsibility. From my perspective and my recollection, there are two factors here. Well, I don't know if it's two factors, but at least two factors. One concerns about how this interacts with federal law, and what precedents this might mean for other trafficking cases. Two, a Southern District's general dislike for Rule 11, and then third, there were other federal statutes that were considered at various points, and I remember looking at those and saying, yeah, it doesn't quite fit. Two, just to be clear, that process of looking for the square peg that, would fit into the round hole of the 2 years that had been committed to was a process that came before the MPA was actually negotiated, at a time when Redacted was working with defense counsel to see if there was a federal charge that could be within the 2-year scope that would allow Jeffrey Epstein to serve his time in a federal facility rather than in a state facility. Is that correct? Is correct. Okay. And I recall at least one of those ideas, and I recall that my general reaction to it was, we're pushing the law that just looks odd, and we don't want to go there. Are you talking the assault on an airplane or the obstruction of a witness, or... my recollection is not about the assault on the airplane. Okay, but about his home being a special maritime jurisdiction. Oh. Which is... no. Definitely square peg and round hole. Right. Correct, but there was... so I guess Is it accurate that, from your standpoint, a 11C1C federal disposition was not going to be acceptable? That that's not something that you would approve? It would have been unusual. I don't recall with specificity, but I can, based on circumstances, infer that it would have been unusual, and I would have looked at it and said that this isn't typical. I'm not comfortable. So why not offer the 5-year hit and say that's it? I wish I could speculate. I mean, I could sit here and speculate after the fact. I can speak to what I recall, I can speak to what I approved, I can speak to the considerations that went into it. There are all sorts of things that in hindsight we may or may not have done, which may have worked out well or not. I can't answer that. So I guess the big unanswered as yet question is, why was there a fixation on the 2 years when that's not something that comported with anything that was possible in the federal scheme? So, speaking to the 2 years, I don't remember with specificity. Let me give you my general recollection. And then let me speculate. My general recollection is that there were earlier charges, you all may know those in more detail than I do, but there were earlier state charges that were brought. That were contemplated, of which there is no public record. There is. I don't know if there's a public record or not. I can just say my recollection is that there were earlier state charges that were contemplated. The state attorney chose to not pursue those earlier state charges and take it to a grand jury. From public information, my understanding is that's why Chief Redacted became upset. My general recollection is that the 2 years represented what he would have received if the original recommendation, or the original view of the state attorney's office, had gone through, and it hadn't been brought to the grand jury, and I would sort of point to, in this Exhibit 3, I thought it was in Exhibit 3. Somewhere, there's a reference to, as you can see it, Exhibit 3, page 3, as you and the agents conceded, had Epstein been convicted of a felony that resulted in a jail sentence and sex offender status, neither the FBI nor our office would have interceded. But that is completely silent as to what those original charges may have been, or how they related to... I understand. Okay. And so, to close the loop, my understanding is that those 2 years reflected what that would have been, such that the case would not have come to federal authorities in the first place. Okay, where did that information come from? Who said, oh, those charges would have resulted in a 2-year sentence? Was that something that was analysed by your office, or did it come from defense counsel, or from who? I can't speculate. It had to come from someone. It did not come from you, is that correct? So I would not have the knowledge to know what that charge would have resulted. As an initial matter, a penalty that says up to blank years is rarely that number of years, right? Right. By the time you apply guidelines and all that, and so I would not have the knowledge to know how to calculate that state sentence. And in fact, were you aware that Florida did have its own state guidelines? Sentencing guidelines? Generally, I know that, right, there was a process, right. Might I at some point have said, Mr. or Mrs. or Ms. Orsa, or management team member, if this had been done the right way in the state, what would he have gotten? And someone comes back to me, possibly, maybe someone at some point has said, look, this would never have come to us if it was done the right way in the state, and this was the term that he would have gotten. At some point in this process, my general understanding is we got to that 2 years based on not random, but based on this was the calculation that he would have received. Right. And to make sure we understand, is that your actual recollection, or is it your belief based on what you know happened, that's the way it happened? So it is my recollection of my understanding, which is convoluted, so yeah. It is how I recall viewing the term sheet when I approved it. Okay, how we got into... And so, if we got to the term sheet, it's 21. No, it's not. It's one of these exhibits. Mr. Redacted. 15. By Mr. Redacted. Thank you. 15. 15. So, if we go to the term sheet, Epstein pleads guilty. Contended to an information follow, charging him with... These particular statutes I am not familiar with, but I would have assumed that either Redacted or someone else would have selected them appropriately. It makes a binding recommendation to serve at least 2 years in prison. Let me back up if I could. Those 3 statutes, did you understand those 3 statutes to be the 3 statutes or to be the statutes that the state originally was going to bring? I can't speak to that. You don't know? I don't know. So, you don't know what the statutes were? Yeah, okay. Yeah, it makes a joint binding recommendation at least 2 years in prison. My recollection of my understanding when I reviewed these terms is that reflected what he would have received if the state had gone through with an initial charge, and from our perspective at the time, that would have obviated the need in the first place to have engaged federal authorities. Agree or disagree with the logic? I'm trying to explain the logic. No, I understand. Thank you for that clarification. Is it... You posited a couple of possibilities that you might have said. Gee, what would... Right. He'd be looking at if... Right. The state had done what it originally set out to do, or was supposed to do. Is it... How also likely is it that someone came to you, one of your people, and said, hey, I suggest we go with 2 years because the same reason it's... In other words, it came from, right, somebody else to you, and you agreed. So it's very difficult to reconstruct this in retrospect, in part because I don't want to leave the impression that there was one meeting where this was discussed. As opposed to, you're sitting across the hall from someone, you're sitting down the hall from someone. There are ongoing discussions. How do we resolve a matter that has some thorny legal questions? Some difficult victim witness questions. And this is the kind of back and forth where I might have indicated a concern. Someone was trying to address that concern, or I might have asked the question. It's... Well, you've already told us that you did express concern, right, about the case, and you were having conversations with Redacted, possibly Redacted, correct? Correct. And is it possible? Is it reasonable that one of them might have come up with a solution for you to your problems? And that's the point I'm trying to make. It's certainly possible, and it's difficult to reconstruct that 12 years after the fact. All right. I want to go back to wind up this. Wind up this? This concern about engagement with engaging the federal system into the state process. 21B is the exhibit, that is your comments, really, on the very final version of, right, the MPA on September 24th, and the language is quite striking to us in this regard. Looking at the first email there, you've talked about deleting the petite policy portion upon Redacted's recommendation, and inserting global resolution language which you proposed. And then you say, I'm not comfortable with requiring the state attorney to enter into a joining... Let me redo that. And then you say, I'm not comfortable with requiring the state attorney to enter into a joining recommendation. And then you propose essentially taking out a mention of the state attorney's office regarding the sentence recommendation. And then you also note, I'm not comfortable with requiring a state court to stick with our timeline. And you ask that the reference be softened. Your term is to soften. You also use soften below when you talk about a concern about making Epstein an agent of the US regarding negotiations. So you're really... And then at the very top, in the latter follow-up email, you express concern about, do we really need to set a date for his reporting? I'm very nervous about that. If I were a judge, I would be upset by the federal government telling a state court how to manage their calendar. Sorry, Dexter, you're distracting me. You good boy. Can we delete? Right. So clearly you're very mindful, right, of the importance of not injecting the federal sovereign into the state sovereign. Correct. Fair? Alright. But yet, this whole setup, the whole MPA, did require certain actions to occur. However, they came about in the state because of the federal requirement. Yes. And why was that a good idea? In hindsight, the complexity that this took on clearly is something that if I was advising a fellow US attorney today, I would say, think it through. I do think it would have played differently if he had actually not done all the collateral deals and stuck to what was... But that came later. This is before it's signed. It came later. But let me at least say that... And stuck to October 26th. But look, I understand your point, and the response that I can give was, you have we had these concerns, but we also thought it was very important that he serve some real punishment, and that he register. And whether we balance that or not, a lot of people are going to be questioning for a long, long time, but that's how we balanced it. Because the state disposition was not a precondition to achieving those two objectives, you could have done it with a federal plea, serving time, arguably, and the offender registration. Arguably, we could have it done... No, how we do that? Arguably, we could have done it with a federal plea if judges would have gone... If judges would have gone for Rule 11s, which in the Southern District they tend not to, but arguably Okay. I just wanted to... And again, this is a hindsight thing, but yes, it is. But what we're focusing on is not so much the hindsight as the... At the time, did this make sense? And it seems that you all were putting in so much effort, and it was so hard to make this come together and work, that it's striking that it didn't collapse of its own weight. And to that point, let me say, it's also, if I had to speculate, one question that I'd ask is, everyone's putting in all this effort. Redacted put in a lot of work on the negotiations with the defense counsel that were somewhere between zealous and difficult. Meaning defense counsel were, between zealous and, difficult? Yeah. Whether they're zealous advocates or cross lines to rude, we can have conversations about. And at what point, would it have proceeded differently if folks said, let's take a big step back and let's seriously reconsider. But everyone was very, let's get the job done, let's put him in jail, and I'm speculating in hindsight. But could you not have pulled the plug at any time before it was signed? I mean, clearly by the morning of that day, you were calling for some edits that really seemed to reflect a real discomfort. As you identify. Again, I'm supporting the point you're trying to make that we were focused on getting this done. I'm real concerned that he would not go to jail. And a question that I think is a valid one in my mind is, did the focus on, let's just get this done and get a jail term, mean that we didn't take a step back and say, let's evaluate how this train is moving? From my perspective. Okay. I just want to sort of round out the little bit of this. The state-only resolution. You use the term a couple of times, backstopping. What do you mean by that? What I mean by that is a sense that the state wasn't doing enough, and perhaps backstopping is a polite way of saying encouraging the state to do a little bit more. All right. Did you have any discussions about whether this disposition comported with the Ashcroft memo, in that you were hunting to the state for a minor charge? For a fairly minor charge, what your office had already understood from the evidence was a quite wide-ranging scheme of predatory, behavior regarding minor victims? So I don't recall a discussion around the Ashcroft memo. I would characterize what we did differently, in that there are any number of instances where the federal government or the state government can proceed, and state charges are substantially less and different. And on a fairly regular basis, the federal government but stands aside and lets the state proceed. But in this case, you actually had an active investigation that had been proceeding for a year. So let's take the drug context, where there might be any number of active investigations where the federal charges can be rather substantial, but ultimately the federal government says, just let the state proceed with this. Or violent crime cases where the federal government could bring gun charges using felon in possession or another mandatory minimum. But the state goes forward with... So in that sense... But the state goes forward with what? Forward with different charges that have a lesser term. And so I don't think it's unusual. We can talk about, whether this was the best disposition or not, but I don't think it's unusual to have fact patterns that are under investigation that proceed in state court, where the disposition is different than and would have been if it had proceeded in federal court. All right. Do you have anything on that? Redacted. On the 2 years or something else? Redacted. No, I'm going back to the 2 years. Redacted. Okay. By redacted. Did you believe at the time, if this was part of your thinking, that because it was so important to get sex offender registration, and even later develop monetary damages for the victims under the state plea agreement, that pretty much the only thing that the federal government had to give up in this negotiation was jail time? If you wanted, right, 3 things, correct. You said jail time, sex offender status, and some kind of restitution or damages. Right. Mechanisms. Sex offender registration, there's really no give there. You either register or you don't. I'm being binary. Right. Again, I'm sorry. But it is binary, so it is binary. Yes. And likewise, right. Monetary recovery provisions. So really, the only thing to negotiate is time, right? And so your negotiation is, why did we not start at 3, so we ended up at 2? Well, that's a consequence of what So, I was asking. So, again, my recollection is I understood this to reflect what he would have received as opposed to some arbitrary. Let's start at 3 so we end up at 2. I'm sorry, you have a question? No, go ahead. I'll get to my question. I also, from my perspective, was, early on when we set firm on the 2 years, I thought 2 years would have been the right outcome. We ended up on 18 months. I can't say how. There's some documents that might help, but I was at least initially firm on those 2 years. Right, so when you say, I thought the 2 years was the right amount, is that based on your understanding that that's what he would have gotten in the state? Correct. Alright. And the point I'm trying to convey there is that this wasn't, to my understanding, a random number, but it was informed by, this is what he would have received, and therefore it is a reasonable, agree or disagree with the analysis, but it wasn't an informed number to begin with. By redacted. But you don't recall how that analysis was done, or who conducted that analysis? I don't recall that. By redacted. Or even whether it was accurate, actually. I don't recall that. Alright. By redacted. And I understand the explanation. Right. And, right. What it's tied to, but was there any consideration? Because this case, right, was not about 1 or 2 victims. It was a very large scheme by this older, wealthy man to essentially turn minors into prostitutes, have sex with them, oral sex, get other people involved. You've described it in prior statements as grotesque and deserving of punishment. What I'm not hearing through this process is anybody taking a look at this overall conduct and saying, what is the appropriate punishment for this man's conduct? Was there such a consideration, and did you feel that 2 years adequately punished him for the scope of his conduct? Fair question, and perhaps going back to where we started, which is petite. To my mind at the time, there was a distinction between what would be the adequate punishment if this was a purely federal case versus what is necessary so that it is not to put it in petite language, a manifest injustice, so that it wouldn't have come to the office in the first place. And that I think is the important distinction. Because if the 2 years is what he would have received, and therefore it would not have come into the offices under petite, then if there is a state disposition to that, that is one possible outcome. It would be a different outcome if this were truly a federal prosecution independent of the state, which goes back to the point I was making about concern about a federal precedent with this kind of sentence, because then when the next person comes along, they say, well, here is the precedent under 371 or whatnot. And so this was, rightly or wrongly, and I understand the pushback, an analysis that distinguished between what is necessary to prevent manifest injustice versus what is the appropriate federal outcome to that. Agree or disagree with the logic is one thing, but did I explain the logic? Yes, you've explained the logic. Okay. And I'm going to push back a little bit. Right, on that. Because the petite policy specifically says it does not apply where the state conduct is only a minor part, an insignificant part of the entire course of conduct, and they give examples about where you have some type of a RICO scheme. And the state has indicated or convicted the perpetrator based on something that could be one single overt act in the government's conspiracy, and doesn't that really show what is going on here? That what the state has done was really just a small minor part of the scheme, that the federal government had a real opportunity to punish him for this entire course of conduct? So previously, but if I can circle back to your question previously, it's interesting that you can characterize this as, he's turning these questions into prostitutes. He's turning these girls into prostitutes, and then I think that's really interesting because in 2019, 13 years afterwards, despite all the changes in the law, there is still some element somewhere that says he's turning these girls into prostitutes, whereas this was a typical trafficking case of the kind that you see in the Ludebacher days when, it was called modern-day slavery. That's a very different fact pattern. But, a girl that's held captive is forced to service multiple men per day, where this is part of an ongoing business arrangement. And so I hear what you're saying, but if here at this table at least some element of that characterization is live, what would it mean in 2006 when these laws are still being developed? And that consideration, rightly or wrongly, was part of this analysis. By redacted. Was it explicitly, in other words, was that aspect of it, the perception that this was perhaps activity in which the victims cooperated, was that part of the... No, let me distinguish. I didn't say the perception that this was activities in which the victims cooperated. And I've gone to before is there at least one juror that might say, look, we've got conflicting victim testimony. Some of them said he did nothing wrong. They all knew each other. They kept going back and taking payment. Is this trafficking, or is this prostitution? I'm not saying that I agree with that, and I don't think prosecutors do. I'm saying, is there at least a possibility of that? And
Was that articulated to you by the people you were listening to by redacted and...
So,
redacted?
So that certainly was part of the discussions when I talk about the victims issue. Would at least some jurors view it that way, rightly or wrongly?
And you recall having those conversations?
I recall having not only how would the witnesses stand up in court, but how would jurors view them. And then the second part of that is, as it goes up in the appellate process with respect to the federal nexus. And so I hear you, but, it's sort of one of the factors, and so, by redacted. And so, yeah. What I'm getting, though, is that there didn't seem like there was a consideration or discussion about, is this 2 years capturing the scope of his conduct, versus, we're just going to tie it to this potential state crime that could have been charged. Fair. And I would say that the 2 years was not meant... So the petite policy has several prongs, and to my recollection, the petite analysis was not based on... And let's not even call it petite analysis. That overstates it. But it was much more of a, is this a manifest injustice, and if the original... And so, you sort of see it in the Exhibit 3. This would not have been brought to the office in the first place if, he had pled to jail time and registration, and rightly or wrongly, that was understood from the very beginning of the case, and was a factor in how the case was viewed.
And how do you know that the redacted wouldn't have been upset with a minimal jail time, even if there was sex registration?
So, I can't 12 years later say how we knew that. I can say that my general impression was that this was proceeding at the state, that there were certain charges, and that those charges changed when it went to a grand jury, and then it went from... I think they even changed the ASA involved.
Redacted.
They did. The witness. I can't speak for certain, but you probably have that from the record, and that when they changed the ASA involved and took it to grand jury, the charges that came back were substantially less. By redacted. Do you remember the circumstances? Did you know the circumstances under which that ASA was changed? I don't know. All right. By the way, do you remember an occasion in which redacted came to your office in Miami to press you on what was going to be happening with the federal case? I don't recall. You don't recall,
Redacted.
Just one more. Redacted. Redacted. Yeah. The witness. Yeah. By redacted. So before we... Yeah. Leave this. Yeah. One little thing. So if this case had come into the federal system as apart from the... Right. Taking the digression for the... Right. State system. Do you think that the 2 years was an appropriate punishment, given the scope of his conduct? I think if it had come into the federal system apart from the whole state, and the petite considerations and all that, we may have ended up in a different place. I viewed the 2 years, to my recollection, as a manifest injustice standard, and not an appropriate punishment standard. Meaning, whether it was manifestly unjust that he got 2 years? No, whether it was... So let me rephrase. No jail time was a manifest injustice. If he had gone to jail for 2 years in the state system and registered, the question of whether it would have come to the office at all, and to my recollection, the consensus was, and redacted, based on Exhibit 3, agrees with that it would never have come to the office in the first place because we would not view that under petite as manifest injustice. There are any number of cases that are prosecuted around the country where an individual gets a jail time that the federal government may not agree with, but that doesn't mean that the federal government re-prosecutes those cases. The instances where the federal government re-prosecutes a state case are pretty rare, to my knowledge. And so, under the petite standard and the manifest injustice would have been a manifest injustice to have 0 jail time and 0 registration. But if the original charges had remained, that would be a different matter. That does not mean that is the best outcome in the state system. And so, perhaps beating an issue, but let me maybe give an example. One concern that I had was that in the violent crime side, the state brings a case and, there was a deferment, no jail time. The state then brings a second case and there's minimal jail time. Well, now the person has done 3 violent crimes, they have a gun, they go federal, and it's like, please don't do that. Pretty please don't do that. We're going to punish you a little bit, and then all of a sudden in comes the federal government with the big punch to the face, because the federal sentences are so different than the state sentences. And that happens all the time in any number of contexts in Florida. That doesn't mean that all of those cases get re-prosecuted as gun cases in Florida. That means that we understand that the Florida system is different than the federal system. And so the way we looked at least based on my recollection, those 2 years was not... What would he have received if this was a purely federal case? But would this case have been prosecuted by the federal system additionally, if he had received jail time and registration in the state system? And is it fair to say that this particular concern about, for lack of a better word, federalism, or the petite policy, was that a primary concern of yours versus any of your employees in terms of redacted or redacted? I think it's fair to say that I focus more on the legal side of things, and my team focused more on the trial and how this would play out at trial, and both of them sort of inform the outcome. And are you including this petite policy in your consideration of the legal issues? Yes, yeah. I think those are all tied together. By redacted. So you mentioned victim. But could I, yes. To clarify, I thought we had sufficient to go forward, so it wasn't an ethical violation to proceed. Okay. The victim. You mentioned the victims coming into state court, and you talked about all the victims coming into state court. Do you have any idea what victims formed the basis for the original charge that I do not? He was indicted on. Do you know whether it was one? Was it a felony assault prose of a non-minor? It could have been. It was 3 instances to felonize it. You don't know whether it was one person 3 times? 3 people? I do not. And you don't know whether that person was a minor or not? I do not. All right. I would assume they were, but I do not. Likewise, do you know who was the victim, or who the victims were who formed the basis for the 796.03 charge, to which Epstein ultimately pled in June of 2008? I did not at the time. I've read various accounts of that, but that's based on matters that I've read and not an independent recollection. And what's your understanding? My understanding is that there is at least some issue in the media over whether the right or the best victims were chosen from the prosecution's perspective. And do you know, was there any indication of who the victims were? Do you know who the victims were who were the subject of the state charges? Which particular names? No, I don't. Right, I'm not asking you. Yeah. Other than names? Yeah. I just want to know if you know who they are or how many they were. I do not. Right. It could be one, right? For the solicitation? It could be one, conceivably. Both the charges could relate to one victim. Right. So those matters were very much part of the negotiation that Redacted and to some extent Andy were involved in. I did not. What makes you think that your people were negotiating with which victims would form the basis? Fair point. Okay. Fair point, I withdraw. They may not have. I don't know. I don't know how in the weeds and how much our folks, as a federal system, sort of interacted with the state in terms of what punishment. There's at least some discussion in the media regarding whether the punishment was a function of the victims and registration, and I can't speak to that. Alright. Are you aware, just as a point of interest, that the public record of the proceedings in the state court related to Epstein are utterly silent as to who or how many victims formed the basis of the charges to which he pled? No, I was not aware. Okay, so this idea of many victims coming forth in state court and so on is not really in play. Alright, so you have a 2 years it's been now. A 2-year state deal has been announced to the team by Redacted. Yeah. With your knowledge and approval, right? Because he wouldn't do it otherwise, is that right? Fair. Though at least one was surprised. Do you know what drove the timing of the plea offer? In other words, why did it have to be made at that point? I do not. Okay. You know that Redacted submitted his resignation on the 23rd of July. I saw that in the documents. In the documents, and he submitted that to your among other, as well as the, HR people. Why not? Well, then there was a July 31st meeting at which the term sheet was presented. The document 15 is the term sheet that was presented, as Redacted indicates in her September 6th cover email, and you said you approved it. You happened to be copied. Right, through. So, Redacted. Let me forward this, but let me be accurate. I approve these terms, whether it was the specific term sheet or another document that might have been earlier that looked highly similar to this. My recollection is approving a resolution that had him pleading to certain state counts that had a binding 2-year plus recommendation that provided for 2.55 restitution. Right, but you don't know if it was this sheet of paper. I can't say 12 years after the fact whether it was this specific sheet. Right. Alright, of others. Based on the fact that this was in the email, I think it's safe to assume, but to assume what? To assume that it was this. Oh, but it's possible that there was a slight difference in. Alright. In fact, this same document with a couple of, additional bullets that had to do with the date of entry of the plea, sort of ministerial, is what was prepared by Redacted on or about the 31st, or on before the 31st of July. And this document, as indicated, here, along with the attached guidelines calculation, is what was provided to the folks who met on the 31st, of July. Okay, so on that 31st, it was Redacted, Jeffrey left court, Redacted Sanchez, and the purpose of the meeting with Sloman, Menschel, Laurie, and Redacted, as well as the case agents, was to present the plea offer. And did you get briefed on how that plea offer went? I don't recall being briefed, but in the regular course I would have been. Alright, and at that meeting, there was an expression of concern by the defense team that Epstein wanted to avoid being incarcerated in the state system because of concerns for his physical safety, and that concern was accommodated to the extent that the U.S. Attorney's Office team agreed to explore federal resolution. How does that square with your decision that a state plea is how this case was going to be? Right, decided. So I think I indicated later that it's a little bit more fluid than a decision here or a decision, that binary situations. My recollection is we were very focused on this man should go to jail and this man should register. The 2-year plea to the state charges seemed reasonable and seemed a way to go. We can agree or disagree. Reasonable in terms of, not in terms of, was it the most just outcome, but seemed like a disposition that we would agree to. But ultimately the focus was on getting him to jail. And if that meant exploring a 371, it's at least worth exploring. And so I don't think it was inconsistent, because the focus really was on he needs to go to jail. Okay, in this case, that pushback that resulted, right, in the agreement to explore a federal plea, right, was because Epstein was afraid to be in prison. Why would the U.S. Attorney's Office accommodate that? And here we're beginning to talk about a major point of criticism of this whole process and the outcome, and that is that it appeared that the U.S. Attorney's Office was bending over backward to accommodate the concerns of Jeffrey Epstein, and in this case he was uncomfortable going to a federal or state prison, but all child sex predators who go to prison are going to face some, challenges, right? Right. And I remember along the way a heavy push that he be incarcerated at his home under some kind of home confinement, and my reaction to that was no way. Right. And okay, you don't like prison, but that doesn't mean you get to be incarcerated in your house. Which is interesting, because subsequently, And so, because subsequently what? You might as well finish. Well, because that. Subsequently, the way that the state executed the terms of incarceration were not what I would have expected. And so, again, the focus from my perspective is he needs to go to jail. If the team agreed to explore it, the 371 was on the table, to the extent we have been... I'm speculating now. This is not to make the record clear. Thank you. I'm speculating, not recalling. I can speculate a 371 with a 2-year Rule 11 that had been discussed based on the contemporaneous record? That's a big word. And so to the extent it had already been discussed, even if it was not the direction we were talking, would it have been unusual for folks in the room to say, well, look, we've discussed that, let's go back. Let's see where it goes. I can't fault, to the extent it had been discussed, I can't fault anyone for saying, let's go back and look at it. I think that's distinguishable, at least from subsequent. Alright. At that point, the defense was given 2 weeks to take it or leave it, and if not, you would indict. And there were several occasions, correct, where that kind of ultimately was made. Did that mean... given all of your concerns about barriers to what you would consider a successful federal prosecution, was that a bluff? No, it was not. It was not. You were at some level at least prepared to approve the presentation of the presentment of... an indictment? We should not have gone forward with these negotiations if we weren't ready to approve. Whether in this form or a different form an indictment, and I say that because it was very much a draft indictment that hadn't been reviewed fully by the chain, but it wasn't a bluff. Well, by this time it had been reviewed, and it had been reviewed and revised, and it had... There had been some efforts to begin revising, so it wasn't finalized. Some efforts to begin. Exactly. Right. Okay, looking at 11A, this is a letter that Redacted drafted to sort of actually respond to a counteroffer by the defense. The counteroffer is represented in Exhibit 10B, which is a letter from Redacted Sanchez, which you don't need to go into detail. Because, as you've already pointed out, essentially it was a home confinement, and very, very soft. Landing counteroffer. In 11A, Redacted tweaks Redacted's letter. You're copied on this, and the date is August 2nd, Thursday, and he knows that he hadn't discussed it in detail with you, but he wanted to... He hoped that tomorrow, Friday the 3rd, right, he'd have a chance to... And what's notable here is that there's strong language that the office believes that the federal interest would not be vindicated in the absence of a 2-year term of state imprisonment for Mr. Epstein. That offer was not meant as a starting point for negotiation. It is the minimum term of imprisonment that will obviate the need for federal prosecution. You're on paragraph 2? 1. 1, yes. Oh, 2, yeah. It's the first, right, long paragraph. And then he also states that you in the last paragraph, the U.S. Attorney, U.S. Attorney Acosta has asked me to communicate that the 2-year term of incarceration is non-negotiable. Yes, that's pretty firm. That's a line. It is. In the concrete, that is setting, right? Right. And 11B is the letter as it actually went out the next day. And it's got the same language. It's identical. It has the same language. It is one typo corrected. This is redacted's last day in the office. Yes. And he's gone after that. Do you think that this was the appropriate timing to extend this offer, or to set this as the minimum offer? Or was it something that you would have liked to have seen more fully developed in negotiations with defense counsel? I'm sorry, I don't understand your question when you say more fully developed. Well, you have 2 years. Would further consideration have led the U.S. Attorney's Office to decide that, well, maybe the 2 years is too much of a giveaway. We should stick with a 5-year federal plea. Yeah, I can't speculate this far after the fact whether waiting an additional time period and further discussion would have changed things. I can tell you how we came up with it, but that's a lot of speculation. Would you say that Redacted was, as the criminal chief, was essentially the driver of the resolution? Right. Presented in this letter? I can't. Again, you're asking me to speak to something from 12 years ago. I can't speak to it. I was aware of the multiple prongs. I approved it. If we had, at some point, your question is if at some point there had been a let's sit down and reconsider meeting, will we have gone in a different direction? Perhaps, but I can't, 12 years after the fact, speculate as to what may have happened if something had happened. Alright. That's just a lot of hypotheticals. Understood. The question, though, is whether Matt Menshaw, who was the author, right, of this, who first raised it, right, with Redacted Sanchez, yes, in an informal discussion, and who presented it to the U.S. Attorney's Office team, was this really his baby? I can't. Approved by you. I don't remember who I talked to about what, and so it wouldn't be fair for me to, I can't single out any one person as having a greater or lesser role. Well, you are not the architect of this, right? You approved it as you've described it. No, I haven't said I wasn't the architect. What I said is I don't recall. Right, I recall approving it. I think what I'm trying to convey is these discussions are much more fluid than I think any one single architect. You've got multiple lawyers. They interact on a daily basis. They talk back and forth. To put it in an OPR context, there's probably not going to be a single author to the report. You're all going to go back and forth, and there might be someone that has... Maybe there is a single author. Who knows? But I think it's difficult to say there's a single person, and ultimately I was US Attorney, and so I approved it, and... To your knowledge, did anyone in that chain of... Right. That 5-person chain or anyone else disagree with this offer? I'm not talking about... To my knowledge. To my knowledge, I think Redacted at some times may have felt uncomfortable, but whether there was explicit disagreement or not, I don't recall. In terms of my management chain, I don't recall any disagreement. That you are aware of. That I was aware of. I recall discussions. So, for example, Redacted might say I might proceed with a 371 with a 2-year cap under Rule 11, but then we move in this other direction, and I don't recall anyone saying, let's take a time out, let's reconsider. Alright, and let me just clarify. I think at various points in this case, and it's hard to sort of single out the timeline, Miss Redacted was supportive, or maybe I wish we were going a different direction, and that sort of went in and out a little bit. On her part, yes. Let me ask you this. Having reached the decision that you approved, right, that this was the offer, and the term sheet, or the terms, having that decision made, would you have expected your line also to frustrate that, or to not abide by that, since it was your decision? No, with a caveat that if at any point someone felt truly uncomfortable, I would expect them to come and talk to me about it. And can you recall any instance in which an author, a line author, came and talked to you about a disposition that he or she was uncomfortable with? Yes, so I'll give you an example. I don't recall who, before you asked me, but there was this author who was new to the office who impressed the hell out of me. I'm sorry, that's not appropriate language, who impressed me significantly. He had inherited a case, and it was a fraud case, and the bigger players had been charged, and he was basically given a lesser player to basically just finish up on, right? It was a done deal. The person was ready to plead to some minor count, no jail time, and he felt uncomfortable with it, and went to his supervisor, and then ultimately came up to me, and I had a discussion with this person about it, and it ended up with my telling him to go back and call the defense counsel and tell them we were dropping the case. Which, for a new author in the office, is pretty gutsy and unusual, but if this person really felt that this lesser player wasn't deserving, then that was the right thing to do. Right. And so, and the person was not punished for it. If anything, I recounted that story to others. Okay. A question, shifting gears. Yeah. A little bit. About 18 USC 22.55. Yes, okay. Not to be confused with 28 USC 22.55, which every prosecutor is familiar with. So, whose idea was that? It's a civil provision. It's not restitution, it's damages. It's a damages recovery provision in the criminal code. Right. Who came up with that? I can't speak to who came up with it. Okay. I can speak to the reasoning behind it. Your reasoning, or the proponent's reasoning. My recollection of the reasoning as to why we thought it was important. And the importance was to provide a mechanism for recovery of damages. Yeah. Okay. Yeah, I mean, the victim's bad situation, and here it is. Well, go on. Alright. I might circle back on something. So, is it fair to say that's a fairly... Had you ever heard of it before? Had you come across it before? I don't know, but I don't think so. Okay. So, is it fair to say it was novel to the office, to you, and to this team? I don't think it's fair to say that it's novel to the office. Well, do you recall whether anybody in the team had experience with 18 USC 22.55 and a criminal? I don't have a recollection of any discussion as to whether people had experience with this or not. Did you believe that any legal research was needed or should be undertaken to ensure that the procedure was in fact legally sound when embedded, as it was in this case in the criminal plea? So I would have expected to the extent that there were concerns. Again, we had incredibly experienced. Between the various individuals on my management team, we probably had 50 years plus of criminal experience. I would have expected to the extent there are concerns for those concerns to be raised. Did you raise any such concerns about it, or did it seem to make sense to you? From my perspective, I recall... I don't know if it was at the time or subsequent to it, reading it, and it seemed to make sense. Okay. After a redacted letter went out on the 3rd of August, you almost immediately... It appears you received a telephone call from Kirkland and Ellis, is that correct? I don't recall it independently, but that's what the record shows. Alright, and that's reflected in Exhibit 12. Do you remember who called you? I do not. Do you recall... It apparently was from the context of this Exhibit 12, and the caption Epstein. Right. It appears that the call related to Epstein, correct? Correct. Again, I don't remember the phone call, but from the email I accepted that it happened. So, what had been your knowledge and relationship with Ken Starr of Kirkland and Ellis? Right, up to this point. So, I had been an associate at Kirkland, I think I indicated. What was it? From 94 to 90. What was it? Was it 96 or 97? For a couple of years. I worked on at least one case that I recalled with him. I was a junior associate on a merits brief that he argued. He, at the time, was also special counsel. And so he wasn't in the office nearly as much because he was double-hatting as special counsel. And partner. Alright. And what about Redacted? So, Redacted was a partner at the time. I don't recall working with him on any particular case, although I think I worked with him on at least a matter. He was on my hallway. He had an outside office. I had the typical inside office. Had you had any interaction, any contact with them in the intervening years, socially or professionally? On and off. I was in Washington. Ken Starr was in Washington. I think Redacted had moved to New York, but then came back to Washington to be in the administration. And he was in the policy office, and we likely interacted. And while you were here at the Civil Rights Division, correct? Alright. And were you friends? Were you professional acquaintances? Were you what? How would you characterize that? We were professional acquaintances that had worked together several years ago that continue to interact. Is that true as to the two of them? I mean, it's hard to characterize these things. I think that's fair to say. Did Ken Starr know who you were? Yes. And obviously Redacted as well? Yes. Okay. So what was your reaction to being contacted by them by their firm, them, presumably one of... Right. Them perhaps? So I don't know who called based on the email. I can infer that it was one of them. And I think my reaction is captured by, not my email, but by Jeff's comment, and I don't have a clear recollection, but I'm going to speculate or infer that I heard they were being brought onto the case, and I probably walked down to Jeff's office and said, hey, Kirkland's coming onto the case. I bet you they're going to come on to try and take this up to DC. And then I get a phone call, and then I tell Matt, who tells Jeff, I didn't know, maybe Kirkland made a call to... You're right, unbelievable. And then I say they're likely to go to DC. We should strategize a bit. My concerns behind that are, will DC look at this as sort of legally troubled, going back to the earlier points that I made about the policy issue around the trafficking issues up here in DC. And I really do think he should go to jail, and so I want to strategize a bit. So, did you have concern about the fact that that the defense team was sort of appealing you to the big house? I think based on this, I almost predicted this would happen. Yeah. And Jeff is saying you were right. Unbelievable. Where I, in some way, shape, or form, predicted that someone would be hired, or something would happen to take this all up to DC. And had you experienced other instances in which defense team went to DC while you were at US Attorney's office? While you were the US Attorney? Yes. Was that a concern to you? It wasn't a concern, it was a, how do we address this so that we can back our position in our office? Did you have concerns about the disposition that was underway? About main justice scrutiny of the MPA scheme? So, I had no concerns about main justice scrutiny of the MPA scheme. In fact, I invited Drew to come down. Right. And he was part of the meeting where we discussed the MPA. And so, I say that because if I had concerns, I wouldn't have invited him. If anything, my concern was, is main justice on board? Or are we going to basically be told to drop this case when it goes up to main justice? In your email to Redacted, when Sloman's on vacation, yeah, you say that you make reference to a process foul, that the attorneys in the defense team want to go to DC on the case of the grounds of a process foul, i.e., that I have not met with them, and you express concern that that would delay matters. Is that what led you to agree to meet with the defense team on the 7th of September? It is. My concern was, they came out to DC, and the first talking about, well, the US attorney didn't even agree to meet with us. That's not the best. That's not the best foot to start with when you're having your case reviewed. So, what was your understanding of what the purpose of the meeting on September 7th was supposed to be? They wanted to argue, being defense counsel, wanted to argue why we should not pursue this case. And in this case, it was Starr and Lefkowitz from Kirkland and Ellis and Lilian Sanchez, I believe, who met with you. Fair. I remember it was Starr and Lefkowitz. I don't know if it was Lily Allen. Alright. And our information is, it was you, Drew Oosterbarn, Sloman, Redacted, and John McMillan. Do you know John McMillan? Vaguely. Alright, he was an author as well. Right. Correct. In West Palm? Right, and if I could just add, again, I invited Drew. So, Drew became fully aware of that, and my concern in getting Drew into the meeting was to not have them appeal us, and then have Drew say, not a good case. Alright. So, were you aware that Drew Oosterbarn had, in preparation for this, gone to West Palm and actually gone through the evidence and met with the case agent and the line officer? I was not. Drew is an independent actor and could do what he thought appropriate. Does that seem like an appropriate thing for him to have done in your eyes? Sure. Okay. Would you describe the meeting? Oh, and two other people who were there were, again, ASAC Val Parlave and Junior Ortiz. Right. The SSA. So, and the meeting, I think, was in West Palm Beach. Yes. So, what do you recall about the meeting? The dynamics? Who spoke? How did it go down? I recall there was a lot of people. I think Mr. Saar spoke most of the time. I think my recollection, as best as I can, with the caveat I thought Redacted was there, and clearly he wasn't. So, presented several arguments. I then either left the room with my team, or I think I most likely asked them to leave the room. I then went around and asked who to leave the room. Asked the defense? Defense. I then went around the table and I said, does anyone have any concerns or something to that effect? And then hearing none, I asked them to come back in and I reaffirmed the position of the office. In other words, you sort of decided, you ruled from the bench, as it were. Fair enough? Fair enough. Okay. You didn't take it under advisement. You gave them what your position was right then and there. That's my recollection. I don't know if you have information contrary, but at least, okay. That's my recollection. Okay. So, is it fair to say it was more of a presentation on the part of Ken Starr and his side, rather than a debate or discussion? I think that's fair to say. I may have asked a question or two, but my recollection was not a negotiation, but let's hear you out. And so we understand it was mainly a federalism presentation, as opposed to evidence. Is that accurate? I believe that's accurate, yes. And in your letter to Ken Starr, dated... The letter is actually not dated, but we know that it was sent on the 4th of December. Okay. Of 2007, and it's in this package. You noted that... Which exhibit? Mr. Gonzalez. 34. By Redacted. Thank you. Exhibit 34. You note on page 5, you refer to the federalism arguments, and you say that after considering the arguments and conferring with the FBI and Drew Oosterbarn, you decided to proceed with the indictment, but that you would delay presentation of the indictment to allow the defense to appeal to DC. Does that mean you didn't find the federalism arguments sufficiently persuasive to you to change your position? Yes, with a position defined as some concern. But if we need to, if we don't come to a resolution based on the sheet, then we indict. And there was a letter of, by redacted.
I'm sorry, when you say some concern about the federalism argument?
Yeah, going back to what we talked about with respect to the earlier conversation about solicitation versus trafficking and the federal nexus. But back in July, we had decided that we were going forward, that either there is a pre-indictment resolution, or we go forward with an indictment. The September meeting did not alter or shift our position. By redacted. Even though you had some federalism concerns of your own, they didn't rise to a sufficiently high level. So their request was to drop the matter. Right. And okay. Going back again. Understood. There is legal risk. There is witness risk. All of these. If we can get pre-indictment resolution, good. If not, the indictment was not a bluff. It was real. Ken Starr is of course well known. Right. He was Solicitor General. He's, etc. Did you find his arguments well set forth? Impressive? So, you're asking for something that's 12 years... If I had to characterize, by the time this meeting took place, there had been a fair amount of thought around these. There had been a fair amount of... And I at least felt comfortable that while there was some legal risk, we needed... You've got to balance the legal risk and the precedent risk with outcomes. And Mr. Epstein should go to jail and should register, and I felt comfortable. I felt comfortable enough to basically reiterate our position that... But my question with respect to... Right, was... Did you enjoy the give and take with a man of Mr. Starr's, in all candor?
No.
Standing?
No.
No? Not at all? Not at all, because... Alright. It would have been easier to not have the meeting in the first place. Alright. Do you recall an exchange? Were you the person to whom he was directing most of his comments? Most likely. And do you recall any exchange with him about the fact that... Sort of an observation that the two of you and he, were the only two people in the room who had been presidentially nominated and Senate confirmed to any position, so that the two of you had kind of that commonality. Does that ring, do you mean, a bell? Was he trying to butter me up? Was he? Was he? Look, this was 12 years ago. I don't recall. I think as we talk about this, it's important to note that the position did not change. Whatever exchange they may have had, our position did not change. Right. After this meeting, within a few days, in furtherance of the resolution that had been offered, redacted Laurie met with the state attorney's office to sit down and try to work out how this thing would work. And mind you, this was before the MPA is, actually formulated. Did you learn what happened at that meeting? Do you know how it devolved? I may have. I don't recall, sitting here today. All right. Is at this meeting that somehow the three charges that you specified, your office specified in the term sheet became one. So suddenly Epstein was to plead only to one charge, and this was agreed to by the US Attorney's Office folks who were there. Do you know how or why that happened? I haven't the slightest idea. If you had known, if they had called you on the phone, sort of the mid-trial, right, called to the boss, asking what you wanted them to do, what would you have said? So from my perspective, when I said, when I indicated I approved this term sheet, this is the minimum, I meant what I said. I also recognize that authors, in the usual course, need some degree of discretion to negotiate. And so, my assumption after that September meeting, I think I indicated that there was a deadline, that was fairly short, was that redacted, and some, working together, would go back and work out an agreement based on those terms. And, in the give and take, if they think that this is an important concession, that's within their discretion. But I would have been comfortable sticking to that. With charge sheet. With something that drove me is when I said something, as a general matter, I didn't bluff. I really meant what I said. So in that term sheet, to be fair, what Menschel's letter says is 2 years, is the minimum. If the decision to agree to let him plead to one, as opposed to all three, had no impact on that 2 years, would you have cared? Fair enough. And so going back to where to an earlier discussion, can I get another Red Bull? Going back to earlier discussion, I think I indicated that the state charges I wasn't familiar with, and so if in the give and take those charges changed, my focus was on 2-year registration and restitution, as long as those charges were captured the conduct in some appropriate way. So later, rather much later, the defense counsel admitted that at this meeting they thought, yes, that under misinformation from the state attorney's office, that charge that they got the US attorney's office, or somehow the US attorney's office approved, the 793 796.03 charge was not sex offender registrable, and that's a pretty major mistake, right? It is, and I mean that goes to the heart of one of your major concerns. And they tried to get us to change that, and I said no. The defense tried to get you off sex offender registration. Pretty vigorously. Right? But at this point, the focus is on the charge, and the defense is, one might characterize it as trying to pull a fast one by agreeing wholeheartedly to plead to one charge, knowing, or at least believing incorrectly, that it was not registrable, and the US Attorney's Office not having that belief, but thinking it was registrable. So there's a disconnect. There is error. And the error stems, as they later learned, from the ASA herself. So we look at that and wonder whether that shouldn't have raised some concern that this plan to put things back in the hands of the state, which had kind of mishandled the case to begin with, as, at this point, even not a good idea, because they were continuing to be, well, I won't characterize it, but less than reliable. Is that a fair comment of concern? So one question I would have is, at what point did we become aware that there have been... First, the error was in our favour, not the defence's favour, because Redacted got it right, as opposed to the ASA. Correct. And secondly, at what point did our team become aware of them trying to pull a fast one? Was it before or after the signing of the MPA? It was well after, right. But the point here is that the US Attorney's Office folks were not as familiar with the state procedure, the state criminal procedure, and the ins and outs of the sentencing and incarceration, as you learn later. So, didn't this put the US Attorney's Office side at a substantial disadvantage in trying to play in the sandbox in which both the defense, local defense counsel, and the SAs were very comfortable? Possibly, although I will point out that it was the ORSA who got it right. Not eventually, the ORSA, was correct in her analysis. Right. So, in this case, she was more familiar than the state attorney. Not by practice, but by research, and so, right. My point is, we had good people that were able to, if they weren't familiar with something, the research clearly worked. But it took, as you saw in the process of dealing with the work release and all of that, it took a lot of work to keep up with those, errors. Which is why I say in hindsight, if, given all the effort that took place after this defer to the state was reached, if all that had been known, I really think the analysis would have proceeded differently. Because that was a lot of work. That was probably as much work, if not more, than a trial. Right. Meanwhile, we'll talk about the actual text of the MPA in a moment, but following that... Actually, no, before it was finalized, Redacted was working to identify a federal charge, as we discussed before. In that process, she came up with a plan that would have resulted cobbling things together in an 18-month sentence instead of, 24 months. Somehow, that became the new flaw. The new standard. Do you know how that came about, and who actually agreed to that? I don't. I referenced the one email where I think Redacted says he argued 12. Right. I said 24. We agreed to 18. I assume in the give and take, this was an argument that was reached as... But that was 18 as to the potential federal charges. It somehow became imported, into the state disposition. I can't speak to that. This was something that the trial team was negotiating, and from my perspective, these were the terms that we wanted. These were the terms that I expected if they came back and said no deal. Disappointed, but go forward. But they tried to get a deal, and the defense tried? No, but our prosecutors. And to some extent, and the give and take of any negotiation, I don't think it's unfair for an ORSA to give up some things. But has stated clearly to not only the defense team through the mental letter, but also, I believe, at the end of the December 7th meeting, that 2 years was the deal. So, did somebody come to you and say, looks like it's going to be 18 months, and allow you to then approve that? I don't recall if someone came to me separately or independently of the final language. I clearly approved it at some point. And so, to the extent it was approved, that's on me. But I would argue that, someone's negotiating. One says 24, another side says 12. They say, let's agree to 18. To some extent, as US Attorney, I think I have to back the negotiating discretion of my ORSAs. But you explained quite eloquently the reasoning for the 2-year plea as being what Epstein would have faced if he'd been prosecuted. Right. Absentia by the state appropriately. And then suddenly, without any apparent relationship to that analysis, the 18 months pops up from an effort to try to get federal charges. And so how Does that not undercut the basis for the 2 years? So I can provide the reasoning for the 2 years. I also, though, think that as a supervisor, as US Attorney, it's important to understand that when individuals go out into the field, negotiations take place. And if every time there is some give, they need to come back to the US Attorney, or there is a fear that the US Attorney will not back us. You know, there's a certain... I think there's a management issue there, in that if an officer speaking on behalf of the US makes an agreement, as long as that agreement is within a certain range, the US Attorney should back that, because they're the ones that are on the line. They're the ones that are managing the case, and it's sort of unfair to consistently second-guess those late night... I don't want to characterize it. Okay, I say late night negotiation, but that give and take that happens sometimes in a conference room or on the phone. Do you know exactly what give and take occurred in this case regarding the 18 months? I do not. I've read that one document. Okay, but I do not. Alright. Any other questions on this one? By redacted. Really quick. I agree with what you're saying in principle, but in this case you had almost like a mandatory 2 years is the minimum that the US Attorney will accept. Under those circumstances, where you have come out and said, this is the minimum we'll accept, would you have expected them to have to come back to you to get approval for any kind of reduction in that amount? Would I have expected them? I think Ms. Redacted was in a tough position because opposing counsel was coming at her. It was a tough negotiation. Would I have wanted 2 years? Yes. Would I fault her for agreeing to 18 months? I don't think that's fair to her. By redacted. You could have said no, right? I could have. But But she had agreed to it. The process had gone further down, and to some extent I think there was a need to respect that process. That happens. I guess I was getting, this is not the only case where a supervisor sort of says, this is our standard, and at some point things move, and you've got to provide some discretion. Alright. By redacted. Do you think she misunderstood the priorities? That she thought you wanted to get to a resolution, and so the 2 years could be undercut, versus taking your words literally, and saying this is the line in the sand beyond which you should not go, even if it means kill this resolution? So if I had to speculate, I don't think it was a misunderstanding of priorities, as opposed to opposing counsel was exhausting. And if you go for the full record, it really was an exhausting opposing counsel in this case, was very good at taking any slight millimeter and turning it into, oh, so you said we could do this, and in that back and forth, sometimes there is a, can't we just agree in the middle? And I understand what you're saying, but weren't they exhausting because the US Attorney's Office would not say no to them? And so they always believe from the get-go, because they have a 2-year minimum, that the office is willing to then say, oh, we can go down from there, and that they set the tone from then on, that they could continually chip away at you on virtually every single term that came about. So yes, they were exhausting, but isn't that because the US Attorney's Office would not tell them no? So I would push back, because after the agreement was signed, I would argue they did not chip away. They certainly kept appealing collaterally, and we can talk about that, because there were other concerns raised there. But once we had that September meeting, between that September meeting and the signing of the defendant in favour of the state, that was all negotiated by the trial team. That wasn't a come back to the US Attorney or come to the first assistant. That really, to my recollection, was go negotiate with the state, with the line. Well, but there were a number of things that came about later on. I mean, they continually griped about the 22.55, and that got modified. Later on, and I think later ons are different for some reason we can talk about now or later, but there was an attempt to work this out later on that was clearly there. Redacted. The witness. But I think that's very different than how was the agreement negotiated? And I think that's a different sort of timeline. By redacted. So in your mind, was she prepared to walk away from the deal if need be? After it was signed? Before it was signed. Before it was signed, it honestly was. Get a deal, or ultimately, if we have to indict, we indict. And that's what I said, and I look at it this way. After having said that, if that really was a bluff, what would I look like, right? I would look awful. And so for that reason, that was not a bluff. That was a thought through. This is what we will do. Yeah, this is what we'll do. And if you don't agree to this, then we indict, and we indict. You can't make this kind of statements and not follow through. The office loses credibility if you do. Right, but you can keep giving on certain terms. And my point is we did not give, with the exception of that 24 to 18, we did not give. By redacted. Well, you also gave up 2 charges. Again, I'm thinking of a 2 years, registration, restitution, and so with the exception of that 24 to 18, we did not give.
I want to go back. This morning we were talking about our tracks, and we talked about the legal track, and a little bit about the evidence track. There's another aspect of the evidence track that is in play here, because there was a substantial type of evidence, and the question is, to what extent were you aware of this? In October of 2005, the local police executed a search warrant on Epstein's residence, and among things they found, there were cables and cores where there had been computers, computer equipment, video surveillance, cameras and CPUs, all of that computer-based stuff. It had been removed, forgetting why necessarily. If you look at Exhibit 29, were you aware of that, by the way? That had occurred? I was aware that the state had gathered evidence, but not much more beyond that. Okay, so 29 is... I'm sorry, I'm on 21. Wait a minute, this is not the one I'm looking for. 73? Let's do... Do you know what? Okay, this is not the exhibit I'm looking for, and the numbers are a little bit messed up. There is an email, which I may or may not be able to put my hands on, in which Redacted informs you that she really wants to get her hands on important potential, on computer evidence, that it's important potential evidence, and she had a plan to get it. So the question is whether you knew at the time that the investigators had identified this computer evidence as being out there, and that they believed it contained a potentially very significant evidence against Epstein. Computers, surveillance cameras, given his activity, right, in his home. Redacted. He's not on it. By Redacted. Alright, she did not inform you. She informed someone else She informed Sloman and Menschel on July 3rd, and Laurie. My apologies, you're not on this. When she advises them that we want to get the computer equipment that was removed from Epstein's home prior to the state search warrant as soon as possible. So there was the stuff out there, and, right. As of July, there was an abiding keen interest in getting it, and the defense team was resisting the prosecutor's efforts to get it. Were you aware of that at all? So I think you asked about that in your questions to me. Right, I did. I have no recollection of this computer evidence that... Alright. Did the question say that, without getting into specifics, that there was a grand jury issue around this? It does. I don't have that. It is addressed in the non-prosecution agreement if you look at the final non-pros... Yeah, I don't have. It's referred to... It's referred to. The question that you asked, what question was that? The question was whether you were aware that that was something that the prosecutors wanted to get. I don't have a recollection of some computer evidence. Alright, but I think... Is there? What was the question? Aware that Redacted was instructed by her managers to delay her efforts to get this computer evidence because the defense were resisting those efforts, and it became an issue that was in play in the negotiations. I have no recollection of that. Okay, if you can give me 1 second. Sure. Pending federal... And so your question said that there was litigation pending in federal court related to the U.S. Attorney's efforts to obtain, computer evidence? Without going into further detail, I have no recollection of any litigation pending in federal court regarding that. Alright. And did anyone suggest to you and your team that getting to a plea deal was premature because you needed to get this evidence first so that you knew whether you had potentially some very important evidence against Epstein? I have no recollection, and if anything, okay. I think there was a desire to move quickly as opposed to slowly. On the plea? Yes. And do you know where that energy came from? Who was wanting to? I don't, but move quickly? As I recall, so for example, when we were setting up the meeting in September, there was a request to set it up in August as opposed to September, and we had to push it back to September because of vacations or something. Alright, so in addition to not getting the computer evidence, the government curtailed the investigation to a large extent, despite finding more victims. There were witnesses who were not interviewed, things that were not searched, property that wasn't searched, target letters not served. So, these all would have been steps taken by the FBI to enhance the federal investigation, right? As opposed to back to the state, right? In case that this was sort of, being returned to, right? Was this... Mr. Todd, are you asking Alex if he's aware of all the things you just said? By Redacted. Were you aware of all of those steps that were being foregone? Or foreclosed? No. My assumption would have been we may have to go to trial, and so we should continue to develop the basis for trial. So if I could, for example, after Drew came down, I said, if we go to trial, can you be on the trial team? I cite that because I'm thinking we may have to go to trial. Right. Why not get Drew, who's from Miami, on the trial team? So is it your understanding that the federal investigation, notwithstanding the drafting of this MPA, was still continuing? Yes, my understanding is you run these on parallel tracks, and again, I'm sitting here inviting the head of CEOS to be part of the trial team, and talking about how to formulate the trial team.
Okay. That implies that I was clearly thinking we might be going to trial. Alright. When you first received the draft of the non-pros agreement, and this is 16A, it's a draft by Redacted. Do you know who came up with the... It sounds like you didn't, but who came up with the name or the moniker non-prosecution agreement? I do not. Do you know what this was modelled on, if anything? What the genesis was? I do not. I noticed from the contemporaneous emails that initially it was done differently, and I think it was Redacted Laurie who said write it as a contract, or I think there was an email to that effect. Someone may recall it better than I, but this version of September 10th, which is the first business day after that, yeah, September 7th meeting from Redacted goes to a management up through you, and you do a rewrite almost right away, adding original state charges, which at that point were all still in play, and you also added, this is Exhibit 16B, a statement that it would be Epstein's job to move the state to add additional charges, and that latter piece is on page 3, just below paragraph 8, so you can I back up a second? Sure. When you say I did a rewrite, is there some indication of what I did a rewrite of? Yes, if you compare the two, right. There are things that are bracketed in yellow in Exhibit 16B, which represent, right, the changes from 16A, right. Okay, so those are the two things that are different, and they're referenced in your message. Yeah, at the beginning. We bracketed them just to make it easier for you to recognize, right, that. So my point is that right from the beginning, you are participating in the process, in the drafting process. Oh, so I would characterize that as not participating in the drafting process, but approving a draft. I did a small difference. Rewrite. Yeah, and so something comes. Here's how I would distinguish. Someone that's participating in the drafting process is sitting at the table with 2 or 3 people, drafting it as they go, versus something goes through the management chain, and someone in the supervisory train says, can you change A, B, or C? Alright. I clearly, here and in other places, it looks like I'm inserting the same themes, which is deferring to the state. Let's mention the state charges. And we can't force the state to do anything, and so I'm adding to this. I'm clearly aware of it and approving it, but I wouldn't say that I was drafting. Fair enough. Did you read it? I would assume that I read it, or else I wouldn't have edited it. Alright. So we have a draft from Redacted, a working draft on September 10th, with a small rewrite from you. There is in the Exhibit 17 series indication that of the kind of activity that Redacted was going through to come up with a federal plea, but eventually she and the defense attorney, who is most actively working on this, J. Lefkowitz, turn back to the MPA, and if you look at 17D, just to make the sort of staffing clear, of course, Redacted has left. Redacted is going on vacation as of September 15th, and so Redacted Laurie has helped finalize. So the finalizing of the MPA, the final version of which is in Exhibit 22, falls to Redacted with Redacted, right? Yes. Okay. And Redacted puts you on notice in 18B in that process. This email in 18B is sort of a follow-on to 18A. Do you see it comes 1 minute after your email in 18A? It's a response from her to you, only in which she makes note that the defense tried to reopen all the loopholes that I had sewn shut. Yes. So it's fair to say that you're on notice that they're being difficult. That's fair. Okay. In the course of that being difficult, 19A is an email to you from Redacted on September 18th in which she represents that, or explains that the defense is that things are kind of falling apart with the negotiations, and she fears the deal is going to fall apart completely. Mr. Todd, should we take a quick break here? You're losing your voice. I can confirm. Redacted, I'm fine. Mr. Todd, you could probably use a minute. Redacted, alright, we'll take a break. The witness, alright. Redacted, a 4-minute break. Mr. Todd, 4 minutes, that's... Redacted, okay, off the record. By Redacted. Back on the record, looking at Exhibit 19C, you say, you write to Redacted regarding whether you're available to... At a time when she's going to be hashing out language. You advise her that, but I don't think I should be part of negotiations. I'd rather leave that to you, if that's okay. Yes. Why did you say that to her? Because she was the line lawyer involved, and I think it's important for a US attorney to, absent truly exceptional circumstances, to not get involved in sort of the negotiations. You can meet, like I did in September, reaffirm the position of the office, back your author, but ultimately, I think your trial lawyer needs discretion to do their job. At this point, of course, we know Redacted is on vacation, right? And you're aware, were you not, that Redacted Laurie was about to decamp for Washington. In other words, he left at the end of September, yes, to become the Chief of Staff and Principal Deputy Assistant Attorney General. Correct. For redacted. Yes. Who headed the criminal division. Okay, so it was really just the two of them at this point, and with nobody apparently involved between them and you. So, fair. But when you say just the two of them, redacted is an incredibly experienced lawyer. So to say just the two of them is should not imply that there was an experience in that table. I certainly in no way intend to. Right. Too fair. Suggest that. Fair enough. Looking at 19D, in which redacted is on page 2, looking at the latest draft from redacted, meaning redacted, and this is in the throes of negotiating the MPA. Redacted is essentially telling you he agrees with redacted's observations that the defense team are just up to all kinds of nonsense in this deal, and constantly changing their terms, and not just apparently negotiating or dealing with these warring drafts with the drafting process in good faith. Again, that's my characterization, but redacted says to you in this email, I suggest we simply tell him, redacted, that his counteroffer is rejected, and that we intend to move forward with our case. Right? And then your response is interesting. You say to him, why don't we just call him? Tell him, 1, you agree and then change things. 2, you being redacted agrees and changes things. Correct. Tell him you agree, meaning redacted agrees? No, I see. Yeah. Tell him you, redacted, agree and you change things. I see. That is not acceptable to us and is in bad faith. Stop it, or just indict and then try to work it out. So, is the try to work it out, if numbers 1 and 2 are what you should tell, what redacted should tell redacted, is number 3 something redacted should tell redacted, or what you're telling redacted? Try to work it out? It's what I'm telling redacted. Okay. So just to be clear, you say tell him, meaning you, redacted, tell J, number 1. So, and number 2, but number 3 is then what you're instructing redacted to do. Yes. I'm just trying to understand. Yes, so, okay. So my understanding of this is they're being difficult. Hey, this isn't the first time that an attorney agrees to something and then goes back and tries to pull a fast one. So tell them you're onto this, that they need to stop it or will indict, but then that will try to, redacted should try to work it out. Okay, but they need to stop this tactic. Did you really think that was going to be effective with this defense? I don't know. Team? I think one of the hard things with this is, if it was right on September 6th, it remained right, irrespective of really. I think I say, sorry, I know it's a pain. You do. This negotiation was a pain. But if it was the right position, the fact that you've got annoying counsel on the other side, doesn't it make it any less of a right position? You tell them stop being annoying, you try to work it out, and if not, then you indict. Alright, and is that sort of... You had a question? Redacted. I was going to, but redacted was going ahead. By redacted. Is that being consistent with your sort of way of doing business? Being even and working it out? Yeah, that is our position. It's not a bluff, it's what we want. You work it out. People yell and scream on the other side. You work it out. If not, then we indict. What would have been the tipping point for you? What would have caused you to say, okay, I agree with you, redacted, I agree with you, redacted, let's indict? So it's really difficult to speculate, but I think the tipping point would have been a failure to reach, it was pretty clear, jail time, registration, restitution. Okay, we moved from 24 to 18 months. That was a give and take, but ultimately, if they came back and said we can't agree to these terms, then we indict. Alright. By redacted. It seemed like your troops are telling you we've reached the end of our rope. We really want to just go forward and indict. Right. And you were coming back with, tell them again that the defense is being difficult, but I want you to work it out. Does that tell your troops basically that what your priority is? You want them to get to this resolution, and if they have to give up stuff, it's okay. It's really okay, but you want this resolution. So, it's not if you have to give up stuff. I'm not telling them to give up stuff. I'm not telling them to negotiate things away, but I think the dynamic from my perspective is incredibly... So there's a tactic that counsel will sometimes take when they negotiate, and then they try to come back and renegotiate, and that is, to my thinking, one of the most annoying tactics that you can have, and it creates a lot of frustration. And what I'm trying to say is, look, they might be frustrating folks, but if this is being worked out, so looking at this, we thought we had an agreement, and then they changed things, and I'm saying, look, if you thought you had an agreement, tell them you had an agreement. Don't let them change things. I understand it's frustrating to you, but if it was right 2 weeks ago, the fact that they are frustrating attorneys doesn't change the underlying legal analysis. The attorney's behavior doesn't inform the rightness of a wrongness of a certain disposition to a point. By redacted. What's the point? So I think after now I'm calling it an MPA, I was personally very frustrated with the failure to report on October 20th, and I had envisioned that entire collateral attack. I think I would have looked at this very differently. In what respect? To the extent that this was Going back to, for example, the public corruption prosecutions that we had. One of the values of it was to have a public figure stand up and say, I did this, and plead. One of the values was the, avoiding a long and messy legal process. And so when you put all of that together, those, this is why I say it's not quite. This was the factor that we consider. That is, all of this put together, and in something that could have been very positive for the victims over sending a signal, as it dragged on, became exhausting and negative for the victims. It put us in a position of what to do with notifications. It put us in the position of a lot of appeals to Washington. It put us in the position of having to deal with complicated legal issues that actually got more messy in terms of how does a federal 22.55 relate to a state charge. And had all of that been known, I do think this would have proceeded differently. Differently in what way? So if I factored all of that, I can't predict it's right, what I would have done. But I think if I had known all of that, this could have proceeded very differently. I was very frustrated with the October to June time period. So if you had been back in that time frame in early September, looking at this with, I don't know, what Harry Potter character it is, right. But whoever can see into the future and anticipated or foresaw, right, what would have happened? Would you have simply said, look, we're not going to go the state route or go the federal route? Quite possibly. All right. And let me we'll probably get into it, but at some point, I do think the post versus the pre-signature time period was different for any number of reasons, and we'll probably want to talk about that. All right, we will. But now I'd like to return to some of the terms of the affair. The MPA, because you did make... Let me make sure that this is correct.
Redacted. You skipped this one.
By redacted. Oh yeah, before that. Thank you. My colleague reminds me 19E is an exhibit that has an exchange between you and redacted Laurie about at the time when the plea agreement, the federal plea agreement, right, was still in play, and the issue is whether you should sign it, and, right, you didn't want to because you never do. But you say at the bottom we should only go forward if the trial team supports and signs this agreement. What did you mean by that? The first part of it? So what I meant by that was I got something that the document was unusual. So my signature appearing on this document is not in and of itself unusual. And this would have been the plea agreement, not the federal plea agreement, or was this about the MPA? This was about the MPA. Okay. Right, and so the MPA had my signature. Now, the MPA is almost too generous. So that in and of itself is not indicative of something, but it does raise my concern. Is this something that ultimately the trial team does not feel comfortable with? And if it's something they don't feel comfortable with, should they speak up and let me know because we shouldn't go forward with it? And did you ever have a conversation or a discussion about that issue, other than mentioning it? Not my recollection. I would... Okay. Assume based on this that Redacted would read it and would take me at my word and say, look, I think you're going in the wrong direction, Alex. I think you're going in the wrong direction or I'm uncomfortable with it. Okay, all right. By Redacted.
Did you ever have a direct conversation with Redacted about wanting her to sign the agreement, as opposed to yourself?
I did not. This was my communications with Redacted, and I really meant that if at the end of the day my team isn't comfortable, then you shouldn't go forward.
You never recall hearing from Redacted that she was not comfortable moving forward with the plea agreement?
By Redacted. The MPA?
I did not hear. I don't recall hearing from Redacted that she was not comfortable. I know that at various points she became frustrated. At various points Redacted became frustrated, but they were negotiating this. If at some point they did not, they thought this was a mistake, or wrong, or unjust, I would think that they would tell me.
What would you have done? Sit down and really have a serious conversation about where this is going, and sit down and hear them out, again, even if at this late phase. Right. I would think that that's what I would have done. Alright, let's turn to the MPA. What is this? Exhibit 22? Did you read it? We know that you made some final tweaks to it. 22. So, it's the final, as signed, 22. And so I would... Again, I don't have an independent recollection of reading it. I would not have made tweaks to it without reading it. Okay, and so I think you can infer that I read it. Alright, and let me say you were clerk to an appellate, a very eminent appellate judge, and you did you do appellate work? I did. Yourself? So you were somebody who's an appellate lawyer, who has that experience at a high level, is often more sensitive to words and phrasings, and to documents, contents, than might be, again, to caricaturize a little bit, but a more of a shoot-from-the-hip trial attorney who spends his days, in a rough-and-tumble courtroom. And is it fair to say that you were more of the former, and more... So I would push back. I think that's not respecting the talent of the trial lawyer. And particularly on these types of agreements or documents, these are folks that sort of have expertise, because even if this was sui generis, they have seen a lot of this. I am not suggesting that redacted and redacted Laurie. Right. We're not up to this. Right. Because certainly she also had a lot of appellate experience. I'm simply noting that this seems to be sort of in your wheelhouse. Well, look, I apologize. I'm not sure what in my wheelhouse means. I appear to have read this. I suggested some edits. As I would have approached this document, my assumption would have been I'm looking at it from my earlier concerns, that the policy level concerns. Does it capture the we're deferring to the state? Going back to the put in the petite policy versus not, does it capture the policy concerns of appropriately understanding that we can't force the state to do something? And does it capture the essential elements of the terms that we look for, the imprisonment, registration, and restitution? Alright, so one of the things that is a little striking that's different from the original draft's MPA, even as amended by you. So let's pull out the 16b. Is what I would call the non-admission of guilty. So in the first page of 16b, the first paragraph, that's the first clause, after the 1 through 5 statutes listing in 16b reads, "It appears that Epstein has accepted responsibility for his behavior by his signature on this agreement." I'm sorry, you're on 16b? 16b. Okay. It appearing, yes. Okay. So his is, and this is not, this seems to be fairly typical sort of plea agreement language, right? Yeah. And if you look at the top of the final MPA, 22, the third, it appearing clause, fine. Where are you? 16b. Right. Has the third, it appearing he has the, down at the bottom, yeah. It says, refers to it has accepted responsibility. Second up, yes. Exactly, he's accepted responsibility. Right. And then above in the fourth, it appearing, yeah. It references the fact that it appearing Epstein has committed offences against the United States. Yes. Okay, so there's a sense of acceptance of responsibility. In the final MPA, which is 22 in your right hand, the third, it appearing clause says nothing about Epstein committing offences. It simply references the U.S. Attorney's Office and the FBI having conducted their own investigation into Epstein's background and any offences that may have been committed by Epstein, including, the enumerated statutes. And then following the enumerated federal statutes, there's no reference at all to the Epstein accepting responsibility. Do you view that, the removal of that acceptance of responsibility, to be something that was appropriate? So, trying to reconstruct, the focus was on, and I know I'm repeating myself, but jail time, registration, restitution. Whether he accepted responsibility for a federal or for a state, I think my focus would have been on these were the terms. Does this encompass those terms? So, as that concession is not something material as far as... I don't want to use the legal term material, but it wasn't important. So to your objectives. So, is that right? First, I'm not sure. So, it wasn't a concession from those 4 bullets, right? It was a concession from an earlier draft. Right. And so to say it's not important is, again, there was an early draft. It changed. The focus was in any give and take. Drafts change. The focus was, did he go to jail? Did he have to register? Did we have restitution? Alright. By redacted. Do you remember noticing that change and thinking it just doesn't matter? I don't. In all candor, until right now I was not aware of that change. I doubt it would have taken 2 documents and sort of put them side by side, as opposed to, does this capture what we're trying to get to? By redacted. So does that... I was aware of the 24 to 18. But up until this question, I wasn't aware of that change to my recollection. So, by redacted. And you're aware of the 24 to 18 because you noticed it in the MPA, or because somebody told you separately? Or do you know... I can't say other than I was aware. By redacted. In the final MPA on page 5, there was a series of things that are included at the bottom of that page, in that long paragraph, and the one that I want to focus on is the immunity portion. That was certainly not in the original draft proposed by the U.S. Attorney's Office. In this paragraph, the United States agrees that it will not institute any criminal charges against any potential co-conspirators of Epstein, including but not limited to heavy redaction. Did you notice that provision? I don't recall focusing on the co-conspirator provision. To the extent I reviewed this co-conspirator provision, I can speculate that my thinking would have been the focus is on Epstein's. Epstein's going to jail. Whether some of his employees go to jail or other lesser involved is not the focus of this. Alright. This particular provision, as you know, has Enormously generated, criticized, enormous, yes, for a number of reasons. One of which is that it is blanket transactional immunity. It gives blanket immunity to unnamed, unidentified, yes, potential co-conspirators. People who, even in the future, if evidence is developed against them, as long as they could be considered co-conspirators of Epstein in this conduct, they have a get-out-of-jail-free card. Do you have any idea where that came from? I don't, and I don't want to characterize it as giving... I understand how it could be read that way in the record. I don't want to characterize it, but I don't know where this could have come from. I would review this for the policy concerns. Did it do the sort of the bullet points of my assumption, rightly or wrongly? Would have been that redacted and redacted would have looked at this, and that this was appropriate? I understand your point. All right. And I believe the point you were referring to is that when I use the term jail, get out of jail free card, that you recognize this is limited to your district. And that's an important point, of course, to recognize. Of course. But nonetheless, this does give blanket immunity to people if you have no idea who they might be, correct? If you had focused on it, would that have raised some question in your mind? If there was a discussion like what we're having here, then it very possibly could have raised. It's difficult to say it would have, but I understand your concern. All right. And the named individuals, massive redaction, are all individuals who are described in the Pross memo and so on. And the Pross memo does identify that at least one of these women, herself, engaged in sexual activity with minor girls. Yeah. So that she has liability in and of her own. So I don't have an independent recollection of that, but when I reviewed the Pross memo, I did notice that. All right. Now, you told us this morning that you have no recollection of that actually having read the Pross memo back at that time. I think what I said was I don't have a recollection of whether I did or did not read the Pross memo. I have since, when you've provided it, read it, and I note that it does reference her. Having read it now, does that change your view of anything that we've talked about so far today? So, reading it 12 years later, knowing all of this, possibly. And part of it is, I do not think we approach these cases differently, and I think these cases will play out very differently in court today. I think it's very different to sort of go back and recreate a thought process from 12 years ago. Dex, don't get in the way. And if you were relaying back then on the characterization and summary and recounting of this case to you by your people, your senior people, redacted, and in particular redacted, right, do you have a, did anyone, Dex, move out the fucking way. Did anyone in that ground include redacted Laurie in any way to your recollection characterize this case as not serious or as trivial, or as involving unimportant victims? In any way try to diminish either the conduct or the victims? Not my recollection. I do think there was a concern as to how the victims would present in court, given impeachment, and given contradictory statements, but that's different than trivializing the case. Alright, okay. Back to the immunity provision. Were you aware that none of the four named co-conspirators had cooperated? I was not, to my recollection. Do you recall any other case in which blanket immunity in the U.S. Attorney's Office, was in which blanket immunity virtually without limitation, I was granted? I don't recall discussion around this provision, and a general matter, I did not discuss in typical cases that bubbled up to my level, the focus was on who the prime, target is, and not on what we would do with the co-conspirators. And so, I don't recall, but that doesn't mean it didn't happen. And that's just not typically something that I got involved with. And likewise, non-immunity being given to non-cooperating co-conspirators, or co-defendants, is that something that was done in your office? Again, as a typical matter, I did not get involved with these, but let me also say that this wasn't a federal prosecution in the first place, and so this whole thing is Swiss generis to some extent. It is, but the grant of immunity is real, right? I understand where you're coming from. All right. If you had focused on that provision, would you have insisted it come out? One question I would have had is, if we're naming, as I sit here in sort of focus as we are now, but this is with the benefit of hindsight and criticism. If there are specific folks, why do we have any potential language? Because that seems quite broad. It's without limitation as to people as long as they're co-conspirators, right? And so what is the need for that? Okay. And I see. And so, if we had this kind of discussion, I would be sending redacted an email saying, what's the need for this? What's up? But to be clear, as we sit here today, you have no recollection of having noticed that. I don't have a recollection of... If I read over it, my assumption would have been that redacted and redacted thought this through and sort of addressed it for a reason. All right, and if... By redacted. And did you have anyone ever come to you with the evidentiary issues and say, we need to track this down before we give such a blanket immunity? I don't recall any conversation around co-conspirators. By redacted. This is where there is a mention of computer equipment. There is a provision later in that same paragraph that provides that the federal grand jury investigation will be suspended and all pending federal grand jury subpoenas will be held in abeyance unless and until the defendant, violates any term of this agreement. The defendant likewise agrees to withdraw his pending motion to intervene and quash certain grand jury subpoenas. Both parties agree to maintain their evidence, specifically evidence requested by or directly related to the grand jury subpoenas that have been issued, and including certain computer equipment, inviolate until all of the terms of the agreement have been satisfied. Do you view that this agreement to suspend at least certain aspects of the federal investigation to have been an appropriate concession? Again, my focus was on certain points. I would have assumed reading this that this was thought through. Okay, and that people had thought it through. Alright, okay. There is what's being criticized as a confidentiality provision. Yes. Right. Oh, God damn. My arse is numb. Right, and that's on the same page 5, paragraph 13, which provides that the parties anticipate that this agreement will not be made a part of any public record, and then there is an exception for FOIA, or compulsory proceeds from a court, in which the government will provide notice to Epstein. That seems to be limited to the placing of this document on the public record, right? As opposed to sharing it, or disclosing it for whatever purpose to individuals. Is that a distinction that makes sense? That is a fair distinction upon reading this. I'm not sure that is a distinction that was... I'm basing that on my reading currently, and not as a recollection. And in fact, the parties, both defense counsel and even the US Attorney's Office, took the position that this should never have seen the light of day, even to be disclosed to, victims or other parties in interest, except for filling it. Or except for sharing it on a limited basis with law enforcement. I think there were emails that talk about it if we share it. We'll tell them not to disclose it. Is that sort of overstating what this paragraph requires? Possibly. We can get into that, and we can discuss it. I will need to understand a little bit more. I know there was litigation around disclosure on this, but I need to understand much more than the positions that we took, and the why before committing on them. In Exhibit 23, there is a discussion of with the MPA after it has been signed could be revealed. The existence of it could be revealed to the police chief, or even the FBI, or the girls, and redacted in the middle of page 1, or 2/3 of the way down on page 1 of Exhibit 23, proposes that if we tell anybody about the MPA, you just ask that the recipient of that information not disclose it. And you then, at the top of the page, to Laurie and Redacted, who is going to take over Redacted Laurie's position as the managing author in West Palm Beach, should talk with you about it on Wednesday, You should talk about it, about who we tell and how much. Do you remember that conversation? And I don't. I know there were several concerns about leaks in media, and I imagine that we had a conversation quite literally about who to tell and how much. And did you feel that this, at the time, as best as you recall, did you feel that clause bound you to not tell anyone? So my recollection of the clause, whether it was this clause or whether there was a discussion, I was aware of this provision, and my recollection of this provision is at some point it was raised as something that was the subject of negotiation. Okay. That the office policy was that these types of deferred prosecution agreement is not made part of the public record, and therefore that this is not a substantial concession. Because of the typical course of business, that would not be part of the public record. And that's because it's a non-prosecution agreement as opposed to a deferred prosecution agreement. So, deferred prosecution is not to analogize from a non-prosecution to a deferred prosecution. These are, if the non-prosecution is not typically part of the public record, the deferred prosecution, it makes sense that it follows the same. And so, it seemed a concession. I understand how it was perceived publicly after the fact. At the time, it seemed that we weren't giving up much, because the typical policy is this is not part of the public record, and individuals need to file a FOIA. And so by saying it's not part of the public record, and individuals need to follow FOIA, if that is viewed as a concession, it really isn't. So is it understandable that Epstein would not want this document to see the light of day, because it describes the existence and nature and scope of the federal investigation? Right. And also his concession to liability under 22.55. It's understandable. It was also my impression at the time that it would see the light of day because, if victims have 22.55, the ability to get 22.55, they obviously have to hear about it from somewhere. And given the press interest, eventually this would be FOIA'd. And so from my thinking at the time, rightly or wrongly, this is a concession that's basically saying we'll follow office policy. And we're likely going to be FOIA'd on this anyhow, and it can play out in the FOIA. And so, is this really a, concession? Alright, another piece of the agreement is something that is absent, and that's the sort of typical language that you find in I think in pretty much any federal plea agreement, which is this agreement only. The defendant understands that this agreement only binds the U.S. Attorney's Office for whatever district he or she is in, or, right, and that truly what you would call global dispositions are unusual, right, for the federal government. And I would note, and this is after the fact that it does say this district agrees. Okay, understood. And it also has you as a party, not the Department of Justice, right. But it does omit that standard language, and do you know whether that was done sort of by mistake or consciously? I can't speak to that. Alright. Another piece is phrasing that you injected when you addressed the first, it was towards the end, right. You talked about injecting the best efforts language. Yes. Okay. Does it? I believe you made clear why you did that. That is, to avoid the appearance of having the federal government be dictating anything, but why rely on best efforts, and to what extent is that even enforceable? So first let me say it was not to avoid the appearance. It was to avoid the actual legal discovery dictating, but... So Epstein understands that he has no authority to require, but to undertake discussions and to use... So, as I recall, if he did not plead, then there was no agreement. No. I'm sorry. Yes. I don't mean to... It appears in number paragraph. Right. 11. Epstein shall use his best efforts to enter his guilty plea and be sentenced no later than the... Right. Set date. And then in the first paragraph after numbered clause 11, he will use his best efforts to ensure compliance with certain procedures and best efforts to convince the judge of the Florida court to accept his binding recommendation. So best efforts kind of became a sticking point in enforcement, didn't it? Because what does it mean? What does best efforts mean? So I think it's fair to say that one of the issues that came up after this was the U.S. Attorney's Office, at least from my perspective, was in a little bit of a bind because we had agreed to this, yet he wasn't turning himself in. And so how do we deal with that? And so there's not a phrase that I focused on at the time. I understand your point. Alright, I'm going to move on from those. Is there anything else on those MPA clauses? And finally, let me just say you didn't ask. We had incredibly experienced attorneys in the office. I assumed, rightly or wrongly, that this language had been thought through and vetted. And, sitting here 12 years later, I understand the issues that have arisen from it, but at the time, these were not issues that were focused on. To your knowledge, who was involved in the drafting other than Redacted on your side? Right. And Redacted Laurie, and you to some extent? So I can't say 12 years after the fact, but again, Redacted Laurie, very experienced head of the Palm Beach office, have prosecuted any number of cases. Just to keep, perspective and context, the final week that this was being negotiated, Redacted Laurie was in Washington and bouncing back and forth on the weekends because he was in transition to the front office here in the criminal division in this building. That's a factor in terms of being able to give attention to some details. Would you agree with that? It could be a factor. On the other hand, I'd say that Redacted wasn't leaving the department. He is professional. He knows his stuff, and you would expect a professional, if they're reviewing a document, whether they're on vacation, whether they're looking to move from one part of the department to another, that you would expect them to review it, fulfilling their responsibility to sort of focus in and make sure that it encompasses what it should. And that's not a criticism of Redacted. That's saying that might be a factor. That doesn't lessen, from my perspective, reliance on his expertise. Understood. After the MPA was signed, and Redacted came back... Yeah. Right about that same time, he quite quickly identified a potential problem, and that was the commitment the agreement that the U.S. Attorney's Office would identify the representative for the victim. Do you recall him raising that? I don't recall him raising that as an issue, but I know it was an issue.
Alright, it was an issue, and it was one that he raised as soon as he came back. So there was an effort, which he conducted then in redacted absence, to craft an MPA addendum to address that issue. Are you aware that Redacted received a copy of the MPA in November when Ken Starr wrote a letter to Redacted asking her to review the 22.55 portion of it? Do you remember that issue? I remember that the issue was applied to CEOS. Okay. Well, it was. It was appealed initially by letter to Redacted, raising an issue that was new to... that had not been raised with you, and that is what led to your letter to Ken Starr on December 4th. I will accept the timeline. Okay. It's difficult without all the documents. Sure, but yes. And at the time that Redacted saw the MPA, he sent a message to Redacted about his view of the MPA, and you didn't see it, but I just wanted to name some problems that he identified with the disposition and get your reaction. To it. So first, he says, I'm not thrilled about the agreement, but he acknowledges that's out of his hands. He says in terms of the charging and sentencing provisions, Epstein is getting a much better deal than the average defendant, with the exception of defendants who have done physical harm to their victims or abused very young children. We haven't seen more egregious conduct because of its serial nature. The area we need to be most careful about relates to the victims. The US should seek to ensure that the plea, which is not giving him serious jail time, provides the best means possible to address the harm he caused to the victims. That generally means restitution and/or therapy. While the agreement provides facility for the victims, the relevant terms still seem pretty advantageous for the defendant, and not all that helpful to the victims. They get an attorney who will be paid by the defendant, which involves at least some conflict of interest. Or they could hire their own attorneys on a contingency basis, and they get waivers from the defendant when his plea would facilitate their civil cases in any event. Then, they still have to sue him to get anything. Most times for wealthy defendants, we make them agree to a restitution fund, and then still provide that the victims can sue the defendant independently if they so choose. Or if they choose, sorry. We always make them clearly admit their guilt. No, please. This is incredibly important to the victims. I would have taken the guy to trial unless the victims were clearly against it. And I don't think most of them are here. He then says to Redacted, who by this time is working for... Redacted, right. So that's the context in which he's addressing it. Redacted specifies that Redacted wouldn't and shouldn't address the agreement. So that... Why was my access? Oh yes, cat bed will arrive today is literally the one they're sitting on right now. Jolly good. So that's the context in which he's addressing it. Redacted specifies that Redacted wouldn't and shouldn't address the agreement. So that the issue that was then before Redacted, put there by Ken Starr, was whether this 22.55 scheme or scenario set out in the MPA was appropriate. It appears that she then sent that back to you to address. Right. But as far as Redacted commentary on the MPA, if you had been aware of this perspective at the time, that you and your people were fashioning the MPA, would that have been helpful to you in deciding how to proceed? So may I? Yes. Okay, I assume you've read the whole thing, but let me just I have. And so a few comments. First, let me say he was part of the September meeting. And to my recollection, these perspectives, so at least the outlines of the agreement were disclosed at that meeting, and I don't recall this type of communication at that time. Okay. I also recall that there was a lot of back and forth around this restitution fund concept, and our perspective was that the restitution fund puts the victim at a disadvantage. Because, let me try to recreate. I don't recall the details, but I can recall that there was a perspective that the restitution fund, put the victims at a disadvantage, and there is some reference to, was it an Alaska case? It's called the Redacted case. Mr. Redacted. Redacted. The witness. I'm sorry? Mr. Redacted. Redacted. The witness. Redacted? Ms. Redacted. Redacted or redacted? The witness. Redacted? By Ms. Redacted. Yeah. And so to the extent that there were better ways of crafting this, that certainly would have been highly relevant, because to my recollection, we were not wed to any particular way of crafting it. The intent of the 22.55 was to come as close as possible to putting the victims in the position they would have been had he been tried and convicted federally. And so the answer to your question is yes. Is yes, that would have been helpful. Okay. As you set about addressing the 22.55, you consulted with Redacted. Do you recall that? I recall consultations. I don't recall that it was specifically with Redacted, but did you know her? Yes. Okay, and do you recall the nature of your interaction with her? I don't. I know from contemporary review of the record that there was an email from her. It's 41A. 41A. And what I want to ask is simply 41A is an email in which you ask, you note to redacted, who was redacted, right. One of her deputies, she oversaw CEOS. She, redacted, mentioned to you that redacted was looking at this, which is the 22.55. 22.55, she contacts her counterpart in the civil division. Redacted, and there's an email from him, which is the second page of this exhibit, which he copies you on. So my question is this the extent of your interaction with redacted on this issue? 12 years. Okay, after the fact. I don't remember. Okay, alright. In Exhibit 35, there is a letter from J. Lefkowitz in which... I'm sorry, it's an email from J. Lefkowitz. Exhibit 35 to you, and this is substantially later, but it has a sentence that... or a phrase that we'd like to ask you about, and... alright, it's highlighted at the top. It says, back at the beginning of January, when we both agreed that there were significant irregularities with the deferred prosecution agreement, you called a timeout. Is that accurate? Did you and he agree that no? There were significant irregularities? No. Okay. And if I could, there are several instances where, not just to me, but to other people as well, G recharacterizes conversations. Recharacterizes them inaccurately, or misleadingly. Alright. What I recall agreeing to at some point is that there was an appeal to the DHE, or there was an appeal in place, and I basically said, I think there was a letter that I sent saying, if you want to appeal, go ahead. We're not concerned about this. But that doesn't mean that I agree that there were irregularities. Alright. Or that there was a timeout. I'm part of a department. I'm part of a hierarchy. If someone wants to overrule me, that's okay by me. Alright. So the MPA addendum was worked out, and the defense team continued its sort of multi-pronged assault. In the middle of the negotiations between Redacted and Lefkowitz about the MPA addendum, that's when you had the much commented on breakfast. Correct. On October 12th. And you have stated publicly that perfectly accurate that the MPA was signed and that was a done deal. And so that this was not tied in any way to any effort to influence the terms of the MPA. Fair? Fair. Because the way this was reported was that I negotiated over breakfast. It was signed, and that's really important. Of course. There were, however, a number of open issues. Yes, right? And in Exhibit 28, J. Lefkowitz on page 2, this is an email to you, acknowledges your breakfast on Friday. This is dated October 18th, and following up on your conversation with him about the day for Epstein's plea. So he knows that you said you didn't want to dictate a schedule to the state. So all I want to note is that when you had the breakfast, there were issues still open that were the subject of discussions between the defense and the U.S. Attorney's Office. And so... no, let me redo that. And so, I guess my question is, while that was a meeting of convenience in a public place, in a location where you had business later that day, a speech, I believe, optically, do you understand the public concern that this was sort of a one-on-one negotiation on pending issues? So I understand how there can be concern. This, it was not unusual. In this case, I actually very intentionally waited and tried not to have one-on-one meetings, but there are other instances where I might from time to time have one-on-one conversations with the opposing counsel. I don't remember the breakfast. I can speculate that one of the issues that was informing this was somewhere around this time, but I can't say with certainty that this was what it was. But somewhere around this time, there arose allegations that Redacted had directed the designation to her boyfriend's partner, or something along those lines. I believe it was a former law school classmate of her then boyfriend. And so I don't remember what the details, were. But I know that was a topic that he wanted to raise, with me. Did he, at that breakfast? I don't remember the breakfast. Okay. You asked me about one characterization of what I said in the record, of that breakfast. I think I responded, Through, or my counsel responded, and they're pointing out that I seem fairly perturbed at how he inaccurately characterized something that I said. And so we don't need to revisit that, but... alright. If you look at Exhibit 27, another sort of point, just to kind of... Alright. Mr. Redacted, could we... Before we... Mr. Redacted, yes? Mr. Redacted, leave. Are we leaving the breakfast meeting? Mr. Redacted, no, this is... The witness, okay. Mr. Redacted, this is directly related. Mr. Redacted, okay. By Mr. Redacted. And that is Exhibit 27 in the second email down. It's from Redacted to J. Lefkowitz. The date is October 12th, so that's the same day as your breakfast. Right. And the date of it is not
I'm sorry, the time is 9:48 a.m. Your breakfast was at 7. So this would have been pretty shortly after your breakfast, and Redacted writes to J. Lefkowitz with a copy to you and Redacted, stating that he just got off the phone with you. That is, Redacted just got off the phone with you, and then he furnishes a revised paragraph 1, which suggests... I infer from that shortly after the breakfast you had a phone conversation with Redacted about a revision to this paragraph, and that was likely something that you talked to him about. Again, I'm not right. Suggesting that this... Again, I don't recall the breakfast, so I can't say one way or the other. I take your point. I don't recall seeing this. All right. Well, it was, but you were copied on it. Okay, all right. Redacted, you wanted to... By Mr. Redacted. I just wanted to point to Exhibit 30. Can we back up a second? Mr. Redacted. Sure. The witness. Redacted, I'm not sure whether your concerns are... So, I would only raise the question where, or the point where, based on this, and I don't recall, so I can't speak, but Redacted is saying, J suggests revision has been rejected. Here is our latest, Redacted. And so, there are multiple ways to read this. One is that this was raised. Another is that we're rejecting something that J has proposed, and... Ms. Redacted. The witness. Because I was meeting with J. I asked that Redacted not reject it until after I met with him, and I'm speculating because I don't recall the topic, but it does appear that it says, J's suggested revision has been rejected. Here is our latest. Ms. Redacted. All right, thank you. Redacted? By Mr. Redacted. Can we just go to Exhibit 30 quickly? There's some highlighted language. This is a letter from Lefkowitz to you on October 23rd, 2007, where he recounts, again, the things that happened, or his version of the October 12th breakfast meeting. Yes. Are you at that? Yes. At that point right there, Exhibit 30. Yeah, I'm there. Okay. So, in the highlighted language, if you could just take a look at that quickly. Yes. So, he is recounting that you had assured him that the office would not intervene with the state's attorney. Now, this is new. I don't think we've had the evening session before. This is a new page at 6 p.m, but it carries on. Yeah, just pointing that out. So he is recounting that you had assured him that the office would not intervene with the state attorney's office, or contact the civil claimants or intervene regarding the sentence that Epstein receives pursuant to a plea agreement. Yeah. So is he correct in his recounting that? Can you find that for me? Yeah. So again, I don't have an independent recollection. Oh no, I'm looking... Ms. Redacted. Oh, you have it. The witness. For something. I don't have an independent recollection of that breakfast, but in the contemporaneous emails and the contemporaneous record, there is correspondence between Redacted and I, and you all asked for this, and I spoke with my counsel, who then responded, and there's an email exchange where there's an October 20th. This was an October 23rd email. October 23rd letter. And then there is a response that's drafted on October 25th. I don't know if we can find that. From Redacted to J, that specifically addresses the point, and then I respond, Redacted runs that by me, and I respond, I edit the letter and I move it. I sort of emphasize, I make it firmer, and my edit says our office cannot and will not agree to this, and then my comment to Redacted is, what do you think of this rewrite? Is it too strong? By Mr. Redacted. What day was that? That was 2 days after this. I don't know if we can find that in the chronological record. That was October 25th. Let's just take a minute. Is that what you have? Mr. Redacted. Sorry, apparently my ability to separate paper has failed. The witness. Okay, so this is... Mr. Redacted. Oh, I see. The witness. So... Mr. Redacted. Sorry, go ahead. The witness. So, October 25th, I'm writing to Redacted. What do you think of this rewrite? Is it too strong? And it says, Dear Jay, I'd like to take this opportunity to document our conversation of October 24th, which clarifies some of the representations in your October 23rd letter. I write in particular because you indicated that your intent in writing the letter was to memorialize our conversations. Our agreement is limited to blank, 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 ... I specifically want to clarify one of the items that I believe was inaccurate in the October 23rd letter. Your office states that this office would not intervene with the state attorney's office regarding this matter, or contact any of the individuals, potential witnesses, or potential civil claimants, and their respective counsel in this matter, and neither your office nor the FBI would intervene regarding the sentence Mr. Epstein received. I'm quoting Jay's letter. As we discussed and hopefully clarified, and as the U.S. Attorney previously explained in an earlier conference call, such promises equate to the imposition of a gag order. Our office cannot and will not agree to this. It is the intent of this office to treat this matter like any other case. Thus, as is typical, we do not desire or intend to intervene in the State Attorney's Office. The non-prosecution agreement provides sufficient mechanisms to achieve the goals of the federal investigation. You should understand, however, that there are some communications that are typical in these matters. And so I go on. And so my point is, this was pretty based on, if you review my emails and language, for me to write something up saying, what do you think of this rewrite? Is it too strong? And to edit redacted language to, our office cannot and will not agree to this. It is not my agreeing with this characterization, but my polite way of saying, this ain't what I said. Let me be clear. And then, again, no independent recollection. This is just based on inferring from the contemporaneous emails. Okay. By misredacted. What I would like to do is ask a couple of questions in a couple of areas about the main justice review. Okay. Then take a short break, and then redact it to some questions that are CVRA related. And then we have some summary questions. Okay. Is that all right? Can I, before you move on, can I address something that redacted was getting at, but it's getting late, so I'm going to circle back to, please, something that I thought you would bring up. Misredacted. Sure. The witness. So I think something to talk about is pre-agreement and post-agreement. I think are different, and one concern that I had, and I certainly shared with Mr. Redacted, was once it was signed, so we had the initial issues with the case. Once the agreement was signed, we now have an overlying issue of, is the agreement binding? To what extent it's binding? And so your question was, why this level of process after the agreement was signed? And I said, I think you'll get back to that. And I think to some extent, there are two parts to that. One is, the office shouldn't be afraid of review. We're part of the Department of Justice, and review, whether it by main justice, or now you all, is part of the process. And so, to the extent that they want to appeal to Maine, it would be unseemly to sort of say, don't review us. And I don't think it would help reviewing this, but the second part of it is, if we were to walk away from the agreement, that not only are we litigating the underlying criminal case, but we're litigating a civil criminal issue on top of that, which is, did the agreement bind? And that's something that did inform the exhausting amount of process that they received, which didn't change any of the outcome. By misredacted. Didn't bind what? So if we were to walk away, could we still prosecute? I see. Right, because having signed that, we were now parties to an agreement, and that would overlay any sort of prosecution. And so you had these collateral issues coming. By misredacted. Just to make sure we're clear, are you saying that there would have been a difficulty in declaring a breach so that you could then indict? Correct. And so we'd have to litigate over a breach, because as much as they had collateral challenges, they are very careful in saying, this is not a breach, we would just like a review. And so one of the issues that overlaid the post, that October going forward time period is on top of this. Do we now want litigation over a breach? And so I think that is why the post-agreement time period is different than the pre-agreement. Misredacted. The witness. Time period. By misredacted. But was part of that problem the result of the change from, here is the date that you must comply, to, you must use best efforts to comply? Possibly. I would, whether it was that or others, or other parts of the agreement, we can talk about, but how, once the agreement was signed and they start pushing the date, there becomes a legal issue over, are they really in breach or not? And I understand your perspective. I'm just saying, earlier I said that there was a difference. You asked about the process, and I said from my perspective, there's a difference between the pre-agreement and the post-agreement time period. And much of that difference is informed by, if we declare a unilateral breach, how does this hold up in court? Because now there's a signed agreement that the United States is a party to. And are you saying that part of the reason, or maybe all of the reason, that you continue to give accommodations and process and delay was because of the concern that you couldn't actually win a breach argument? I think that was a consideration. Another part of the considerations are if a party wants to take, main justice gave a lot of process. It wasn't just to redact it, but it was just up to the Assistant Attorney General for Criminal Division, to be polite, but it was up to the DAG. And so if main justice is going to give them this degree of process, we should be in the position of saying go forward, as opposed to, I don't think it looks positive for the office to be viewed as fearing department review. But were you giving the impression to the Department of Justice that you were the one who wanted this review, so that they felt like, well, it's not just these defense attorneys who we can blow off, it is a United States attorney who is asking for this review, and so therefore we need to give the courtesy of reviewing this? I don't think I asked for it as opposed to saying, if you would, so from the very beginning, they said that they're going to take this to the Deputy Attorney General and Attorney General. And I said, if you want to, fine. They just finally did, but that was not, I think they raised that as early as August or September, and so I'm not surprised that it ended up there. I also thought it was important to not be in the position of fearing review. I think if you look at the contemporaneous record, there's an effort on our part to expedite the review. Okay, by misredacted. But there's a difference between have at it, go do what you want, up at Maine and getting that right, that non-opposition, and actually sending a signal to, in the case of the criminal division, the Assistant Attorney General, in the case of the DAG's office, Mark Phillip or his assignee, that you supported their review, that this appeal process. You could have said, look, we're going to go ahead and get on with our business. If they want to, if you could have not so much opposed a review, but not seconded their request for the defense request for reviews, or not in fact invited the reviews. So I'd be curious as to the timeline. I would take issue with, I invited the reviews, and I question whether did they initiate the reviews on their own, and then I said, have at it, or did I, based on, I mean, you've got more of a record than I do, or did I invite, I would say I did not invite the reviews. Well, bad terminology perhaps, let me ask you this, did you convey to the criminal division that you wanted them to review this matter, as requested by the defense attorneys? So from my perspective, I'm thinking back 12 years now. The very reason that we invited Redacted to come down to Miami back in August was a sense that it would end up here. And so if it's going to end up here, let's bring Redacted down. Let's make him part of the initial meeting. You know, if there are concerns, let's raise these. Let's address them. Let's get them out so that we don't end up, after we go forward with all of this, back in front of Redacted and Redacted. And it's much better to involve main justice earlier. And so, I would say I was trying, if anything, to involve main justice so that we didn't end up where we were, and it had been my expectation that that October date would have been met. The collateral reviews afterwards, the collateral appeals, obviously did not go as we planned, and it was my sense we were going to end up at main justice one way or another. So my question is, in December, after the December meeting, right, that you had with defense counsel, and they told you they were going to go to main justice, correct? To the criminal division, did you convey to main justice criminal division that you wanted them to conduct the review that defense counsel was seeking? So I don't recall what I may or may not have conveyed. I think my recollection was, if they want a review, that's their right. As a department, we're not in the business of telling individuals that they can't take something to your superior, or your superior, or to your supervisor or your superior. Whether main justice takes this on or not is ultimately at their discretion. Would it surprise you to learn that the criminal division front office understood you to be requesting their review, the review that was sought by defense counsel? Would it surprise me? Perhaps. My understanding, recollection is we shouldn't fear it. If they want it, that's their right. I thought by inviting Redacted down in the first place that we had at least tried to address that early on, but I also thought that we might end up there in the first place. Were you aware that a decision was made to grant the decision by your office to grant defense counsel's request? Their insistence that Redacted's role in the criminal division review be limited to review only, and that he not be permitted to, or that the criminal divisions, I'm sorry, I misspoke. That because Redacted had already been involved in essentially being a prosecutor on the case, right, that the criminal division and CEO's role vis-a-vis this review should be review only. That is, they should be taken off the case as a partner? So I sought emails to that effect in the record. I don't have an independent recollection, 12 years. Do you think you were involved in that decision? To take them off? Yes. To my recollection, I wanted them on as a partner, and I think the contemporaneous, emails from Redacted is, can you please come on board? But that was earlier, before this review process? No, even after the, alright. Review process. I think there are contemporaneous emails where we're saying it's important that you be part. If you go to trial, it's important that you be part of the trial. As I went through the record, at least I remember, an email, perhaps from Redacted to Redacted that I'm copied on saying, hey, can you reconsider? It's important that you be part of this. Reconsider the review-only limitation. No, reconsider being a part of the trial. Oh, alright, team. Alright, so to be clear, do I understand that you, correct me, that you don't have a recollection one way or the other, whether you requested the criminal division to conduct the review, or it could have happened, or... So, what? To the extent Again, I'm going back. 12 years. To the extent there was a request to... It would be in the context of, this is going to Washington, we're not fearful of this, have at it. And you would have conveyed that to Washington, not just to the defense attorneys, is that correct? I imagine in some way it's... Alright. By misredacted. And just one? Yeah. Just one point. This one. This one was a little bit of a... Yeah. Odd posture. However, because you had a signed agreement, and so, basically a contract between parties, right, and particularly on Mr. Epstein's side, a party who was extremely well represented. So, was there any consideration on your part, instead of saying, hey, everybody's got a right to review, knock yourself out, go up to Washington, as opposed to saying something like, that ship has sailed, guys, you signed this agreement, we're going forward. You don't go forward, you're in breach, end of story. So, his counsel are raising serious issues that go to ethics and go to fundamental relationships between sovereigns. Is this 22.55 appropriate as a matter of federal policy? Is what we're doing an overreach? Is what we're doing contrary to law? Are we extracting? I'm characterizing. This may or may not be accurate. Are we extracting unduly? Are we using criminal law to extract civil concessions in an ethically suspect way? Those are serious issues. That isn't just, is this a good case? Those are genuine issues. I happen to think that, as I recall, that we were in the riot or we wouldn't have agreed to it. But by the same token, let's assume that Main Justice ultimately disagreed. Is that from a Main Justice perspective? And maybe I'm coming at this from a, being informed by having been at Main Justice. Where there was talk about, can you believe what this author may have done or may not have done without consulting? That these are serious issues. They establish precedent. They, maybe the DAG would have said, this is not the kind of thing we'd support, and this is wrong. And so at the end of the day, let's move forward. But once these issues are raised, I don't think a US attorney should say Main Justice should not review this. I think we're part of one department, and these are valid issues. Main Justice doesn't need to take months to review this. Main Justice can expedite their review, but those are valid issues for the Deputy and the AAG to review. But one could look at it and say, well, those are all issues that the defense certainly knew about before they signed that agreement, and having signed the agreement, they are wavering over that. That's what contracts are for. You've got all these issues, don't sign the contract. And if I could, I think there's a December letter. I don't know if it's in the exhibits, but there's a December letter that I wrote that, for me, this is the 19th. Maybe it's the 19th, misredacted. The 19th is your sort of ill-fated MPA addendum effort. The witness. No, a letter to Ken Starr that I wrote, but misredacted. The 4th letter is to Ken Starr. The witness. I'm sorry? Misredacted. Is it the December 4th letter? The witness. Yeah, it's probably misredacted. December 4th. The witness. Is the December 4th? Misredacted. Yeah, I didn't have a date. Misredacted. All right. That's the one you wrote. The witness. So, misredacted. To him? The witness. So, misredacted. In response to the witness. So, misredacted. 22.55 issue. The witness. I think, I'm starting on page 4. I responded personally in some detail to your concerns because I care deeply about both the law and the integrity of this office. I responded personally and in detail as well because your letter troubled me on a number of levels. Upon your understanding of the negotiations the 22.55 was first discussed July 31st. And one of these 4 points in the middle of 2007, your defense team asked to meet with me. On December 7th, I met. After considering of the arguments and after conferring with the FBI and redacted, our office decided to proceed with the indictment. At that time, I offered to delay our prosecutors to delay presentation to allow you to appeal our decision if you choose. You chose not to. Instead, you elected to enter into the MPA. Since the signing of this agreement, the feds in our office have addressed several issues that have arisen, although the exchanges at the time were a bit litigious. By misredacted. Could I thought point out, that this letter is in response to not the request for a review by the criminal division. That comes later. This is in response to Ken Starr's letter to redacted about raising 22.55 issues that have been raised with you before, that have not been raised with you before, sorry. Right, which is in essence a review. I mean, they're coming to Main Justice, and it's against these many previous foregone opportunities to object that I received with surprise your letter requesting an 11th hour after the fact review of our agreement. Although it happens rarely, I don't mind this office's decision being appealed to Washington, and have previously directed our prosecutors to delay. Indeed, I'm confident in our prosecutors' evidence and legal analysis. I nonetheless directed them to consult with subject matter experts in the Criminal CEO's division to confer to our interpretation of the law before proceeding with this indictment. So I guess, we consulted CEOS. I'm thus surprised to read a letter addressed to the department headquarters that raises issues that either have not been raised with this office previously or have been raised and in fact resolved in your client's favor. I'm troubled likewise by the apparent lack of finality in this agreement. The authors have been negotiating with defense counsel and have for some times complained to me regarding the tactics used by the defense team. It appears to them that as soon as resolution is reached on one issue, defense counsel finds ways to challenge the resolution collaterally. So this is your protest of, it sounds like Starr's effort to bypass you and go to redacted with new issues. It is, and I'm pushing back in that. Was I inviting this, or was I sort of saying, that's it, there must be some closure on this matter? Some in our office are deeply concerned that defense counsel will continue to mount collateral challenges to provisions of this agreement, even after Mr. Epstein has entered his guilty plea and thus rendered the agreement difficult, if not impossible to unwind. In closing, I ask that you consult with co-counsel. If after consultation with your defense team you believe that our agreement is unethical, unlawful, or unconstitutional, I'd ask us that you notify us immediately so we can discuss the matter by phone or in person. I have consulted the chief prosecutor in this case, who has advised me that she's ready to unwind the agreement and proceed to trial if necessary, or appropriate. So, are you suggesting that this represents your protest of their appeal to redacted? So, on this point? So, protest is a loaded word. What I'm suggesting is, this is not an invitation to appeal to main justice. This is sort of saying enough is enough. But, Mr. Acosta, in fairness, to clarify, right. This is in response to a letter directed to redacted dated November 28th, right. 2007, raising issues that he had not raised with you. The appeal subsequently that I was asking about was, right, an appeal for a de novo review. A de novo review of the whole case. Understood. And the reason that I read this, is not, on the one hand, I'm saying we do not fear review, but this is not an invitation to defense counsel to do a de novo. I am not inviting them. I'm not saying, let's have more review. I'm saying enough's enough. If they appeal, that's fine, but this is not an invitation to appeal. But there was nothing you could do to stop their appeal, right? Except indict? And so the department shouldn't stop an appeal to main justice by threatening, fair enough, because main justice has a right to review. I should have said that this appeal process was stymieing progress in resolving the Epstein case. It was. And you had no recourse other than, at least theoretically, you could have just said, we're, right, going to tear it up and indict because you're in breach, in effect, which would have raised civil litigation, overlays, which is the point that I thought merited, alright, at least flushing out. By misredacted. So, short of the department itself getting a move on, and getting this thing through expeditiously, did you feel like you just had to sit there and wait for everything to get done? I'm not sure sit there and wait, but ultimately the case did not get better with time, and there was frustration on our part about, the witnesses are not getting better. Time, they're getting older. Which goes back to how a juror may see them. Misredacted. Right. The witness. And I do recall conversations of they're getting older. This case is not getting better. We now have the civil overlay that we need to deal with. And so, yes, there was process. But while there was, should we just call it a day? All of that factored into, well, if the department is reviewing, the department is reviewing. By misredacted. Okay. What is your view of whether the criminal division's review encompassed the MPA itself? So, the criminal division, by its terms, did not encompass the MPA. I would say that's different from the deputy's review that encompassed the totality of the circumstances. Okay. Did you have conversations with the DAG, with Mark Philippe about this case? Not to my recollection. Okay. And we've already talked about the submission that Redacted made on behalf of your office, which I thought was a fulsome submission, and included the draft indictment, the MPA. I believe it included the term sheet and other documents. Did you or anyone else to your knowledge ask ODAG to review or assess the MPA, or approve it? Before signature, not to my recollection, but it was part of the ultimate review when Redacted submitted the matter to the deputy. He included the agreement. It was included. Their very brief letter, you remember? The letter that redacted? Yes. Authorized? That he offered? Sorry, offered, not authorized. Offered, that he offered. Addressed really only the issue of the appropriateness of the case for prosecution in your office. It did not in any way reference the disposition, the plea agreement, or the MPA. So it was a brief letter. Based on Redacted's submission, I would have read that letter as they had all the material in front of them, and they were saying that there was no misconduct or abuse of discretion. That's correct, but they did not say that they contacted, that they addressed or assessed, reviewed even. They didn't say they reviewed or approved the MPA. If the letter is here, I don't know, but yeah, I have it right here. It's not marked as an exhibit, but this is Redacted's letter to Jay Lefkowitz and Ken Starr dated, right, June 23rd, 2008. It states that this office, meaning the Office of the Deputy Attorney General, has completed a thorough review of the U.S. Attorney's handling of the matter involving your client, and states that they've received and reviewed submissions from both parties, and then states that the Deputy Attorney General will intervene only in the most unusual of circumstances in a U.S. Attorney's matter, and we do not believe such intervention is warranted here. Even if we were to substitute our judgment for that of the U.S. Attorney, we believe that federal prosecution of this case is appropriate. Moreover, having reviewed your allegations of prosecutorial misconduct, and the facts underlying them, we see nothing in the conduct of the U.S. Attorney's Office that gives us any reason to alter, our opinion. And so if I could point out, this office has completed a thorough review of the U.S. Attorney's handling of the matter. And so, handling is a broad term, and in reference to, we believe that federal prosecution of this case is appropriate. The way I recall reading that is, the federal prosecution of this case, the argument was that the agreement was inappropriate because this case should not have been even prosecuted, and therefore that the federal prosecution of this case was appropriate. And so, the handling of the matter, we reviewed the handling of the matter, not the agreement, but the handling of the matter, and that the ultimate disposition, if, is at least not an abuse of discretion, or is appropriate. And that's how you read it? That is how I read it. And did you ever discuss that? Did you ever discuss with anyone in ODAC what the scope of their review was? Not to my recollection. It was a fulsome submission. Correct. But if the issues presented by the defense were essentially federalism issues, right? So again, this is based on, as much recollection as contemporaneous record. The issues presented by the defense were, in essence, it was the heart of the non-prosecution agreement, which is, was it an abuse of discretion to proceed in this case in the way that we did on the grounds that there should not have been a federal prosecution in the first place, or that we were using federal criminal law to elicit a civil outcome? And so, I don't think it's fair to sort of narrow, you can't say that our handling was, that their handling was reviewed without reviewing the non-prosecution agreement. Do you have any reason to believe that either ODAC or the criminal division that the ODAC, let's stick with that, did in fact review the MPA other than to be aware it existed, whatever its status might have been? So again, it was clearly submitted, it was clearly referenced, and it was clearly part of the complaint. The heart of the complaint about our office was that we were using this agreement to impose civil liability, and so I think it is fair to infer if the complaint implicates the agreement, that the agreement would have been reviewed. But that's your inference. You didn't have any specific communications with ODAC. To that effect, I don't recall a specific communication. Alright, okay. I would like to take a short break. We're getting there. I hear you. There is, all good, one area that my colleague, Redacted, will take on, which has to do with the CVRA. Right. And then we have some kind of wind-up questions. Okay. Mr. Redacted, before we take a break, can I just... Mr. Redacted, yes. Mr. Redacted, I'll try to queue up what's going to be coming next. The witness, Mr. Redacted, and maybe that'll help us move through it, because... The witness, right. Mr. Redacted, you have been through a very long day. The witness, yeah. Mr. Redacted, we appreciate the time you put into this. You've been here for quite a long time. The witness, well, yeah. By Mr. Redacted. The area that I want to discuss after the break has to do with the ultimate notification to the victims about the resolution of the case, the state plea, and the result of the federal investigation. And there's going to be... We have documents that are already marked there that might be helpful if you take a look at a couple of them, so we don't have to go through... Maybe during the break, so we don't have to go through them one by one. Or I can just give you a very quick overview of where we're going. I want to find out basically how you were getting from there. What would be the state asking for the U.S. Attorney's Office to make the notification to the victims about the upcoming state plea that happened in November of 2007. There will be document 32B to the defense, then finding out that the government wants to notify the victims by letter, and then demanding that they see the letter and have some kind of comment on it. There will be document 33, an email from Lekowitz. Then we have an exchange of letters, but the one I'd like you to look at is document 37, which is a letter coming from Redacted to the defense. Not now, but, during the break. So I want to find out how we get from that document, 36, where Redacted is writing, Miss Redacted, 36, by Miss Redacted. As letter saying that, citing the CVRA regulations, saying that the government is obligated to notify the victims about the resolution of the case, and attaching a draft letter to the victims telling him the time and date of the state resolution and plea, inviting them to come. to ultimately a letter from you coming on the 19th of December 2007, which is number 41B, agreeing to not notify the victims of the state plea, and agreeing with the defense to have the state be responsible for putting out that notification. And then we end, ultimately, with a letter or draft letter that we have that goes out to the victims in the case on after the plea in July. Well, we have the draft I'm going to show you, which comes in June, showing that the letter was clearly meant to be sent after the plea as per the agreement, and that is document number 51. Okay, so it was a lot to, unpack there. That's a lot to unpack. We should probably take it a step at a time? Yes, I just wanted to, alright, give you an overview, because I think there's some of what you had mentioned earlier, and I know it's, been a long time, so, I'll try to orient you for the timelines. So, if you just I've highlighted the sections of those letters that we want to talk about, and if you have a chance while we're taking a break to look through them, that may help orient you so that we're not, spinning our wheels on this. I don't want to waste any of your time. Fair. Misredacted. Alright, off the record. Off the record. Misredacted. Alright, back on the record. Mr. Redacted. Are we back on the record? Misredacted, yes. By Mr. Redacted. Okay, great. So I know I gave you a lot to unpack of the short break we just had. One, basically what we're trying to get to find out is how your decision-making process regarding the victim notification issue. So maybe if you could just give us anything with your December 19th decision, could you give us an explanation about how you got there? So I think we should probably take this in stages, okay? As a general matter, I recall that there was back and forth after the agreement regarding how to notify the victims, and there was back and forth between Redacted and Jay Lefkowitz and Redacted around all that. Sorry, I'm losing my voice. So am I, but that's okay. And I recall that there was an issue in particular that was raised that I tried to address in the letter, and I recall at the end of the day, it was my impression that once there was an agreement for him to plead, that there was an attempt by Redacted to provide notice to the victims, but it was I think I was on a Friday, and he was pleading on a Monday morning or something along those lines. And finally, I recall that the view of the office was that the CVRA did not apply, and so that this was a discretionary balancing that included consideration of what impact notification of the 22.55s would have at trial, the 22.55 provision, if we had to go to trial. Easy, good girl, Clara. So we can unpack that, but those are my general recollections. Okay. And look, let me add, I think it's important. So I came in and out of the case at stages, and I was involved in certain aspects more than others, and while we had a long discussion about the term sheet and matters like that, while I was clearly involved in at least one dispute around the 22.55, the nuts and bolts of how victims were notified is not something that I have a recollection about. Okay, fair. But we can unpack it. Okay, let's start with the Exhibit 33. So there, we have as you can see, it's an email from Lefkowitz. To you, and to Redacted, objecting to a letter being sent to the victims unless the defense gets to review it. And later on in some of your other correspondence, you discussed that you extended to the defense the courtesy of allowing them to review these letters. Is this the genesis of that courtesy? I don't have a recollection as to what the genesis might be. I know that there was back and forth between our office and the defense about that letter. Okay, but as you can see on 33 that you're not in the response from Redacted, but Redacted instructs Redacted to send the proposed letter to Lefkowitz, and I assume that Redacted wouldn't have done that had you objected to it. Again, I don't recall any specific conversation. As a general matter, this is not something I was getting into the weeds on unless I had to. There was a lot of back and forth. Redacted is someone that I trusted. He was handling this matter. He's incredibly experienced. I know that there were concerns and issues around the impact that notification would have on the witnesses. I know there were issues around the language, and I trusted that folks were working these out. One of the criticisms that's come post, the CVRA, litigation, there's been the government allowing the defense to have review of those letters, or potential victim notification letters coming out of the government, and that's unusual. Have you had any other cases where you've let the defense review such documents? I've had no other cases where I'm even aware of victims being notified, because I assume it all operates without it rising to management level. And so this is the first and only time that how individuals are notified, to my recollection, was even in the executive suite. Isn't that usually done, accomplished by almost a computerized task? I would assume so yes. And given that that's the usual way that notifications are made by a victim witness specialist, who is usually that person? Yes. Do I have that right? And so the FBI has their victim witness specialist? Yes. And your office, the U.S. Attorney's Office, has dedicated people to do that job as well? Correct. So why, in this case, not direct, this notification to that person to be done in the usual course, why elevate to something that the defense is going to be able to review? So I can't address the second half of that, but the first half of that question, why? Why was it elevated? I think Redacted addressed some of that in her, was it 2017 affidavit? And so we had an agreement that had been signed, and we also had substantial questions as to whether ultimately Jeffrey Epstein would plead in court or not. And so one of the questions is, how do you deal with notification of a possibility where that possibility could be used to impeach potential future witnesses who are also the victims? And that is a matter that was being worked out by the authors in the office. And the impeachment is what? And so the impeachment, and I believe Redacted went into it in some detail, is you, Miss Victim, stand to gain quite a bit of money if there's a conviction, correct? When you're aware of this agreement, hey, guys, calm down. And this isn't based on my recollection. This is based on the Redacted affidavit, where she says that she had concerns that the impeachment go along, somewhere along the lines of, were you aware that if Mr. Epstein is convicted, you stand to receive substantial sums? Yes. Were you influenced by this? And there was some, according to her affidavit, this isn't my independent recollection, this is according to her affidavit, there had already been dispositions of the victims, of at least some of the victims that raised these issues. And so I do think it was a valid concern by the authors how these notifications took place. Okay, but isn't that type of line of cross-examination the same for any case where there's a super wealthy defendant? It may be. The 22.55 may make it a little different because it's automatic. But ultimately, there are the judgments that line attorneys make, and as U.S. Attorney, I think it's appropriate to back up their judgment unless there was some reason for me to believe it was incorrect. Was there any thought ever to just giving the victims notification that there will be a proceeding that will end the federal case, just separating that in maybe a later notification about the 22.55? I can't speak to what thought there was or was not. I can say around this time frame it was far from clear that Epstein would ever go into court, and we were thinking we may have to just go to trial, because these collateral attacks keep going. Okay. Let's get back on track to the question that I asked earlier about allowing the defense the courtesy to look at these letters is, can you just remind us again, what was the reasoning that they're allowed to look at the victim notification letters? I can't speak to that. This is something that Redacted would have handled. I think that, I'm responsible for the office. I'm not shirking. I'm just saying that this was for the most part within their wheelhouse, and not something that I was involved in. I can speculate. Sure. The agreement was notifying them. The letter was notifying them of certain rights in the agreement, and therefore this is a time where we weren't sure what was happening with the agreement. And so perhaps this is a way to address some of the concerns around the 22.55. I don't know. I'm just speculating. Okay, let's move on to Exhibit 36. This is a letter that goes out to Lefkowitz under Redacted signature. You are CC'd on the letter. Alright. And what he is doing is sending a draft victim notification letter, which is attached as the attachment there, dated December 6, 2007. And I wanted to get your impressions of... If you go to page 3 of the letter, please. And the first little paragraph there, when it refers to the Victims' Rights and Restitution Act, and then ultimate for the CVRA. If you could just read that paragraph to yourself, please. Are you referring to paragraph 10? I'm sorry, I'm on the letter, not... I'm sorry, I'm on the... Oh, left. The letter to... Sorry, Lefkowitz, not the draft letter. This one right here. The additionally? Yes, additionally. Pursuant to the Victims' Right and Restitution Act of 1990, our office is obliged, our office is obligated, etc. Okay. Do you agree with that language? That interpretation of the victim's rights as far as the notification? So let's sort of take this one sentence at a time. With respect to notification or other information that we were supposed to disclose, the statute requires that we provide victims with the earliest possible notice of... I would assume that is a restatement of the statute. I don't have it in front of me, but let's assume that that's a restatement of the statute. Just as in 18, these sections are not limited to the victims. Through this federal... should be appropriately informed that a non-pros does not require to forgo his legal obligation. On a sentence-by-sentence basis, I mean, do I agree, sitting here? Sure. But I would want to sort of sit down before I gave a legal opinion and spend more time with it, but... Okay, because coming out of your office, sort of this and that... Well, let's go to the next page, page 4. Yeah. There was a citation to the right to confer in the first paragraph there, citing the CVRA's reasonable right to confer with the attorneys of the government in this case. Okay, so we have, it looks like to me, right. Well, it appears that there is 2 references to the CVRA obligations that the government has, that ultimately the government argues that it did not have. Can you explain why that is a correct interpretation? So, what I can say is, so it looks like at least some of the victims were notified. I recall a discussion and a view that the CVRA did not require it. It was discretionary. Because it wasn't, the case is not indicted. Indicted, so it did not attach on its terms. That doesn't mean that it's not something you aspire to. That just means it wasn't legally binding. So, and in the same manner though, while the CVRA isn't legally binding, it also doesn't prevent you from notifying the victims, does it? It does not, no. And you have the discretion to notify should you choose to. Correct. Okay. And so, if you look at the letter that's attached to this is a draft that goes out, we're on page 1, 2, and page 3 of the letter. And the second to last paragraph, the letter is giving notice of Mr. Epstein's change of plea and sentencing that will occur on, at this time it was December 14th of 2007, and it gives the address, and it says underneath, there, you are entitled to be present and make a statement under oath. If you choose, you can submit a written statement under oath, etc., etc. So this is a letter that's actively inviting victims to come to the state. Would you agree that that's inviting victims to come to the state plea? I think that's fair. And with the letter's reasoning that the government is would like to send this letter because it believes it's obligated to, because it resolves the federal case. So I don't want to speak to the reasoning, but it's clearly a draft that the government is saying it intends to send. Okay, now ultimately, this is not a question, just got it. Some information that will help to move us along. Right, obviously this letter is never sent. Misredacted drafts, we have them, and I'm not going to show them to you, 30 letters, copies of the letter. Right, to different victims, addresses them, puts them in envelopes, and is then told not to send the letters. Alright, well the plea is scheduled for December 14th, so yeah. Yes, but one of the issues that's still percolating until the end of December is who is going to make this notification, because as you can expect, the defense pushes back on this letter. And so now we go to the number 39, please. And this is... oh no, wrong voice. And so now we go to the number 39, please. And this is a December 11th, 2007 letter from Ken Starr to you. And if you look on page 2 at the front, at the top of the page there, this letter is complaining about an oral notification that Misredacted gave to one of the victim's attorneys that a letter would be coming. And so Mr. Starr is writing you to complain about it, and he mentions it, later in that paragraph, that we have thought that the notification process had been in abeyance until completion of our ongoing discussions with respect to that process. So were you having discussions with Mr. Starr about the process at this time? I don't recall discussions. I think there was at least correspondence, or... I'm sorry, where are you? I was reading the letter. I'm sorry, where are you? What paragraph? Let's take a look. And it's been a long day. Let's slow down here. We're on the second page of the Starr letter. Right. Oh no, yes. And it would be this and that, the language in there, in the second sentence which goes towards the bottom. This notification, but quite apart from our substantive concerns, which we have thought the notification process had been in abeyance until the completion. That appears not to be so. This is respectfully... So, where does it imply that I was having... I don't recall communications with Mr. Starr. That's why I'm curious where... At least verbal communications. I'm curious where you're reading that from. I thought he's saying we had thought that the notification process had been held in abeyance until completion of our ongoing discussions. Are you saying that he's... So, I don't know where that may have come from, but I don't recall. I recall at one point, I think I sent a letter saying we'll hold off for a week. I don't recall the date of that letter, while you review some matters. Where the abeyance comes from, I can't speak to. Okay, let's go to Exhibit 41B. This is your December 19th letter, and what I'd like to draw your attention to is page 2, the second to last paragraph there. Yes. So, could you tell us how your decision-making around this paragraph? How you got to this decision? So you're asking me to recreate. At some point, the issue clearly moved from redacted interacting with defense counsel to my desk, and my recollection 12 years after the fact is... So, you're saying we shouldn't notify them about the state proceeding, and sure, the state. This was negotiated between Epstein and the state attorney.
We did not direct the state proceeding, so whatever state process is appropriate for the state process will be given. But with respect to the federal resolution, we intend to provide victims with notice of the federal resolution as required by law, and your question is if we thought it was discretionary. I recall believing it was discretionary, but you could also... It doesn't hurt to in a letter say we're kind of required to do this, and I think it was the right thing to provide them notice of the federal resolution. Yeah, and once that resolution was reached, and part of the key word is what the resolution is, my understanding is that Redacted made efforts to notify victims of that resolution and let them know that there will be a hearing the following Monday that they should attend because it would bring an end to the case. Well, let's just back up real quick. As far as the state attorney notifying people of victims of the state resolution, did you have any concerns with that particular part of it? So, difficult to recreate the thought process 12 years later, but ultimately you've got federal, and you've got state, and the state attorney will do what the state attorney thinks is appropriate. It's not for me to direct the state attorney. I'm inferring, based on this language, it's not for me to direct the state attorney, or for our office to direct the state attorney's office on its obligations with respect to the state outcome. Okay, I'm just asking because, the whole case came to your office because of some issues with the state attorney's resolution of the case. So now it's going back, and they're going to be in charge of the notification. Did that raise any flags with you, or did you have any concern about whether it would be done correctly, or done at all? So again, this has come up in different contexts, and I think there was obviously a concern about how it was being charged, but that doesn't mean that they will not fulfill whatever obligations they have. Let's not assume that the state attorney's office is full of bad actors. Okay. By Redacted. But even if not assuming that they're full of bad actors, it's going to be difficult for them to notify the victims, wasn't it? That they didn't even necessarily know the same list as the federal victims because you had found more victims. So we could certainly have shared that list with them. I mean, there are ways that this could have happened. I don't know what the communication were, but as a conceptual matter, having the state notify them of the state hearing and having the federal government say, and this is the federal resolution, is consistent with the law. But since whose voice is it? Ah, yes, it is her. But since the federal resolution is tied to the state plea, why not just combine the two of them in the notification? Here's the federal resolution. We're tying it to the state plea, and here's the date of the state plea. I can't speak to the why not. I can speak to my belief that this would be consistent with law. That could also be one approach. I can't speak to why A versus B. Did somebody instruct you or did you have a conversation consulting with somebody about whether this was the better approach? I would have said, based on practice, not recollection, but based on practice, I would have sat down with Redacted most likely, since he was handling this matter, and we would have talked about it. I would not have sent this without running it by at least Redacted, if not other individuals in the office. I don't know if based on your record there's emails with drafts, but... every document that I'm aware of was sort of shared within the management team, and this would have been one of those. With respect to that one specific decision about this, should be at the discretion of the state attorney, did you consult with anybody in DC about that issue? I don't recall consulting with someone in DC about this issue. I recall a general perspective that the CVRA as a technical matter did not attach because ultimately this was not an indictment. By Mr. Redacted. Oh, before we leave this letter, if I could, and I understand your questions, but I feel some obligation to raise the tension between did you consult in DC versus should you allow DC review. And so just, we certainly were allowing review, but US attorneys' offices don't consult in every matter, especially offices that have the kind of experience... Mr. Redacted. The witness. That Miami does. Mr. Redacted. Back to me. Mr. Redacted. Mr. Redacted. Mr. Redacted. Back to you. By Mr. Redacted. Before we finish with this letter from the 19th, can we look at page 3, please? If you could read the first paragraph on page 3 to yourself, please. Okay. Could you, in that section, you mentioned that prosecutors had asked you to declare a breach, and you resisted. Can you discuss this? So, sure, that's referencing, I think, increasing frustrations by the prosecutors, and I think that's reflected in contemporaneous emails saying, why don't we just rip this up? And I recall conversations with Redacted, and that goes a little bit to what we talked about earlier, which is concern that a unilateral breach would overlay not just the initial issues that we had, and not just the fact that the victims are getting older, and the case isn't getting better. But then we have
Was the unilateral breach a valid breach, or was it not a valid breach? And is the delay justified or not justified? And ultimately, that additional liability, not liability, that additional legal uncertainty would have made the case even harder because they were very careful to always say there is no breach. Misredacted. The witness. Let me address, because I went on to read the next paragraph as well, and so let me circle back to an earlier issue. Misredacted. Great. The witness. Because I at least want to address it, because the next paragraph then says, and it's clear that I'm increasingly frustrated. It's against that my frustration with it appears to be an 11th hour appeal weeks before the now scheduled July 4th plea date. That said, the issues raised are important and must be fully vetted, irrespective of timeline's concerns. We hope to preserve the July 4th date. I understand defense counsel shares our... With this in mind, and in the event the defense counsel may wish to seek review of our determination in Washington, I spoke this past Monday with Attorney Gen Redacted, confirming if it's possible, appearing to ask her to grant the potential request for review, and to in fact review this case in an expedited manner in an attempt to preserve the July 4th date. Mr. Redacted, July 4th. Mr. Redacted, that address, January. The witness, I'm sorry, the January 4th plea date. Sorry, it's by Mr. Redacted. And that addresses the question I was asking. And that goes to the question you're asking, and again, I'm recreating and I'm speculating. Having that following the another 11th hour appeal here, I would say I wouldn't say let's appeal this again. I think I'm saying pretty clearly it's against my frustration with what appears to be an 11th hour appeal weeks before the now scheduled January 4th plea date that this is not an invitation to do another appeal, because the appeal is already in Washington. But my saying, if we're going to do this appeal, let's get it over and done with, then I'm sort of speculating based on the language, so that we can get this pled on January 4th, and let's not put it off until after the holidays. But you did say to ask her to grant the potential request, which is for review, which is why I wanted to, on my own, raise it, because is that saying please appeal me, or is that saying this is an 11th hour appeal that you have now taken to Washington? It is December 19th, we're about to go into the holidays. There's a January 4th plea date. There should not be another way to put it off. And so, if you're going to do this, I'm going to try to expedite it so we can get this done. I'm just going to look at the chat real quickly. Okay, I'm both here and going to the hardware store. Excellent. I'm glad you can listen. Finally caught another stream and I'm curious, are you reading an active of the files or the .gov version? I'm asking because the version on government websites started getting purged as soon as the war in Iran started. I downloaded all these files from the government website as soon as it appeared. So, last-minute redactions have not appeared so far. That said, I think Dataset 7 is the last one I've actually downloaded, so I'll have to download the rest. But what I've read up to this point is as unredacted as it's going to get. So I hope that helps, and yeah. As I say, I do understand the redactions for certain victim information. That absolutely has to be redacted, but, certain protected names, yeah, I'm a bit leery about that. Certainly, I think after Dataset 7, because I haven't got 8, 9, 10, 11, 12, I'm going to have to download those. But those are huge files, so yeah, my PC couldn't take it. But no, this initial early stuff, that is fully the most unredacted version I can get. I grabbed it immediately because I just knew they were going to try and wind it back. Okay, continue on. And in fact, it took until May, 15th. And it did, and apologies, I just realised my voice is, alright, rising. So I don't know if that's my frustration at reading this again or it's getting late, but it was a frustrating matter. Apologies. By Ms. Redacted. Let's just move to Exhibit 46. So this is an email from Ms. Redacted to you and Redacted discussing how she has interviewed some victims that day. There's a mention that one of the victims said that she would rather not get any money, and she would rather have Epstein spend a significant time in jail. Did that piece of information go into your character list at all about how the case should be resolved? So again, not based on recollection, because this is maybe, if not 12, 11 years ago. Okay. But at this point, there had been an agreement. The agreement was signed. It was being reviewed. Based on this email, we're trying to get and expedite the criminal division, because I see it says, please reach to Redacted to make her decision. And I think at this point, as I said, if we knew earlier, if we knew that it was going to go this long and take all of this, I think we may have approached the case differently. But we were so far along in this, there was a signed agreement. The United States can't unwind an agreement just because it's frustrated, or just because some victim indicates that they don't like it. That's not, if the agreement is not legally valid, if there are some other concerns, but I don't think this in and of itself would have been grounds for unwinding an agreement. Do you think it's misleading for the government to have been interviewing those witnesses and preparing them for a trial when there's already a signed MPA that resolves the issue? So that was part of the judgment, that there's a signed agreement, but based on the course of conduct, is that agreement really an agreement that will be honoured? And so there was an ongoing investigation as well, because we didn't know if we go to trial. And my recollection is that the judgment was until we know that this agreement is really going to be performed fully, that to inform victims of the possibility of civil recovery is problematic, and I can't say that judgment's incorrect. That I think that's a valid judgment. Fair enough. And then the last question on this email is at the bottom. Ms. Redacted invites you to attend interviews with 4 of the girls who will be coming in the following day. Did you attend? I did not. And as U.S. Attorney, I don't think I attended. That wasn't typical for our office. Had you ever had that type of request come from a line assistant? Not my recollection, but I also tended not to have communications come from line assistants in the first place. Were you at all curious, you discussed the issues with the witnesses in this case, right? That potential impeachment and that went into the negotiation phase. Did you have any interest in seeing these people, even interacting with them personally, so you could make your own assessment? So, any interest is, would there be value in doing that? So, we had very experienced prosecutors. It's not just interacting with the victims were in a really hard position. It's not, how would I draw a distinction between a victim being interviewed by an agent and how a victim holds up in court, in a public setting under cross-examination, and in that? I don't think anyone in the office was questioning the pain or the suffering of the victims. I think that the issues were, how will they hold up in court, which are uniquely trial issues? Okay, then let's move on to, what was your understanding that the federal government was going to do as far as the notification about the resolution of the case? So my understanding was that once we believed that the case was going to be, that the plea was going to go forward, that we would notify the victims of the resolution and of the agreement and how it played out. Now, are you saying now you had agreed to not notify? Well, did you? I mean, one would read your December 12th, 19th letter as an agreement that the federal government is not going to notify the victims of the state plea. And that will end that part of the case. Is that correct? So I would pass my letter differently, and this is 12 years after the fact. So this isn't based on recollection, but on my reading and my understanding of the course of conduct in this case, sitting here now, my understanding was that our office was notified. Was it on a Friday afternoon? Yes. That he would be pleading on Monday, and that at that time, Redacted made efforts to notify victims that he would be pleading, and that would terminate the federal resolution of this matter, and that the victims should attend that hearing, which wasn't the state resolution of the case. It was the federal resolution. And so you're saying that the state plea was also the federal resolution of the case? Based on my understanding of what happened, that's how my recollection... Based on having reviewed the record, that's how I believed it proceeded. Although I think Redacted attempted to do so, couldn't reach some attorneys, and exercised best efforts to let them know, but did not get a hold of all of the victims. Over the weekend. Before we get too deep into that, let's just take a quick look at Exhibit 51. So this is an email forwarded to you from Redacted from January, June 25th, 2008. So that is 5 days prior to the plea in this case. Yes. Or the state court plea. And the attachment there, you'll notice, is a letter with a notification of identified victims, and the letter is written, would you disagree? That is written with, on June 30th, Epstein pled guilty. Do you see that? Yes. So, the inference, it appears to be that this letter was to be sent after the plea. I see that. I also, based on my review of the record, where I think I'm recalling the redacted affidavit, where she said that she made an attempt to notify the victims as soon as she was made aware that he would be pleading in state court. Well, what redacted says in affidavit, correct, I believe is that she made notification, and the police department, Chief Redacted's police department, made notifications. Is that correct? Does that ring a bell? Mr. Todd, do you have a copy of the affidavit, so we can just look at it? Mr. Redacted, do you have Redacted's affidavit email? Mr. Redacted, it's right here, one copy. The witness, I'll hand it back. Mr. Redacted, almost done. The witness. So, relevant to this paragraph, 34, and then another paragraph, these and other attacks and efforts to avoid the MPA's terms led the FBI investigative team, the office, and me to conclude that prosecution at trial remained a possibility, and we should prepare as such. This meant that the victim notification letters had to cease because 1. We no longer knew whether Epstein would perform under the MPA, and hence we did not know whether providing information about the MPA would be accurate, until we believed that Epstein, through his counsel, would attempt to use victim notification concerning the MPA to suggest that victims have been encouraged by the FBI or the office to overstate the victimization for monetary compensation. And then fast-forwarding, because you can read it on your own. On Friday, June 27th, at approximately 4:15, I received a copy of Epstein's proposed state plea agreement, and learned that Epstein's state court change of plea was scheduled for 8:30 a.m. on Monday. The Palm Beach Police Department and I attempted to notify the victims about the hearing in the short time available to us. I specifically called to Attorney Edwards to provide notice to his clients regarding the hearing. I believe it was during this I never told that the state charges involved other victims, and neither the state court charging instrument nor the factual pro-offer limited the procurement of prostitution charges to a specific cell. So that was what I was referring to. Again, I am basing this based on my review of the affidavit, and not on recollection of how this may or may not have been proceeded, or may not have proceeded 12 years ago.
Okay. Would it surprise you to learn that Ms. Redacted only communicated with Mr. Edwards that day? That's because she was under the direction from a manager to only contact Edwards regarding this, the potential plea for that Monday.
Hello, Dexter. The affidavit said she attempted to notify the victims, so I can't speak to that.
Okay.
And I don't have an independent recollection of this going back 12 years.
Were you aware that Ms. Redacted was directed to have no communication with the state attorney's office, and probably during that latter period of the case in 2008?
Not to my recollection.
Okay. So would you not recall hearing anyone directing her to not communicate with the state attorney's office?
I can't speak 12 years later, what role I may or may not have had. I question how, if there is an attempt to schedule a plea and all of that, how can there not be communication? But I can't say whether I did or did not. When I say I have no recollection, I mean that in the broadest sense of the word.
Okay. In your December 19th letter, you did agree that the state attorney's office would notify the state's victims, right?
Yes.
And do you have any idea how that was to be accomplished?
I can't speak to that, no.
And would you have any knowledge of who the state victims are? I would infer that our office would have had sufficient communication with the state attorney's office to communicate who the victims were in this case, because it was an ongoing matter, but I don't know.
Do you want to go on?
Ms. Redacted. Okay. Are you done with that portion at least for the moment? Ms. Redacted. Yes, thank you. By Ms. Redacted. I just want to clarify something you said a moment.
Sure.
Ago, Mr. Acosta. You said you referred to the agreement, the MPA, as having been... It was signed and was being reviewed. Were you talking about Washington? Right. The criminal division. But we established earlier, did we not, that the MPA was not the subject of the criminal division review. They expressly declined to review it. I stand corrected. Okay. I just wanted to be clear on the record. Thank you. So we've had a lot of conversation about facts. We are fortunate in this case to have a plethora of documents upon which we can rely even 12 years or so after the fact, and we've tried to plumb the depths of your memory as to the events. Are there any facts, any conversations, any incidents, anything based on the questions that you've heard here today that you have recalled, that you want to tell us about, want us to know? So give me a minute to just sort of think this through. Of course. I think we've covered most of the issues pretty clearly. I guess I would have two general comments. The first is whether folks agree or disagree with the initial 2 years, registration and restitution. The office's focus was on having Mr. Epstein go to jail at a time when, from our perspective, these cases were, at least presented with these facts, federally at least unusual, and that most trafficking cases involve a different sort of nexus. It involved bringing individuals into the country, or holding individuals against their will, or doing something like that, and this will go to my second point, which is, sitting here, we now see several high-profile individuals who abuse power and have now been prosecuted, who were known at the time who abused drugs, like Bill Cosby, and there were rumors at the time, and so looking back, maybe it was the right call. Maybe it wasn't the right call, but there is some degree of, I'm not sure what the right objective is, frustration, that, and certainly some of this goes to me, but I think a lot of this goes to Redacted and the individuals involved, that the attempt to put someone in jail, as opposed to decline the case and say this is just a state case, that the federal issues are too tricky, that ultimately this is sort of novel interpretations, that the attempt to come up with an outcome has rebounded in the way that it has, and I'm not saying, look, that's life, but I understand that. So I'm stuttering a bit. But I do think it's important to look back on this and try to be in the shoes of the thought process in 2006 and 2007, when trafficking prosecutions were fairly new, when, more so than today, some jurors may have looked at this as prostitution and were, perhaps more so than today,
Judges' tolerance for victim shaming may have both caused more hesitation on the part of victims, but also created more issues at trial. And so I think we touched on that, but I think as we sort of wrap up, this portion of it is important to just restate that. And to, in addition, are there any facts conversations or anything that you did ask this, that we've not really elicited from you that you want us to know? And to be clear, you'll have an opportunity to, supplement this. Not that I can think of. All right, sitting here. All right. How do you respond to public criticism that the defense attorneys, the Epstein defense team, were gaining extraordinary access to an influence on prosecutors from the line level all the way up through the department? So I will point out early on in the case, when I said early, you pushed back, but from my perspective, early on in the case, not when it was first investigated, but when it first bubbled up for decision. And that would be mid-2007. June-ish, May to June 2007, May, June, July. We determined here's what we need for resolution, and I think I addressed some of this in the Daily Beast letter. Because we were receiving criticism back then, and I think that letter has been misconstrued to some extent, because it was not, here are some influential people, we're backing off. It was, we early on set 3 criteria. 2 years, registration, restitution. Despite all these attorneys, despite all of these appeals, despite all these efforts, the office did not budge with the caveat of the 24 to 18 months, which we've discussed, and from my perspective, despite all of that, I backed the office in sticking by that resolution in the various appeals to Washington. And so ultimately, it was a year-long process, but we ended up a year later exactly where we started, with the caveat of the 24 to 18. And so, to the extent that there was influence, there was no change in position. Well, my question was access. That this team of defense attorneys, had extraordinary access. They asked for meetings. They, pressed for, with communications, and they had that access. Did that seem extraordinary to you? So they asked for a meeting with me before the agreement was signed. I granted that. That's not the first and only time that I granted a meeting to defense attorneys. I don't think it's atypical, particularly as a case is coming to resolution, for a U.S. attorney to sit down and meet with opposing counsel. And I can think of several cases where that happened. There was certainly a lot of access in Washington. I would speak to, I think that's a question to direct to this building. Because the process here was lengthy and frustrating. But I think we successfully held firm in our positions, despite all the process in this building. And again, my focus is not on your response, but on the access. And, based on the prominence and the prominence of the defense attorneys, if these had been local attorneys, your sort of average criminal defense attorney from, name where they hang out in, Miami, coming to you and pressing for this, you, writ large, the department, do you believe they would have had the same or a comparable level of access? So, I don't know the answer, I'm asking. Yeah. So I guess I respond this way. If an attorney, after meeting with my management staff, asked for a meeting with me, I believe I did and would have granted it, and I can think of several matters on which those types of meetings were granted, and so that was not unusual. Alright. With respect to the back and forth after the agreement was signed, this was an unusual agreement. And to some extent, as a result, the back and forth quickly elevated, particularly because matters would elevate, in particular, when they were being addressed at main justice. That would be one natural way for matters to elevate within the office. And so, the fact that they were being addressed and reviewed, and letters were coming here, would naturally elevate the way the matter was being treated, was treated in Miami. In particular, Jay Lefkowitz had ready access to. Of course, he was involved in the negotiations with Redacted directly in creating the MPA, but after that it appears from the record that he was often contacting you and running or going above the people who worked for you, and on numerous occasions you, again my characterization, reprimanded him or instructed him not to do that and to direct his communications to the line attorney or her supervisors. Is that a fair characterization? Yes, I think on several occasions I said direct them, and again, that was after the agreement was signed, but yes. But there were many issues still pending, correct? Yes. Okay. And that was his ability to reach out to you as a function of your personal association. Is that fair? So I don't think that's a fair characterization. I think you could also say that it was the ability of a function of his insistence in not doing what we asked, and the fact that in a typical course, a Miami attorney would not have done this because they would have had to interact with the office on an ongoing basis. And so the repeat litigator believes very differently than the one-time raised earth litigator. Raised, R-A-Z-E-D? Correct. Is it reasonable for us to understand that you have followed the media coverage of what happened in the Epstein case over the years? Yes. In your view overall, and in whatever specific respect you wish to address, has it been accurate or not so? I think it has been inaccurate in several ways, and we can go through them, but if you could just tick those off. So I think it's inaccurate in that it has been characterized as our approving a state plea, and the complexity of this case was a state plea, and we were deferring to in favor of a state prosecution has been lost, and it's something that I have attempted to correct, but it's very difficult to sort of explain that in the media. You know, this is a bad analogy, and so I haven't used it in the media, but I thought about it, and so I'll share it. So after the Jesse Smollett plea in Chicago, there was some discussion of whether the federal government should bring charges, and I remember the media saying that, and I haven't used this analogy because I don't want to compare, and I think it would be disrespectful to compare the facts of that case to what happened to these victims. And I don't want the comparison to be drawn, but there is a legal comparison, right? The US attorney in Chicago could have stepped in and said, whether or not the state takes this plea, we may investigate this federally and sort of stop that plea from going forward, or at least put a wrench in those gears. Or the US attorney could have pursued that under petite policy and did not. And so our stepping into this sort of reminded me of how many times cases that are viewed as a manifest injustice do occur, and yet the federal government does not step in. And the fact that we stepped in has been construed as this became a federal prosecution and sort of going to, is it redacted or redacted? Redacted. Redacted sort of question earlier, the distinction between it was not a manifest injustice versus this was the right outcome is something that I think has been lost in the coverage of this matter. I think a second issue that has been lost in the coverage of this matter is there are references to Prince Andrew and Alex Dershowitz and Governor Richardson and Bill Clinton, and things happening in London and the so-called Lolita Express, where things may have happened on airplanes. And so this is viewed from the public as this international matter, where the victims were local, the actions, to my recollection, was local. And so the distinction between this Palm Beach incident and what the media likes to cover, which is, did Mr. Epstein force a minor to have sexual relations with Prince Andrew, is a very different fact pattern, both in terms of the public perception of forcing a minor to have sex with a third party, that they have, that is outside the solicitation context. It's sort of, I'm travelling with these women and forcing them to have sex, versus a more local matter that, I don't want to say solicitation because I think we've covered that, but that some may view as that. And I think those are two major elements, right, that are being lost in the coverage. The case has been criticised as having involved improper influences or favours, or payments that affected decisions that were made within your office, and you're aware of all those, allegations as well. In connection with this case, were you yourself ever offered any payments or any favours or any promises or job assistance or anything like that? No. In connection with this case? No. And to your knowledge, was there any such offer to anyone associated with this case in your office? Not to my knowledge. It's been asserted also that the handling of the case in the office was affected by Epstein's wealth and influence in the Palm Beach community. What's your response to that criticism? Again, my response would be, sometime in May or June, we came up with these 3 points and we stuck to them. And despite all of this, when people make these assertions, somewhere along the way, the fact that we stuck to those points is lost and it's not talked about. And so we did stick to those points, and question whether the case would have come to us in the first place, I think that could also go the other way. I don't understand that. That it's highly unusual for a case to be brought to the US Attorney's Office after the State Attorney not declines, but fails to fully prosecute? Right. And so one question that also doesn't get asked is, to what extent was this case brought to us in the first place because of his profile? In other words, are you suggesting that his wealth and influence in the community affected the state authorities? I'm not suggesting that. What I'm suggesting is the case came in, the case proceeded, and someone can make the argument that the only reason that Chief Redacted brought it to us was because it had such a high profile. Are there other matters that take place in Palm Beach that a state attorney declines in the first place that isn't brought to the state attorney because it doesn't rise to that? You mean to the US attorney? To the US attorney because it doesn't rise to that profile. All right. By misredacted. Well, in fairness, he might have done it because of the number of victims too, right? He may have, I don't know. What I'm suggesting is we try to treat it fairly, not looking at, hey, how wealthy is he, but also not saying we need to do this because he is so wealthy. By misredacted. What do you think about the media's treatment of the line assistant, redacted? I wish her name wouldn't be in the media. To some extent, US attorneys, when they take the job, realize that part of their job is to take the slings and arrows. And there are instances where officers were accused of misconduct, and I always sort of felt that was I don't want to say below the belt, but that's not why they take the pay cuts that they take to go into federal service. And I think the media coverage of this case has been unfair, and has lost a lot of the complexities. It's not surprising because, here, we're talking about a lot of those complexities, and it takes a fairly sophisticated discussion, but I think it's particularly unfair on redacted. In your attorney's written response, he used the term relentless to characterize the team of lawyers, the defense lawyers, and in that Daily Beast article that you wrote, you referred to the year-long assault on the prosecution and the prosecutors. You noted that the defense was more aggressive than any of which I or the prosecutors in my office had previously encountered. You noted that the defense investigated prosecutors and tried to disqualify two, and I believe that those two are redacted and redacted. That is correct? All right, yeah. And you also noted or asserted that there were investigations into the family lives of individual prosecutors, accusations of bias and misconduct against individual prosecutors, and even the threat of a book on prosecutorial zeal. Do you still regard that characterization as accurate? I do. Whether I would use those same words now, we can spend a lot of time talking about it, and I'd want, to think about it. But I do think that's accurate. I think this really was a raised earth type of matter. And in the office's typical interactions, the prosecutors know they have to come back to the office. And so they were not... Sorry, not the prosecutors. It's getting late, though. The defense counsel. And so they were not... It's not just the accusations against the attorneys, but the mischaracterization. I could go through the record, and there's several instances where my words or other authors' words are being mischaracterized, or where, going back to one of the redacted emails, people walk out of the meeting believing they have an agreement, and then there's unwound, and that is not... I don't know if that's typical in Washington, but that's certainly not typical in the Miami office. All right. In that Daily Beast article, I think you also used the term peccadillos. Yes. What did you mean by that in particular? Could I see the... I was afraid you'd ask that. I have it right in front of me, and I don't at the moment. But... Mr. Redacted. Are you talking about the To Whom It May Concern letter? Mr. Redacted. Yes. Yes. The witness. Yes. By Mr. Redacted. Yes, thank you. And it's a reference on the second number page of this copy to personal peccadillos in the middle of the page. Also, individual prosecutors and their families looking for personal peccadillos that provide a... So, redacted was, to my recollection, she wasn't investigated. Redacted. Big redactions here. And I haven't encountered that in other cases. I recall it, at one point, they also looked in redacted and redacted's family and his background, and I thought that was a little out of line. Oh boy! Wow! Okay, this is a lot of redactions here. What is going on here? So, the context of the matter, they are talking about the personal details of prosecutors on the prosecution team. So, I guess... From what I can see so far, yes, some criticism can absolutely be levelled on the prosecutors for not pushing as hard as they could, but the actions of the defence, they had Alan Dershowitz, he had very, very high-profile, powerful lawyers on his side. Epstein had so many good lawyers on his side, and a very, very good legal team. And he's confirmed here one of the best, or one of the most effective, or one of the most aggressive. Do you think they cross the line into completely unethical? I think so, because of the way they kept pushing back the plea date, wanting to always change something in the deal, and they speculate potentially so the girls get older and thus it doesn't look as bad to the jury. That's what I'm thinking anyway. All right, big redactions here. QA, big answer here. QA. The A is an I, and this is redacted. Another redaction. Fucking hell, this is a lot of redactions. And this has been noted heavily in red, so this is big info. This has been labelled several times. What's going on here? Okay, so it carries on here from an answer. But the point I was trying to convey is this is not typical behaviour by defence counsel. So they're redacting what the defence counsel did. Which isn't a good sign, I don't think. But the point I was trying to convey is this is not typical behaviour by defence counsel. Did, and despite all this, my point was, despite all this, we did not budge. And again, that's not the focus of this question. More big redactions here, holy shit. So, so this is the context of stuff from the context of what the defense team has done. Yeah, I think. Yeah, I mean the prosecutors. I think they should have shown a bit more backbone, a bit more spine, not cut a deal. I think the court process at the very least would have worked, but yeah, I mean I guess if they're questioning the reliability of the witnesses, they might want to take a gimme, but that's not ethical at all. They shouldn't have done that. They should have absolutely taken it to trial. That's unfortunate. Anyway, carry on. All right. Are there any other examples where defense counsel came to you that you have not otherwise been addressed with? Allegations about someone, I'm hesitating. Else. Just because I'm trying to think through and not to my recollection, no. Did they ever raise or imply that there was information regarding you, of whatever respect, that was in the nature of a sort of a threat or a veiled warning? So the book reference was that I might be personally embarrassed by pursuing this matter, because I would be the subject of a chapter in a book on prosecutorial overreach. And who was going to write that book, do you know? Professor Dershowitz. He was on the defense team. Okay. Did you consider him a professional friend at all? I had not to my recollection met him. I understand in this letter I sort of grouped him in. But I say for the record that it's hard to know what my intent was in 2011, but that's for simplicity of grouping individuals because I did go to Harvard. I may have run into him in Harvard, but he was not my professor, and I didn't work for him as a teaching assistant. I had some interest in criminal law, so I may have chatted with him, but that would have been it. And did you consult with him at all in connection with your efforts? Your interest in potentially teaching or being involved in the law school world, either at Harvard or at Florida International or anywhere else? Not to my recollection. At some point when I applied for the deanship, I wasn't aware of the deanship until... So let's take this in part. I thought about looking at Harvard for a teaching position. To my recollection, I never followed through on that. I knew Elena Kagan, and may have had a conversation with her. That would have been a preliminary. How does this process work? But I don't recall taking it. If I took it that far, and I'm not saying that I did, this was a long time ago. I never sort of went through... The way law schools hire is a very... They call it the meat market. And take that for what it's worth. It's something that happens at the hotels here, at the Marriott here on Connecticut. There's a very formalized process, and I never... went through that. I don't recall any conversation with Professor Dershowitz about that. To the extent I was thinking about it, it'd be natural for me to talk to Redacted, but I don't recall talking to him. With respect to Professor Dershowitz, with respect to FIU, the dean process is very decentralized. To the extent a faculty member spoke to him, I don't know. To my recollection, and again, this is a long time ago, I did not ask him for a reference or a letter or something to that regard, although I may have. It was a long, long time ago. I was also no longer active in this case at the time. All right. And what about with respect to that same process on your part? Ken Starr, who actually was a dean of a law school at the time. Did he provide you with a reference, or not? Hang on, sorry. I'm just putting I'm putting my smart ring on my charger because I forgot to charge it. Not advice? Not to my recollection. All right. As a letter from Ken at the end, there was some... By the time this was over, there was some degree of tension between us on my resolution of this matter. But it also appeared to be tension that both of you were eager to leave aside. I'm a big believer, and I had good relationships with the defense bar. I think lawyers can disagree and not be disagreeable, and we will be a better profession if we all learn to do that. So with the world, yes. There is an sort of investigative journalist author named Redacted. Yes. Do you know that name? Yes. Did you ever speak with her? So she was the recipient of the Do Whom It May Concern letter at the Daily Beast. Oh, really? Yes. All right. Thank you. We didn't know that. Did she comment back to you on it? It was a long time ago. I don't recall. So she wrote a book called Trafficking. Have you read that? She did. About this case? She did. I haven't read it recently, but I read it a while ago. And she says in that book that you told her a few years after the MPA was signed that, as she writes, he felt incapable of going up against those 8 powerful attorneys. He felt his career was at stake. Did you say that to her? Not to my recollection, and what I tried to do was, for the record, provide this letter to her, and the purpose of this letter was to say the exact opposite, which is, and we have this, and she in the New York Times, and I think the New York Times called it, what's the word? Like, apologia? Does anyone know what? Apologia. It's an apology. It's a fancy way of saying, you're explaining yourself. Yeah, I looked it up, and it's a little more derogatory than explaining yourself because I felt a need to look it up. But the New York Times called this letter an apologia. And this was recently. And I say this because when folks read this letter, they read it as, this is why, we had these, I think sometimes they selectively read language, the prosecutors and agents in this case, and what followed was a year-long assault. I use the word assault as it was more aggressive than anything in which I or the prosecutors in my office had previously encountered. Excuse me. Mr. Epstein hired an army of legal superstars. Harvard Professor Dershowitz, former judge and then Pepperdine lodging Ken Starr, former deputy assistant to the president, then Kirkland and Ellis law partner Jay Lefkowitz, and several others, including prosecutors that formerly worked in the U.S. Attorney's Office, the Child Exploitation Section. I'm not sure who that was, of the Department of Defense, and the Department of Defense? No, in the Child Exploitation and Obscenity Section of the Justice Department. Defense attorneys next requested a meeting with me, and they read that as saying there were all these powerful lawyers in this case, but they don't then go on to talk about, despite this army of attorneys, the office held firm to the terms first presented to Mr. Black in the original meeting. So what I understand you saying is that the panoply, this pantheon of attorneys, did not have the influence on you that's alleged? And the purpose of this letter was to say, despite all this, right, we held firm. So how can you say that there's influence if we held firm? I would also note, and I think we talked about this, that those terms were developed before many of these individuals came on board. So it's not like these terms were developed because, now these individuals are on board. All right. And we haven't, of course, talked about the whole work release issue, but yeah, I think that speaks for itself on that. Yeah. By misredacted. So I'm not sure I'm clear. Did you have an interview or have a conversation with Ms. Redacted aside, or just sent her this letter? I spoke to her briefly, saying, I'm not going to speak on the record. I'm not going to address even off-the-record details of this case, but I will provide a letter to you. I've had a lot of requests over the years to talk about this case. There were enough requests coming that I thought it important to provide a statement to defend the actions of the office. I didn't want it to be to one reporter in particular, because I did not want to play favourites, and so I provided a to me whom it may concern letter that was a public letter, but then I gave it to her. Misredacted. All right, go on. By misredacted. And just one thing on the... Oh dear. How do we do that? And just one thing on the work release issue. Did you tell the defense that the U.S. Attorney's Office would not object if he got work release, as long as he was treated like every other defendant? So I don't recall what I may or may not have said specifically around work release. My recollection of our general position is, your pleading in state court to incarceration of 18 is now 18 months, it was 24. Whether it was 18 or 24, this would have been... Any conversation I would have had would have been after the agreement was signed. It's our expectation that he be treated just like everyone else, if it was typical to provide that kind of work release in these cases. That would have been news to me. I certainly would not have expected that, and I think based on our subsequent communications with the State Attorney's Office, that was not what our office envisioned. By the same token, I don't think our office envisioned that he be treated worse than the typical offender. Well, did you know that Redacted was in fact trying to make sure that he didn't get work release? Yes, and so I don't see any reason why I would have contradicted that, is my point. Oh, fuck, Oh, God! Oh, God, I've got a numb bum. Alright, you've mentioned a number of times that the sexual offender registration was one of the 3 important prongs for you in the office. Yes. What was it that you saw the sex offender registration as accomplishing? So, to some extent, it's putting the community on notice that, irrespective of whether he's in Florida or elsewhere, he's a registered sex offender. To some extent, I don't know if this is... but I'll say it anyhow. This was a serious crime, and there was a public sanction associated with this, and I thought to the extent that he committed the types of acts that typically are associated with registration, that should go forward. But the primary motivation there was, put the public on notice that he is a registered sex offender. And did you see any conflict with that as being a goal with the provision in the MPA that the MPA was going to be kept confidential, and the communications in which the U.S. Attorney's Office was having with the defense about continuing to keep things confidential? Do you see any inconsistency between those two? No, in that I generally was of the opinion that this MPA would go public, and certainly his state court plea would be public, and his registration would be public, and so what he did would be known.
And given what you know about these officers back and forth on notifying the victims, do you think, looking at the entire course of conduct of the office, that the victims were treated fairly and with dignity and respect? So I want to be careful, not because I'm fudging, but because it's a complex question. If, looking back in hindsight, we knew that there would be a, 8 months period, when do we have an agreement? Do we not have an agreement? Is this concluded? Is this not concluded? Is this an ongoing investigation? How do we deal with all these notification issues? If we have foreseen all of that, I think I've said before that that's something I certainly think should have been considered, and it's very possible we would have done something very different. But that was not foreseen, and so it's then a very difficult judgment to be made because there is an agreement. There is concern as to, if we have to go to trial, how do you address this? There is, going to the redacted affidavit, at least one instance, and I'm merging my recollection here, and my knowledge after the fact, because your question sort of calls for an after-the-fact assessment. So you've got the redacted affidavit, which points out that defense counsel did all they could, but is using this to impeach and weaken witness credibility in a case where there's already questions around witness credibility. And so it's a very imperfect situation with discretionary judgments to do the best to sort of balance all these factors. Is that the best outcome? Probably not. But that's where we were. And that's why I think this case would have been very differently if, October 24th? He would have gone in and pled and taken his time and served his time like so many other people have done, as opposed to mount all these legal challenges that we then had to work through. And I'll preface my question with the fact that we're still investigating this. We've made no conclusions. With respect to this. But if OPR determines that your office should be criticised for its handling of this, matter, does that criticism fall on you, or does it fall on your senior managers? Because as a non-prosecutor, you are relying on them to keep you informed for their judgment. So I was the US Attorney. I certainly relied on my staff, but ultimately I was the US Attorney, and I don't think it's justifiable or fair to sort of say this was on them. I was sufficiently aware of matters that it was my office, and while I'll say that I might not recall this, or I was relying on A, B, or C for guidance, or to handle this matter, ultimately I think those judgments always sort of bubble up. By misredacted. In your press conference, your reference, this is the, I think, July 10th, 2019 press conference, you reference victims. What they went through was, horrific, you said. And then you said, I have seen these videos. I have seen the interviews. I have seen the interviews on television of these victims and their stories. Just to be clear, are you talking about interviews and television coverage and videos recently? Or back in 2006 and recently? 2007. Okay. I just wanted to be very clear about that. The US Attorney's Manual requires us all in the department to conduct the fair, even-handed administration of the federal criminal laws. What's your view as to how the handling of this case comported with that principle? So, I do think it was fair and even-handed. We, after the fact, may look back and say that 2 years may not have, it shouldn't have been a manifest injustice standard. It should have been, a sort of a de novo. Let's treat this as a new prosecution. That's a judgment you all make, but those judgments were made with an eye toward fairness and impartiality, and once those judgments were made, despite all the attorneys involved, and despite all the litigation, and all the stuff, all the appeals to Washington, and we stuck to that position. And I think that speaks to the way the office approached this matter. Alright, we spoke sort of offline earlier about an issue that was raised in that press conference that was not clearly answered on your part in that context, and the question was, and this is on page 15 of the internet transcript of, that press conference, you were asked whether you were ever made aware that Mr. Epstein was an intelligence asset of some sort. And you in your response, you said you couldn't answer it, couldn't address it directly because of guidelines. Can you clarify, first of all, were you ever made aware of that? If he was, assertion. I'm not aware of it. Alright. Did defense counsel ever say to you that Epstein had that status? Not my recollection. Alright. And to clarify, I also don't know where press reports from multiple sources, not from multiple sources, but from multiple media outlets that I told someone that he was an intelligence asset. I do not know where that came from. If I can just... So there are questions that I may be asked publicly that I don't think it's right for me to comment as to what classified information I may or may not know, because that's not the kind of stuff you go into, but the answer is no and no. Alright. Without reservation, without any no and no. Alright, excellent. Thank you. A couple of final questions. As you can tell, can I, yes, address a second issue that has come up at times? Yes. There are also media reports that this was because of cooperation in some financial
Financial matters. I don't know where that may have come from. All right, thank you. And we are familiar with that, what you're referencing to. What you're referring to, sorry. Was the corporation related to financial matters? We didn't ask you about it. Okay. As you can tell, ODR obtained many electronic records. Yeah. Mainly emails, but other electronic holdings from the department. The Department of Justice, however, has not been able to find or recover a portion of your email account as U.S. Attorney that contained emails received by you between May 26, 2007 and March 2008. Correct. A period of time rather relevant to this. We have obtained many records, of course, from senders and from other people copied. So we may have many of the records, but the fact is, that's a gap in the holdings. And this is despite the fact that, as you no doubt know, the law requires that U.S. Attorney records be maintained and archived. Right, indefinitely. Can you give us any insight, any idea why that might be the case? I can't, and my recollection was after several issues that took place, the department had some sort of records retention software that automatically retained these emails. Is that not accurate? There was a switchover from... Right. A period in which that record retention responsibility resided with each U.S. Attorney's office, and at the switchover, it became centralized. Right. And this appears to have sort of gotten lost being caught in the switchover. My recollection is that there was some automatic retention mechanism. Okay, and I can't address that, although there's certainly a fulsome record. But just to ask the inevitable question, right, did you take any action to discard, destroy, or dispense with any official records? Not related to this matter? Not to my recollection. I think there's a fulsome record, and not to my recollection. Alright, and is there any particular gap that you've discerned in the records that we provided to you? Not that I recall. Do you have the emails that I sent out of curiosity? We do. Okay, so you have the sent but not received. Yes, just checking. And likewise we retrieved from the Federal Records Center, right, records that were boxed up and sent there, hard copy documents, after your term ended. And there is nothing that relates to the Epstein case. There were records that were maintained that were kept in the main office, right, after you left, because it was an ongoing matter, but do you have any idea why there are not any in the records of yours? So, none of were sent? So I have a recollection that when I left, there were some binders that I passed along to Redacted, because it was an ongoing case, and we sort of had binders out that sort of had correspondence back and forth. Alright. And you've already made... I asked you about facts, but you addressed a sort of broader statement to us for the record about the case. Is there anything else you want to tell us at this point? Give me a second to, sort of think this through. In fact, if you'd like to take a quick break and talk to your attorney, and that will be the last question. Do we need a break? Mr. Redacted, no. Miss Redacted, your attorney says God no. The witness, I will follow up on this. Miss Redacted, alright. The witness, nothing that if something comes up, my understanding is that we've received the transcript and have enough time given the length of this to review and comment. By Miss Redacted. Exactly, yes, and for the record, right. When the transcript is prepared, which should be within a couple of weeks, we'll ship that off to your attorney. We'll ask you to review it, to make not only any corrections, but also clarifications, and to add to it. If you feel having read something that it needs to be clarified or expanded upon, you're invited to do so. And if I could ask one other question, I'm not familiar enough with the way OPR operates, and this may be sui generis, so you may not be prepared to answer. If there is a report, as opposed to a letter, which is what I typically am familiar with, will that report be shared in advance for comment? I'm going to... Or is that to be determined? Ms. Redacted. I'm going to defer to Ms. Redacted for that. Ms. Redacted. That's a question that doesn't need to be on the record. Do you have anything else that you'd want to put on the record before we close out? The witness. I do not. Ms. Redacted. All right. Ms. Redacted. All right. Thank you. I want to extend our great appreciation for your willingness. The witness. No problem. Ms. Redacted. To come in and help us with this case. The witness. So let me... Now that we're off the record, let me say... Ms. Redacted. Are we off the record? The reporter. Not yet. The witness. Not yet? Oh. Ms. Redacted. No? The reporter. You didn't say it. Ms. Redacted. All right, that's it. We're off the record. Whereupon, at 8:38 p.m., the interview of R. Alexander Acosta was concluded. Certificate. The United States of America, in the District of Columbia. I, Beth Roots, notary public, before whom the foregoing deposition was taken, do hereby certify that the witness, whose testimony appears in the foregoing pages, was duly sworn by me, that the testimony of said witness was reported by me by electronic record and thereafter reduced to typewritten form. The said deposition is a true record of the testimony given by said witness, and that I am neither counsel for, related to, nor employed by any of the parties to the action in which this deposition was taken, and further that I am not a relative or employee of any attorney or counsel employed by the parties thereto, nor financially or otherwise interested in the outcome of this action. Bear fruits. Notary Public in and for the District of Columbia. My commission expires April 30th, 2020.
Oh, well, that is that for that entire fucking wad of a deposition. Alexander Acosta, that's his name. Or a Alexander Acosta. I don't know. That's his name. But yeah, that's basically what we spent the last 3 streams doing it. Oh, we got a few more things in the chat. Section of the show currently reading was the outrage of how light the sentence was. Yeah. And, you know, we've seen plenty of reasoning why that might be the case. To be fair, it should be pointed out that this guy being interviewed, the witness, they came in voluntarily. And they did this. So I will give him props for that at least. But yeah, he seemed to point out the very interesting thing was the redactions. And it's talking about the things that the defense counsel did that he did not like. And it might be that they were a little bit scared to bring it to trial, but they also, I think they started off, as he says, with sort of a plea, which may have been a bit too low. And I agree. I think he should have served a lot more time in prison. And certainly the victims, they deserved a lot more compensation. Yo, man, reading the files, let me tell you, this stuff is not even the tip of the iceberg. This is just a cherry on top of the horror sundae that is the stuff that hasn't been released yet. Well, if it hasn't been released yet, how do you know that? It could be just like 10 pages of Epstein likes puppies or something like that. How? I've been told there is still a boatload more that will turn your hair white. Who told you this? And turning my hair white? I don't know. Could I turn my hair white? I don't know. I think that would be a pretty good look for me. Respects for voicing this. Absolutely. Thank you very much. And all of this will be sort of compiled into one clip, one video, and that's probably going to be about, I want to say 6, 7, 8 hours. That sort of length of time. It was very, very long. But I'll clip it. I'll release it as its own separate video. And see what we go for. Yeah, I learned of Hawkins having been on the island from net reading the files. Yep, he was. He was in the files. I always knew that guy was wrong from something. He felt very wrong and felt like someone else could use him as a voice. Possibly. I mean, Stephen Hawking isn't necessarily a saint. Bear in mind, he did cheat on his wife. I think he cheated on his wife, married, I think it was one of his nurses. Cheated on his wife, divorced, married the nurse who he cheated on her with, and then I think he remarried his wife or something like that, but, you know. But yeah. But just because somebody is... I want to make this important distinction. Just because somebody is mentioned in the files, all that means, that doesn't necessarily mean they were involved with kids or did any of the horrible shit. All that meant is that they were associated to some degree with Epstein. Epstein knew a lot of famous and powerful people. But just because people knew Epstein doesn't mean they were involved in or trusted with the horrendous shit that was going on there. Okay, I mean, Prince Andrew was in his inner circle, sure. Stephen Hawking possibly knew Epstein. Epstein knew the rich and powerful. I mean, he even collected... I would say he collected association with rich and powerful people in a way. But it doesn't necessarily mean that they were involved in the heinous shit. As much as I do... Not that you should necessarily joke about it. I do make light of Stephen Hawking being on the fucking files because, let's be honest, how is he going to go about doing some horrible shit? And indeed, he's got nurses. He had nurses near him or around him at the time. But that said, I could be wrong. Of course, he could be involved as well. But also, I think David Copperfield was mentioned. But I think he was doing like a private performance for Epstein and a few rich people. Doesn't necessarily mean, as I say, that he was involved with kids. Or he was involved with the victims. Or he had any knowledge. So, got to be careful where to draw the distinction. But based on the evidence provided, some people likely had more association with Epstein and more knowledge of probably what went down than others. I mean, I know a lot of people like to mention Trump.
I mean, I don't know. I'm British. I'm not involved in any political bias in that regard. Bill Clinton, yes. He's caught in so many photos, and including with potential victims as well. But there's also, obviously, we know Prince Andrew. I mean, Prince Andrew is very obvious. Ghislaine Maxwell as well. Ghislaine Maxwell, who I should point out, is in prison and is refusing to name names or cooperate with the authorities. Let me just check. The unreleased stuff may never be released if the court's word is it pertaining to trials will never be released. Well, at the very least, if they do release it, they can wait until I've done this lot first and had a break. So I don't necessarily mind that. I live near a military base, and let's just say you hear things every now and again at the bars off base. A military base isn't necessarily the same as intelligence agencies or law enforcement, but I do see what you mean. A lot of military personnel do go into law enforcement, although it's a civilian field, so there's a lot of different things you need to learn. God, we're getting very active chat. Let me just read the rest of these, and then I'll carry on. There is no option to release material that names and details child-related acts. Well, yeah, I mean, you don't want to know the specific details of the heinous shit. You can use your imagination. Not that I would want to imagine such horrific acts. I just want to know who was responsible and to what degree. And also the victim details. I mean, absolutely, the victims need to be protected at all times. Virginia Giuffre was a very, very courageous woman who came forward with her real identity about what happened, and just, I suspect, with lawyers and all this media attention, I think there came a day where she couldn't cope, and that's when she allegedly took her own life, which is really, really sad, really, because I think when I read her deposition and when I read her testimony for the previous lot of Epstein files in 2024, I very much identified with her cause, and I think it was very spontaneous then and there that I basically said, she mentioned her charity a lot, and I, excuse me, I'm not tearing up, my throat's just dead. And she mentioned her charity a lot, and I basically just said halfway through the files, I'm donating all the money to her charity. That was how much it moved me. And I carry on that promise today. Like, everything from all these streams and all that, and all the clips, that's going to go to her charity as soon as they accept donations. I'm just going to work out the total when that day comes, probably add a little bit extra to it, and just send them a fat donation saying, this is for Virginia. That's the big problem. The fact is the guy knew everybody. It sounds like he was some sort of governmental level fixer. I mean, people are mentioning he might have been a government agent. I mean, it even showed up in this testimony. Mossad, that's a bit of a stretch. American intelligence agencies, absolutely. He's an American. He knows a lot of people. He's an asset that they could lean on. Remember, Epstein helped Bobby Kotick push loot boxes and microtransactions in video games. I mean, I'd like to see the more details and the proof of that. If it is, I could probably do it as a separate clip. Don't get me started on Epstein killing free energy. Okay. Again, give us, point out in the Epstein files all those different details, and I will cover them, and I will keep an eye out for them. Pretty sure David Copperfield was dating Claudia Schiffer back then. I wouldn't know. I've never seen David Copperfield, and magicians. I've seen. I remember a show when I was really, really young. It's like Breaking the Magician's Code, and you had the masked magician. I was a kid back then, and I loved that shit. And I think that ended up being like Val Valentino. She didn't take her own life. She was helped. I mean, the official thing is suicide, and that's Australian authorities. Obviously, there's a lot of doubt behind it. I can believe either way. I can firmly believe that the pressure did get to her, even though she did say I'm not suicidal. I can imagine the pressure would have gotten to her at some point, and just the attention, and it would have been horrible having your name in the light like that. But I can also imagine the opposite as well. If she's able to name more names, for example, if she's able to do that, then sure, she would still be a threat. Although, having said that, I would say, she would have already given all the information to the authorities anyway. Maxwell's father used to work for Mossad. Yeah, Robert Maxwell. He was a crook. He was a UK
British businessman. He might have had some other origins. I think he eventually turned his surname into Maxwell because I think he was an immigrant or something. But he was an absolute crooked businessman. And I think he died before I was born. His boat, the Lady Ghislaine, which he named after his daughter, boating accident, and he drowned and he was declared dead. But turns out, he was fucking around with pensions, he was fucking around with his employees' stocks and stuff. I think, he was an absolute crook. I think his death led to sort of like an Enron kind of situation. And if you're too young to know what Enron is, Google it. You'll find some interesting shit. Anyway, let's go on to the next one.